Tuesday, February 8th, 2022. Because most of us are virtual today, we will, instead of having someone present for our invocation and for our pledge, I will hold a moment of silence and have the pledge follow. For those of you who are willing and able to join me in the moment of silence, I ask that you please do so at this time. Thank you. All right, we'll rise for our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our meeting is officially called to order. As is typical for our second Tuesday meeting, we have an update regarding COVID-19 from Cobb Douglas Public Health. I will turn things over to you, Dr. Memark and Lisa Crossman.
Thank you. Thank you for having us today, and we'll go ahead and give you our update here. Right, so today, so what we're looking at today is a number of 1,167 per 100,000 for the last 2 weeks. And we want to apologize, some updates that we had sent yesterday. The DPH dashboard was acting a little wonky, so we actually got 3 different numbers yesterday, and so they sent out a release that they were having some trouble with the dashboard. So this is a current number that we have today, which is still indicating a decline. When you look over to the right at the epi curve, you can see that we're finally making some progress on a downward progression from this Omicron surge. So definitely some good news, and we're heading in the right direction, and state numbers are also going with this nicely. So good news so far, but remember, still very high. So 1,167 is still 10 times, 11 times over what's considered high transmission. So we are still battling quite a big surge right now in the county. When we're looking at our percent positive, we can see that we're at 17.3% of those PCR tests are coming back positive. So that's also in the right direction. We were at very, very high numbers, over 30% for that. So we're heading in the right direction as well. You can see on the right, that curve also supports that. Okay, and then when we look at hospitalizations off of the CDC website, we also see that we are finally off that peak as well. And so we have been seeing the last 3 weeks in our area hospitals, we have been seeing a decline from our highest numbers. That being said, we still have a lot of patients that are in the hospital right now with COVID-19. And so we're definitely not back down to our lowest levels with that surges, but we are at higher numbers. And so we would like to continue to see that go down. And as the story continues to tell for us, we continue to have the majority of our patients that are in the hospitals to be unvaccinated. Studies that are coming out right now and from the CDC from last week showed even starker differences if you have received your booster shot. So it's very important if you get your booster shot, you get a lot more protection against hospitalization and death. Remember, anybody 12 and over is eligible to get that shot. So it is important, especially if you're more than 6 months out from getting your second dose, or 2 months out from Johnson & Johnson, your immunity is going down a bit. So it's time to get that booster shot. This is a breakthrough report off of the DPH website, and you can see the differences between being fully vaccinated, having that booster shot, and being unvaccinated with breakthrough cases. In Omicron has shown us a little bit of a difference. We are seeing more breakthrough, and that's probably the combination of what I told you about, of having our immunity kind of going down, but also we have a virus that was much more adept at evading our immunity. Here is the breakthrough for deaths, and you can see even a starker difference as well. And so if you were unvaccinated, you have 3.6 times the risk of dying from COVID. And so it's very important, once again, that getting that booster shot and fully vaccinated, how helpful it will be for everyone. Okay, so Omicron has taken over, and so we have seen this now for several weeks now. It is the predominant variant that we're seeing, and I do believe in these numbers, they are adding together the different sub-lineages of Omicron. And so I'm going to talk a little bit about what has been on the horizon and in the news a little bit, which is BA2. That is the second lineage off of Omicron that has come off. So this is a mutation of a mutation. And so this one has 27 mutations from its parent Omicron, which is BA1. It is thought to be at least as transmissible or maybe more transmissible than the original Omicron. Now, the good news is it does not seem to be more severe. We're watching countries right now like Denmark, and it has taken over Omicron, the original Omicron in Denmark, but it has not been causing more hospitalizations. So that is very good news. Right now, it's in 57 countries throughout the world, and it seems to be gaining speed. Now, important though is that we're still seeing some coverage with our vaccines. So once again, if you have your booster shot and your full dose series, you are offered a lot of protection. It's not 100%, but it's doing a long way to keeping you out of the hospital and from dying. So very important, and we keep watching this one. But so far it's not a variant of concern quite yet. So here are our best protections. We know what we need to do is we need to mask up and we need to vaccine up. And so what they're showing is that, to have, make sure you have the best fitting mask that you can. And so just kind of having the chin guards is not going to be very helpful. So being able to have a well-fitted mask. Now, of course, top of the line gold standard is N95 if you can get them. And Lisa will talk a little bit about the free mask program that's been coming out. So, but they are not readily available as of yet. So she'll talk a little bit about that. Okay. Lisa?
Thank you. So good morning, everyone. Let's talk just a little bit about testing. Dr. Memark, next slide. So we continue to offer free testing around the county. It's very easily accessible by all our residents. We've got sites over at KSU, the Epicenter, the East Cobb Health Park, and Jim Miller Park. At some location around the county, we're doing testing 7 days a week. Also, a number of pharmacies and physicians' offices are also continuing to offer testing. We're not seeing any wait times at our mass sites, and our results are generally coming back in 12 to 36 hours. I didn't put all of the locations and hours of operation just because it's you can find that on our website. You can also go to the Georgia DPH website for other testing providers that might be near your zip code. Next slide. The federal rapid home test. So remember, I think we've talked about this before at some other events, that website to order the free federal home kits went live on the 18th of January. It really is extremely easy. I've helped a number of folks. It literally takes about a minute to register to get 4 test kits delivered directly to your home. A lot of people have reported that those test kits are coming in to their home within 2 weeks. Also, beginning mid-January, residents with health insurance could also go online to their health insurer or to a local pharmacy and pick up test kits. In some cases, their plan directly paid the pharmacy. In other cases, they had to get a receipt and turn that into their insurance. But I'd say check with your pharmacist or your health plan for options if you wanted to get your kits that way. And then a lot of people have been calling about the free mask, the federal mask program. Remember that that's been announced and is available, but please know that those masks were sent out to national chains pharmacies that were enrolled in the federal vaccine program. So your chains like Walgreens and CVS and Walmart were the ones who got those masks, and the quantities were really limited. So I'd say check with your those locations first before you go over there. In some cases, they're also putting signs up if they've gotten masks or not. Public Health has not received those yet. We're still waiting. And also some of the community health centers, like the federally qualified health centers like Good Samaritan and Family Health Centers of Georgia, were also in line to get some, but I don't believe we've gotten those yet. Those are coming directly from HRSA. All right, vaccinations. First of all, to remind everyone that anyone 5 years and older is eligible to get their vaccine. Anyone 12 years and older can get their boosters. And the additional doses are still recommended for those who are immunocompromised. Public Health is providing all of those vaccinations that folks need. And as Dr. Memark mentioned, we really want to make sure that people hear that they need to get their booster. We are seeing breakthrough cases with folks who got their first 2 doses, but then it's been several months since their second dose. So we're encouraging that. Next slide. This is just to give you an update of our vaccination status in Cobb County. So in Georgia, we have 62% of our residents have received 1 dose, 55% are fully vaccinated. That's tracking a little bit lower than the US rate, which as of the other day had 80% had received at least 1 dose. So we're tracking a little bit below the US. Cobb County is doing a little bit better than Georgia, but still tracking behind the United States full number. We have 65% of our residents have received 1 dose, and 59% are fully vaccinated. 25% have received that booster shot. Okay. Again, there's no obstacles, I don't believe, for folks to get their vaccinations if they want that. All of our public health clinics are offering those, many times on Saturdays as well. Many local pharmacies are also offering regular vaccination services. Our public health staff, along with our core partner, are providing 5 to 10 community vaccination events outside satellite locations each week. Lyft is still, remember, through June, Lyft is still providing free rides to vaccination sites for folks who need that. And then homebound vaccinations are still available through public health and our partnership with Pools Pharmacy. You can go online to look at which vaccines are provided at what locations and their hours of operation. You can also go to the vaccines.gov site for other providers that might be near your zip code. Next slide. We're also trying to do a lot of other things to help provide support to our residents across the county. So one partnership that's continuing is with the Center for Family Resources and Sur Familia to fund, Public Health has been able to fund some additional resource coordinators that work through those agencies to help families with housing and access to other care and utilities that they may need. And so we're continuing that partnership at least through June, and hope that's helping to link folks to the care that they need. We also have recently gotten about $500,000 from the CDC and through Georgia DPH to fund some health navigators in the community. So one level has been partnering with Morehouse. That contract had to go through a lot of legal review because it was kind of the first contract in Georgia that we've done. And so I'm fingers crossed that within the next day that's going to be signed, but we're still planning on getting those health navigators launched through across the county by early March. And then we also have another health navigator that's been funded to focus on linking residents in South Cobb and in Douglas County with chronic disease services, not just COVID, but linking them to the other services they may need that may have been neglected during the pandemic. We have a lot of folks who haven't taken advantage of their health checkups, or they may need other rapid tests, or may need other immunizations. And those have kind of gotten put on the back burner since the pandemic started. So we're hoping to be able to make sure to link our families to the care that they need. All right, next slide. So in general, the takeaways are that we still are strongly encouraging residents to get vaccinated and to get boosted if they're eligible. Testing sites are readily available. There's no wait, and result times are much quicker. And then we still, during this surge, although rates are looking great, they're coming down nicely, but during the surge, we still recommend wearing a multiply well-fitting mask, especially when you are indoors in crowded locations. Watch your distance, wash your hands, and just be careful of large crowded indoor events. Dr. Memark, other things that you might want to add?
No, I just wanted to also just let everybody know that Moderna is now FDA approved for 18 and over. So we have 2 FDA fully approved vaccines for COVID-19. So I think that's great news. And so they will continue looking at those vaccines as well.
And I think there's some conversations right about toward the end of the month that they should be looking at the 6 months to 5 years of age, correct?
Yes, they're trying to release that as well.
So we'll keep you updated on those.
Mm-hmm.
Thank you so much.
Thank you.
Thank you, both Dr. Memark and Lisa. I know a lot of parents are looking for hearing more about the younger persons who can be vaccinated. Commissioners, do any of you have any questions this morning for Dr. Memark and Lisa Crossman?
I do not, Madam Chair.
Thank you. Thank you both for your presentation again. Appreciate all that you do. Hope that you all continue to stay healthy and also encouraged. I know it's encouraging to see the numbers go down, but that doesn't mean that the workload is getting light for everyone that's in the medical and public health arena. So just thank you for enduring with us during this time, and we hope to see these numbers go down when we have our next presentation before us.
Thank you.
Thank you
Feel
so
better.
much.
Feel better.
Thank you. Thank you. I appreciate it. I am on the other side of COVID, still in my 10-day isolation period, but am experiencing some of the breathlessness that does come with it. And so certainly appreciate all of the advice that you've given us over the past going on now 2 years, and hope that our public will take to heart a lot of the precautions that you've shared so that we can all stay healthy and get through this.
Take care.
Thank you.
Thank you.
Appreciate it. All righty, commissioners, we have 3 public hearings that are before us. The first one is with our Department of Transportation, and I see Drew has queued up here. Drew, you can feel free to go ahead when ready.
Excellent. Good morning, Chairwoman, Commissioners. Our first public hearing is related to the Noonday Creek Trail, which has been a phenomenal asset for the community. The Town Center Community Improvement District and the Atlanta Regional Commission have jointly identified a capital transportation improvement project that provides a safe and convenient crosswalk for pedestrian cyclists using the Noonday Creek Trail. The proposed crossing includes an elevated boardwalk approach, a bridge over Cobb Parkway, a bridge over Noonday Creek, and a segment of on-grade trail to tie into existing sidewalk. Total proposed crossing is approximately 0.6 miles in length and limits in unincorporated Cobb and the city of Kennesaw. In accordance with state law, the Board of Commissioners is required to conduct a public hearing prior to expending county funds of $100,000 or more to employ an independent consultant or consulting firm. Therefore, the department recommends the Board of Commissioners conduct a public hearing prior to expending $100,000 or more for engineering design services for Noonday Creek Trail Crossing, State Project number 0017989, Cobb County Project number TR525.
Thank you, Drew. I will go ahead and declare this public hearing open. Kimberly, do we have anyone with us today that signed up for this public hearing?
No, ma'am, there are no public hearing participants for this item.
Thank you. I'll go ahead and declare the public hearing closed. Commissioners, do any of you have any questions regarding this agenda item?
No, just to thank you to DOT and Drew and Town Center CID for making this possible. It's a great project.
It does look like it's shaping to be so. Very good. Thank you, Drew. We appreciate that. I understand that the next agenda item is also yours, so you can feel free to begin that one when ready.
That is correct. Thank you. Our next item is related to master task order contracts. The utilization of master task orders allows the department to recognize savings of staff time and other resources to increase efficiency by allowing projects to move forward in a quicker manner. Provides both flexibility and efficiency to have on-call expertise that may be required for smaller defined tasks. In accordance with state law, the board is required to conduct a public hearing prior to expending county funds of $100,000 or more to employ an independent consultant or consulting firm. Therefore, the department recommends the Board of Commissioners conduct a public hearing prior to expending $100,000 or more to employ independent consultants or consulting firms for master task order contracts for professional services.
Thank you. I'll go ahead and declare this public hearing open. Kimberly, do we have anyone here with us for this public hearing?
No, ma'am, there are no public hearing participants.
All right, and thank you, Director.
Thank you.
Yeah, and thank you, Director Limley. I'll go ahead and declare this public hearing closed. Commissioners, do any of you have any questions for this agenda item? Or comments? I see you, Commissioner Richardson. Go ahead.
Yeah, there was a question that came in from me, and maybe this is my own clarity, but is there a list of the previous firms that have been approved just to kind of see what came through in the last round?
There is. It's a pretty lengthy list because it's broken out by category: aviation, traffic, and engineering. I'll be glad to provide that to you.
Thank you. Thank you. Just wanted to make sure I went ahead and asked that.
Absolutely.
All right, thank you, Drew, and I appreciate in the agenda item you helping to describe what the master task order process is, so to clarify that for the public. All right, thank you. We will now move on to the more meaty of the public hearings today, and that will be to conduct the second public hearing for comments and input on the proposed code amendments. I will turn things over to you, Jessica.
Hello, good morning, everyone. I'm going to share my screen here. Jessica Gwinnett, Community Developments. Good to be here with you all today. We'll go ahead and get started. Of course, this is our second public hearing for the code amendments for this year. And we've presented this at this point twice to the board, the first time at the work session on January 25th, and then of course that evening at the evening public hearing. So the presentation this morning, I'll move through it a little bit faster and I'll do the entirety of the presentation. I want to kind of hit the highlights of the things that have changed since the first public hearing. And then from there, Madam Chair, we'll just ask that you open the public hearing, and of course we'll be glad to take any questions. And we have the subject matter experts from staff are all available to answer your questions as we move forward. But for now, I'll just work quickly through the presentation. Okay. So the first amendments are to Chapter 6. This is alcoholic beverages. The things that have changed primarily in Section 6.1, and as you'll recall, the majority of the changes to the alcoholic beverages code this year are due to state legislation with regard to being able to purchase mixed drinks at a restaurant in a sealed container and to carry them out, as many people did and sort of started during the early days of the pandemic. So most of the language that's in this code pretty directly reflects state law, and that's what we've incorporated in here. So the changes that have happened since public hearing number 1, and you all should also have a sheet in your packet that kind of highlights these, but the definition for brewery was updated to align with state code. Likewise, we added a definition of distillery, updated the definitions of growlers and howlers to add a little bit of additional clarity there, likewise with package, and also added a definition of tasting event, again, to add more clarity to the code. In the licensing section here, again, most of the changes here are pertaining to the new state legislation. And one thing that has changed is section 6-104. Previously, we had shown as being repealed in its entirety. We are actually keeping the last sentence of that section, so that'll be a change. And that sentence just reads, the license shall be prominently displayed so as to be visible to the public inside the premises. And that, of course, refers to the alcohol permit. Moving forward, as we speak to operating regulations for licensed establishments, and 6-176, again, we had a language change there. In the state code, there's language that's written about how mixed drinks in a sealed container can be transported in your motor vehicle to your house, and it mentions something, I believe, about glove boxes and what have you. So we changed the language slightly just so that way if the state code changes in terms of what part of your vehicle your mixed drink in its sealed container is being transported in, if that language changes, we won't have to necessarily change the county code. And that was a great comment made and point brought up by Commissioner Gambrill, so we appreciate that. Again, just continuing through the operating regulations for licensed establishments, and this all speaks to the servers themselves who are going to be serving alcoholic beverages and the requirements for those folks in terms of the things that they need to do with the police department to get those permits. Moving on, pricing of alcoholic drinks. This is a change that incorporates flights, and of course, flights are something that's a little bit of a newer mechanism of serving alcoholic beverages, and so that people can just get a small sample of several types rather than one drink. And so the code here will now accommodate for that. Moving on to Chapter 18, Building Regulations. Nothing has changed here. This is still 18-27, removing a section in here that pertains to the tear down and rebuild of single-family homes. This is a section that was incorporated years ago as there were a lot of tear downs and rebuilds and infill lots, particularly in like the Indian Hills Country Club and Atlanta Country Club areas, lots of rebuilds of single family. And at this point now, Stormwater Management really reviews this to ensure that that tear down rebuild isn't going to have a negative impact on the properties around it. So the review that's being done here in the building department is sort of duplicative of reviews that are already taking place. Moving on to Chapter 50, and this is one that we received a lot of great public comment on. This is the code as it stood before, and this was specific to when traffic studies are required for a land disturbance permit. The changes that have been made is that, first of all, we've clarified that this section here pertains to land disturbance permits, but there was a lot of discussion about trip-ins versus trips and what exactly is a trip-in and what is a trip. So that's all been replaced. Thanks to, again, we had a lot of great public comment on this and input from the commissioners also. So to clarify it, we've replaced all instances where it says trip-ins with trips, so that way it's very clear, and also added into that section that a trip means a single one-way journey between 2 points by a specified travel mode and for a defined purpose. A trip is a standard unit of measure for trip generation used in traffic, again, so that way it's very clear, and I think that will address the issues and the concerns that were raised previously about this section. Article 7, noise. This is in Chapter 50 also. The noise ordinance was covered by Cobb County Police at the last public hearing, but at this point, and as you all know from the conversations that have been had, the determination has been made that there's some additional work that we'd like to do on this section, and so the police department will continue working with county attorneys on that. And at this point, staff will be seeking to withdraw this amendment from consideration, and probably will bring it back for you at a later date for reconsideration once that language is further refined. Chapter 54, fire safety standards. Again, not a whole lot has changed here. One thing that has changed specific to the pre-construction meeting is the option to waive the pre-construction meeting for experienced applicants. And I think the pre-construction meeting is a great opportunity for particularly people who have not been through our process before to come in and understand what's going to be expected, and for the fire marshal's office to get an understanding of their project. But for some of our more experienced applicants, those who frequently pull permits here to go through a pre-construction meeting on every single project may not be necessary, and maybe, you know, to give the fire marshals an opportunity to kind of make a determination on that on a case-by-case basis, depending on the project and the applicant. So that's been incorporated. There has been some discussion about outdoor social gatherings, and I know that the fire marshal's office also spoke with Commissioner Gambrill after, or they sent me their changes, their proposed changes to this language after the agenda was published. So whenever the discussion is opened up with regard to this, it would be appropriate if the board is open to it, to have the fire marshal's office speak to what additional language they'd like to incorporate. Again, since that was received after the agenda was published, it is not included in the packet right now, but hopefully we'll give some clarity on that. Again, this speaks to the fire marshal's office appeals process, and nothing has changed here. Likewise with the fire prevention code. Fire contractors, again, no changes here. This still speaks to the contractors here. Continuing on, again, no changes, and a lot of these are in compliance, as I understand, with the life safety codes. No changes to 5484. Again, there was a lot added to the code with regard to the Board of Appeals for the Fire Prevention and Protection Safety Ordinance. This is the Board of Appeals here is similar to the Construction Board of Appeals, where there's a number of specific professionals that are encouraged to be included on your Board of Appeals for fire. And so that's what's being incorporated here, and where those changes are coming from to bring it more in line with those codes. Likewise, no changes to 54-120 from the first public hearing, or 54-121. And then we'll move right on to Chapter 78. And again, Chapter 78, no changes to the first section here in the definitions, which would remove the exemption for the first $25,000 of annual gross receipts on real property, but also does not change the exemption for rental of single-family residential. No changes here to 78-43, which would simply make the change of ownership process now just follow the same process as a new business license application. And then the police department did a great presentation on human trafficking and massage parlors or health spas and the changes that are being proposed here. So I'm not going to go through all of this background. I'll just hit the highlights of the changes that have occurred since the first public hearing. 78-292, not a significant change, but there was some language there that was pertaining to suspension or revocation. That has simply been moved from this section to 78-294. The language is still the same, but it's just moved to a different section of the code. And no further changes to this section, I believe, for the health spas. And that brings us to the short-term rental. This is Division 11 of Chapter 78. Again, not a whole lot of changes. One thing that we changed, in speaking with one of the commissioners, there was some confusion whenever we say short-term rental. Are we talking about a property, or are we talking about each individual instance where someone maybe rents a short-term rental property? So to clarify that, and so everyone understands, this is speaking towards specifically to short-term rental properties. So we've added property where we say short-term rental. So it's clear that we're speaking to the property itself, to that unit, versus one person who may come in to rent the property for 3 days or what have you for the short-term rental. Again, the short-term rental certificate would be required for operation of short-term rental, and that would be issued by the business license division. Another change that's occurred since public hearing number 1 is that we've incorporated into the language regarding the short-term rental agent, that agent would be someone who would be a 24-hour contact for the property. At your recommendation, Chair, we wanted to be sure that we included that in there to make that clear. Nothing has changed to the standard conditions. Again, these conditions that are listed are exactly the same conditions that apply to any single family residence in Cobb County. So I know there was some public comment in the last public hearing about the occupancy being limited to 1 adult per 390 square feet. That is code for single family residences in Cobb County. So that's not something that's different for short-term rentals. Again, no changes to enforcement or penalty section for short-term rentals, and no changes to the taxation. Of course, with the state legislation last year has already required the advertising platforms to start collecting the hotel motel taxes, tourism fees, and what have you. And that brings us to Chapter 90, and of course, this pertains to smoking in public parks, and there have been no changes to this. I know there was some discussion and some comment from the commissioners about whether or not it was appropriate to keep the exemption for golf courses, and that is still in here, but I'm sure that Michael Brantley, the Parks Director, will be glad to speak to that if anyone has any questions. And ultimately, it seems that that's really sort of a policy decision for the board. Golf courses the exemption could be removed if that's something that's the desire of the board. Chapter 106, the change that's been here, 106-91, this is definitions. Previously, the definition for residential subdivision street had been removed from the code. The change that's happened then since the last public hearing is that language is being left in the code, so we will not be striking through that. 106-98, again, this is another one, and 98.1, where we had a lot of good public comment regarding fees in lieu of sidewalks and what have you. This is another one that staff at this point is going to ask to withdraw from consideration, to take some additional time to really look at it and make sure that whatever's put forward is something that's going to be in the best interest of the county. So for right now, this code is not, again, staff is asking for withdrawal. No changes to 106-136 pertaining to curb and gutter. And that brings us to Chapter 110, subdivisions. No changes here on the subdivision design standards, 11059 and also 11079. This remains the same from the first code, our first public hearing. Likewise with intersections. 110, 83, 89, and 90 all are the same, so no changes in that section. Chapter 118, again, no changes in Chapter 118. We'll go back. So this speaks to fire lanes. And that brings us to 134, and 134, of course, being zoning. We have had, since the last public hearing, we had a second meeting with the Planning Commission. We had a few items that they had continued previously at the January meeting, and so we had those back for their consideration last week at their meeting. So in 134-1, the changes that have been incorporated here, and 134-1, of course, was not an item that was open for the Planning Commission at their most recent meeting because they had already moved this forward to the board at the January meeting. So as part of their recommendation on 134-121, which we'll get to a little bit later, speaking to the traffic studies, they are also recommending that the board add the definitions that are currently in your second packet here for travel mode, trip generation, and trip generation rate. And again, this is similar to the amendment we discussed previously, but this pertains specifically to rezonings and SLUPs. Nothing has changed in 134-7, poultry, and again, Planning Commission recommended approval of that. 134-121, again, back to the traffic studies. And on this one, again, we've incorporated those definitions. Also, since the first public hearing clarified that A1 should be shall rather than should, replaced trip ins with trips, clarified tier 1 and tier 2 projects, and also some other clarifying language and just reordering it so that way everything is very clear about what's expected. And so this was one of the items that the Planning Commission had previously held, and they have recommended approval of the amended language at their meeting last week, along with those 4 definitions to be added to 134-1. Nothing has changed in 134-127. Again, this pertains to the appeal process for rezoning decisions. 134-162 remains the same. We had a lot of questions from the Board of Commissioners about why not add RA4 and RA5 to this also. The reason for that is RA4 and RA5 were actually already added in 2012, and somehow when that amendment was done, RA6 was missed. So this is simply cleaning that up. Those are already available as options. No changes to 134-203.2 RSL. 134-221.2, and this is the repeal of the redevelopment overlay district code. Again, nothing has changed since the last meeting on this one. 134-230 and also 134-231. So that's the light industrial district as well as the heavy industrial district. And this language pertains to freestanding climate controlled self-storage facilities. And since our last meeting, we had a good meeting with some folks up in Commissioner Gamble's district, some residents there that were very helpful and gave us a lot of good insight into what their concerns were with this. And we've tried to take the code that was being proposed and then pull from the code that was being removed, so 134-279, to come up with something that would continue to provide protection, particularly for those light industrial and heavy industrial sites that are sort of spot zoned throughout the county, close by to residential neighborhoods. And I know we have a number of those in Commissioner Gamble's district, as well as in Commissioner Sheffield's district and other areas throughout the county. So trying to ensure that, for those areas, there's going to be some protection for the residential uses if these freestanding self-storage facilities move in. So the changes that we've incorporated into since public hearing number 1, and I've lumped these into 230 and 231 because the language is the same in both. We've added a maximum building height limited to 1 story, not to exceed 20 feet above finished grade. And this is what's currently in 134-279. And the only way that would be able to be increased currently is if a SLUP was approved by the Board of Commissioners. So with this code, it doesn't change that. A SLUP ultimately is required for all freestanding climate controlled self-storage under the code that's been proposed. But the maximum building height, unless approved by the Board of Commissioners, would still be 1 story, not to exceed 20 feet above finished grade. So that'll, again, be at the discretion of the board. On item number 2, this was specific to floor area ratio. It said that floor area ratio should be 1.0, and we've added that to shall not exceed 1.0 just for clarity. We've added a requirement back into the code, and again, pulled this from 134-279, that storage of recreational vehicles must be in a designated place outside of the building setbacks. And that would be on a site plan that when they came to apply for the SLUP, it would be designated. They would show that on the site plan that you as the Board of Commissioners, as well as the Planning Commission, would see ahead of time to know where that outdoor storage is going to take place. We added additional requirements for a 20-foot landscape strip along all street frontages to provide year-round visual screening, again, pulling that language from the language in 134-279. Another concern that was raised is for these facilities that may be on a local road or a road that's not really designed to support tractor trailer traffic. There's concern about those types of vehicles accessing those facilities. So we've added a prohibition for tractor trailers at self-storage facilities access via local road. So that's incorporated into the code now. We also pulled some of the language from 134-279 to the lighting requirements to require shielding and a maximum height for lights at properties adjacent to residential. So that would be limited, and then the lighting plan would be subject to approval by the Board of Commissioners through the SLUP process. And then in number 17 in that section, that speaks to hours of operation. And currently it reads that the Board of Commissioners would set the hours of operation based on the hours of operations of businesses in the area. But if it's an area where it's primarily residential, there aren't any businesses to compare to. So we included in there surrounded uses also. So that way, surrounding uses, if it's residential, you'll take that into consideration in determining what hours of operation are appropriate. So essentially with 230 and 231, by requiring a SLUP for these facilities, it really does give the Board of Commissioners the opportunity to take the unique features of the subject property into consideration, whether it's near a residential neighborhood or on a busier street or what have you, to make sure that the stipulations and the conditions for this specific property are appropriate for the surrounding neighborhood. So at the Planning Commission meeting last week, they did approve or recommend approval of the amended language. 134-272, this is traffic and parking, and there have been a couple of changes to this since the first public hearing. One is that there's been an addition to with regard to striping The language reads currently that are in the first draft that the parallel parking would not be striped, and also included in that, including the curb line and cul-de-sacs. We also, in the portion that speaks to parking on non-hardened surfaces, clarified that new access to a public road would require a 25-foot paved or asphalt apron. Of course, those properties that have existing, grandfathered, so to speak, gravel driveways would not be required to put in a public or a 25-foot paved apron if they're not changing their access, if they're maintaining an existing access point. 134.275.1, this is the Military Airport Hazard District. Again, this is one that has not changed since the first public hearing. This pertains to the, removing the language that the Board of Commissioners put in there a few years ago to give the board the provision to take existing adjoining uses, history and height and those sorts of things into consideration, and really look at things on a case-by-case basis. They're close to the accident potential zone, APZ1, APZ2, and also the clear zone. 134.290, backyard chickens under 80,000 square feet. Again, we're changing this to backyard chickens under 2 acres, just for clarity. No changes here since the last meeting. And also no changes to the sign amendments that were put forward to allow for directional signage, as well as some temporary signage on those non-residential uses on residential properties. And so that's it. That's the bulk of the presentation. And, of course, at this time, Madam Chair, we just ask that you open the public hearing, and then staff is on hand and available. Glad to answer any questions you have. Thank you.
Thank you, Jessica, for doing a great job in walking through all of the changes that have been made to the code amendments, and also great job in synthesizing the feedback received from commissioners. As you stated, we do have a public hearing that accompanies this meeting today. So I will go ahead and ask for us to, or I will formally declare the public hearing to be open at this time. Kimberly, can you let us know if we have any persons that have signed up for the public hearing?
Yes, ma'am. We have 13 people signed up.
Okay.
And I will start with speaker number 1, Richard Grom. Richard Grom, you're unmuted.
Before you go ahead,
I'm
Mr.
sorry.
Grom, let me just confirm with our county attorney if he will be helping to track us on time, as I'm typically with him during our virtual meetings.
Yes, ma'am. I'll track the time, and each public speaker has 3 minutes. I'll let them know when 3 minutes is up.
Thank you, and I apologize, Mr. Grom. You can please feel free to go ahead.
Thank you, Madam Chairwoman. Commissioners, my name is Richard Grom. I am the president of East Cobb Civic Association. ECCA is disappointed that we have received no feedback from staff or commissioners on ECCA's recommendation concerning the proposed code amendments. Nor have we seen any discussion of proposed changes by the commissioners other than a few minor changes that have been made in version 2. The revisions that have been made certainly cannot have exhausted proposed beneficial changes suggested by the public. Having a second hearing without the public having a chance to see all the recommendations, especially those proposed by the commissioners, seems repetitive and unproductive. Having said that, ECCA again recommends the following. Article 7, noise. The decibel range seems unreasonably low and restrictive as presently written. We agree with Lieutenant Dupree and staff that this section of code should be held for further study. Chapter 90, parks. ECCA is still concerned about the realistic enforcement of this proposed code amendment and the creation of non-emergency 911 calls, potentially tying up limited emergency resources. Section 134-162 RA6. ECCA is in favor of the RA6 being added back as an allowable code requested by an applicant. In addition, because there is presently only one code in medium density residential, ECCA believes the next time code amendments are heard, RA4 should be added back as an allowable code requested by an applicant. We realize that it's already a code, but at the present time, it's our understanding it can only be requested by a commissioner. Section 134-203, residential senior living. ECCA believes that the addition of the proposed words to section 134-203, residential senior living, does not clarify the issue of required acreage as it relates to the location of an RSL on a collector road versus an arterial road. ECCA recommends a rewording of all areas in section 131-203 related to this issue for additional clarity. Thank you for your time.
Thank you.
Our next public speaker is Jill Flam. Jill Flam, you're unmuted.
Good morning, Commissioners. My name is Jill Flam, and I'm Vice President of East Cobb Civic Association. On January 25th, I presented ECCA's recommendations on the proposed short-term rental code 78-407. A copy of these recommendations was sent to you via email the morning of the 25th for the work session. We did not receive any feedback from staff or the commissioners regarding our recommendations. None of these recommendations or concerns were addressed in version 2 of the code. In fact, only 2 minor points were addressed at all concerning the code. Our comments were sent again on February 5th. We thought we would hear back from someone prior to the second hearing and possible adaptation of this code, as our recommendation document was quite lengthy. We did not. Most of our comments deal with ambiguous language, undefined terms, and issues dealing with potential administration problems. Shouldn't these items be cleared up by staff and/or the county attorney prior to the Board of Commissioners being asked to vote on codification? The procedure, as it unfolded, seems to put an extra burden on the Board of Commissioners to clarify from the DS any ambiguous language and/or administrative problems created by a code that we believe has many errors. In addition, it gives the public no time to read or even comment on these proposed changes. Why have a second hearing on essentially the same draft of the code? Shouldn't all the commissioners' recommendations be included in the second version? Our recommendations concerning this code remain the same, the specifics of which we spelled out in our email. There remain many examples of ambiguous language in the code, such as best efforts, may be, quiet enjoyment of property, and lack of defined methods of communication between all parties. Concerns remain that a $55 business license fee covers all the work involved with keeping 4 county agencies up to date on changes to the license, and if there is a mechanism to do so. Other questions remain and have yet to be answered. The questions of the homestead and senior exemptions, how children will be addressed regarding occupancy, and if changes will have to be made to a property every time the code changes, or will grandfathering be allowed? ECCA recommends that this section of the code be held for additional work and the public informed of any proposed changes at least a week prior to the next scheduled hearing. Thank you very much.
Thank you.
Our next public speaker is going to be Randy Bobo. Give us just 1 second. We've got a couple of slides to share. Mr. Bobo.
Thank you. Good morning, Madam Chairwoman and Commissioners. I'm back today to complete my comments from the last public meeting regarding short-term rentals. Next page, please. As a reminder, the property directly behind us has 2 dwellings, both used and marketed on Bobo as short-term rentals. While their policies exclude events and large gatherings, those listed here are very common. Next page. These pictures depict a lot of cars with lots of people and lots of noise that disrupt our neighborhood and peace. Next page, please. Here are three examples of reviews actually posted on Bobo regarding these properties. One depicts this one actually depicts a late arrival at 11:30. Late arrivals happen all night long. Late arrivals and early departures create lots of noise in the neighborhood. Next page, please. This particular review speaks to the ability to bunk extras over and beyond the 11 people that they advertise as in the one home. Next page, please. And finally, this is actually a guest in building 2 complaining about the very loud music and partying all night at the main house in building 1. They still gave them 5 stars, but this is noise that we deal with all the time. Next page, please. I would like to ask the board to consider a higher annual licensing fee similar to Atlanta's of $150 annually, rather than the proposed $55. The owner needs a higher stake in this enterprise. Also, please consider additional language taken from Atlanta's code to include, next page, please, that the short-term rental agent's agreement to use his or her best efforts, and I agree with the prior speaker that best efforts is a little bit shallow, but we need some assurance that they're going to be taking care of these occupants, not to disrupt the neighborhood and our peace. Next page, please. I would like to see written rules. This again is coming from the city of Atlanta, written rules that are actually posted in the rental unit that include, and especially our noise ordinance, maximum occupancy, as well as on-site parking limits. Next page, please. And finally, evidence that the short-term rental license applicant has provided notification via certified mail to the property adjacent to the short-term rental license, including all of the contact information. Next page, please. In our case, the owner agent doesn't care about noise or the disruption their property brings to our neighborhood or to our.
I'm sorry, Mr. Bobo, I'm sorry, your 3 minutes are up.
Thank you.
All right, our next speaker is Teresa Stendel. Teresa, go ahead.
Good morning, Commissioners. I have sent several emails to each of you regarding changes regarding self-storage facilities. And while we do understand the intent of community development trying to make it all zoning districts the same, we still have yet to fully address issues in which we have parcels that are spot zoned in residential neighborhoods. We have incorporated some of the requirements that will protect some residences, but on the other side, I don't think that we have fully addressed all of the unintended consequences. We have focused on the spot zoned parcels, particularly in residential neighborhoods such as we have in our area. However, we have not had any discussion really to talk about the unintended consequences of the deletion of 134-279. I think there's a lot to be said. I mean, there are a number of facilities that have been permitted throughout the county over the years in LI and HI, and while 134, 230, and 231 address LI and HI districts, what are the unintended consequences? For instance, yes, the 279 those that were permitted under 279 have been grandfathered in, but where does that leave those facilities? Is it grandfathered in perpetuity? If ownership changes, does that go away? You know, there's so many unanswered questions, and we have requested both of the Planning Commission and of this board to continue to hold this until we get it right. We can't afford to change county code and kind of be a little bit better than where we were, but not having arrived yet. So I respectfully request that 134, 230, 231, and the deletion of 134, 279 be held or withdrawn until we actually have all of the answers to all of the questions that are still on the table. Thank you.
Our next speaker is going to be Hill Wright. Mr. Wright, go ahead.
Hill-Wright, section 131, 121B8, zoning. The traffic impact study language is totally unacceptable. The 750 trip and 3,000 trip numbers are too high. Developers often try to not do traffic studies as it is. We fought too many cases where investors and developers want to rip up our neighborhoods and stack density in or next to our neighborhoods. These numbers will kill our neighborhoods. Furthermore, how will the county staff know what trips are if a traffic study isn't done? And won't this put more burden on the county staff to do the study themselves to make sure developers have not understated the impact? Put the burden on the developers to do traffic studies, not take it away. Another thing completely left out of the code is traffic impact around school zones. I've seen traffic studies that completely ignore a school in close proximity. I've seen segments that should have been included that were not to lower the trip generation numbers. In fact, I've seen traffic studies that were not even prepared by engineers past office traffic studies. The code should require all traffic studies be sealed by a professional engineer licensed to practice in the state of Georgia. It should specifically state that all pertinent segments that contribute to the impact shall be studied, including school zones that are within the sphere of impact. Developers are asking for annexation into cities for more favorable treatment. The code should require any developments that impacts a county street or road must submit a traffic study to Cobb County. No more running traffic through our neighborhoods from property annexed into the city to skirt Cobb County protections. In addition, changes to zoning applications, impact studies and plans, etc. should be available for public review of at least 10 days before a hearing. This must be put in the code because we can't have another hearing where a developer changes a plan at the hearing or so close to the hearing so as not to let all interested parties have enough time to prepare meaningful comments. This code section change is half-baked and a request to be tabled. If it is approved as proposed, I promise you, I'll make sure the whole community knows they have been let down by this board. Next, short-term rental code should include VRBO short-term rental of storage space in homes. Homeowners can now offer to rent storage space in their homes. Last, object to the obvious gender discrimination of the chickens. Thank you.
Thank you.
Our next speaker is Ray Thomas. Give us just 1 minute. We have a couple of photos to share for Mr. Thomas.
Hi, good morning, Chairwoman and fellow commissioners. My name is, am I on yet?
Yes, go ahead.
Okay, thank you. Let me start over again. Good morning, Chairwoman and fellow commissioners. My name is Ray Thomas, and I'm here to speak on behalf of the HOA network of the Mableton Improvement Coalition on the proposed code amendment on short-term rentals. We have 20 homeowners associations in our network, so we feel that we're pretty well represented in our area. First, on a personal note, I'd like to wish the chairwoman my prayers and recovery from COVID, and hope you and your family are doing okay there. I would also like to thank Director Jessica Gwynn and her staff for their work on the proposed amendments that are before us today. We generally support the institution of the proposed amendment on short-term rentals, even though it is not a perfect ordinance. The proposed amendment is a good start. Over the past couple of years, HOA board officers have approached us on the HOA network about complaints on short-term rentals in their neighborhoods. They have sent us pictures of large parties. As a matter of fact, there's a couple of pictures on the screen right now. I apologize for the graininess of the pictures, but I think it points to what we're trying to communicate. So these HOAs have sent us pictures of large parties in their neighborhood, massive parking violations, and noise disturbances. More importantly, these HOA officers are concerned about strange people coming in and out of their neighborhoods, as well as impeding their neighbors' ability for quiet enjoyment of their property. We're also concerned about the proliferation of short-term rentals in residential neighborhoods, essentially turning residential neighborhoods into hotel communities. Now, short-term rentals are a relatively new phenomenon, and many community associations do not have restrictive covenants to deal with this problem when they arise. So again, we generally support the proposed short-term rental amendment. However, we do have a couple of concerns. Our number one concern is the enforcement of the ordinance falls primarily on the shoulders of the Code Enforcement Division of the county. This division is already stretched very, very thin and is having a difficult time enforcing existing ordinances. So we don't see how they will be able to effectively enforce short-term rental rules without additional resources. Secondly, the proposed amendment does not spell out the effect of the proposal on as they relate to community associations. There is one vague, small reference to restrictive covenants.
Mr. Thomas, I'm sorry, your 3 minutes are up.
Okay, well, thank you very much for your time.
All right, our next speaker is Carol Brown. Ms. Brown, go ahead.
Good morning, Carol Brown, Canton Road Neighbors. I downloaded the Gwinnett County Noise Ordinance, and I did send a copy to all of you, I believe. It's a robust ordinance that covers many different types of noise, distance from noise, and uses the plainly audible standard rather than relying on a decibel reading. It comes closer to the Georgia nuisance law, which gives more latitude as to what can reasonably be considered a nuisance by those near it. I think that our commercial zoning code needs to be strengthened when it comes to language and use limitations prohibiting noise emanating from non-residential zoning districts, especially when they are adjacent to residential property. The Gwinnett Code does a good job. Enforcement of noise violations that are related to non-residential properties that have a noise issue on an ongoing basis should be within the jurisdiction of code enforcement. Police can continue to deal with other types of noise and noise taking place at night and on the weekends. I would hope that police and code enforcement should have both A and C weighted decibel meters, but should also be able to accept well-documented readings or video from residents who are impacted, because both police and code enforcement lack staff to adequately address noise violations. I do agree with the decision to hold this ordinance for further work, and I would encourage you to look at the Gwinnett ordinance. I think it has some very good suggestions. I briefly want to address short-term rentals. I agree with the concerns expressed by Mr. Thomas, the previous speaker. I do think that where you have neighborhoods that don't have restrictive covenants, we're going to be possibly more at risk for having investors come in and see an opportunity to turn our neighborhood into a hotel, I think was the phrase he used. Perhaps this should be held for further work. Thank you for your time.
Thank you.
All right. Our next speaker is Phil Anzalone.
Correct.
Go ahead.
Madam Chairperson and Commissioners, good morning. My name is Phil Anzalone. I'm president of Pine Tree Civic Organization. I'm also speaking on the behalf of Bells Ferry Civic Organization. And we are strongly supportive of the short-term rental amendment. We've been working on this for 2 years and have been very desperate. Because of our physical location, we surround KSU, we have Town Center Mall, the KSU Stadium, McCollum Airport. We see a lot more rentals than probably anybody else except for the area around Truist Park. Specifically, we've had major problems over the years, but we don't have the statistics. We have the pictures similar to the ones you've seen with the noise, the traffic, the damaging of roads. We have a consistent problem because the streets within the residential areas are only 20 feet wide. We wind up too many cars that park parallel, we can't get the sanitation truck through, we can't get the school bus through, we can't get fire trucks through. Fire trucks basically just run onto people's lawns to get to where they need to go. And it's very difficult to recoup the cost for that because the county is not responsible. We strongly ask you to pass this. We realize it's not a perfect ordinance, but there are so many issues that need to be addressed immediately. As other people have said before, something that we've also seen, the number of rentals are increasing significantly. That's partly due to the fact that a few years ago we passed the Purpose-Built Student Housing Act. And so a lot of the student housing facilities now enforce regulations a lot stronger. But students specifically then move that to the private households where there are no restrictions, no liquor restrictions, no restrictions at all. So we've moved the problem from some of the housing locations for students into the neighborhoods. In fact, we've seen significant number of houses, people giving up and selling. And what usually winds up is the only people that buy these houses now are corporations that do rentals that need to have skin in the game, what they define. One of the other problems we've seen is the fact that the enforcement, by the time code enforcement gets to this, the people that offended are long gone. So the statistics are not very good. The other thing we've seen too is, especially students, they don't use Airbnb. They go direct. And some of the people, especially owners that are owned by corporations, they deal directly. So there's absolutely no regulation.
Sorry,
we ask you to please pass this regulation.
Our next speaker is Joseph Santoro. Go ahead.
Good morning, everybody, and Chairwoman Cupid and Board of Commissioners, thank you for the opportunity to provide public comment today. And Chairman Cupid, I'm glad you're on the road to recovery and feeling better. So with that, I'll be quick. And really, I just want to thank the board staff for taking our comments and recommendations into consideration. And just a special shout out to Jessica Gwynn for all her efforts and work on this. I know it's no easy task, so thank you for all that you do. Really, the only comment I have today is regarding the rezoning and land use permit application section 134.121. This is relating to the traffic impact studies on page 51. And really, it's regarding the traffic study shall be completed to the Department of Transportation 30 days prior to a planning commission hearing. We believe this is a little aggressive in comparison to some other counties, and would recommend reducing that days, maybe 15, but also maybe looking at a provision that allows more flexibility that the applicant as well as the Department of Transportation can determine a agreed upon delivery schedule. So that's all I have today. Thank you again for all your work.
Thank you.
Okay. Our next speaker is Sharday Taylor. Go ahead, Sharday. You're going to need to speak up, please. Sharday. We'll come back to you. Oh, yes. Go ahead, ma'am.
Yes, I wanted to speak on, I was trying to ask y'all to do a public comment. I wanted to speak on, what were they doing in regards to, helping the community members that need, housing, like as far as low income housing and things of that nature, because people are getting pushed out. And I haven't heard anything in regards to.
Yes, excuse me, Ms. Taylor. Yes, Ms. Taylor, we are in the middle of public hearing for code amendments. And I perceive that you are looking to sign up for public comment. Any comments during this public hearing need to pertain to the proposed amendments. The matter that you're referring to is outside of the realm of the proposed amendments. I don't know if I think it may be too late to sign up for public comment unless that was the initial plan. Kimberly, if you can help address that.
Yes, she was signed up for the public hearing. It's up to your discretion if you wanted to move her to the second public comment slot. I'll let Bill weigh in on that as well.
Okay.
We do have some vacancies in that second slot.
Thank you. I am open if there are vacancies in the second slot, unless we're precluded by any legal consideration, Bill. Bill Rowling, are you with us?
I'm with you. We were just muted for a second. Yeah, as long as the board consents to it, that's fine.
Okay, board by consensus, are you amenable to us adding Ms. Sade Taylor to public comment? I see. All right, thank you, board. Okay, Kimberly, can we go ahead and just add her to the second public comment, please?
Okay, Sade, you'll be added to the not slot in the second public comment section. I'll meet you back for now.
Thank you.
All right, our next speaker is going to be Garrett Wiley. Go ahead, Garrett.
Hey, good morning. Can you hear me?
Yes.
Good morning, Garrett Wiley with the Greater Atlanta Home Builders Association. The Greater Atlanta Home Builders cover 9 counties in the Greater Atlanta area with a little over 1,100 members, and we're one of the largest HBAs in the country. Just wanted to say thank you to staff, chairwoman, and commissioners for listening to our public comments and our kind of taking those into consideration. Thank you, Jessica. I will echo Joseph Santoro with the Council for Quality Growth regarding page 51 and the timeline for the traffic study. We sent in a letter a couple weeks ago and hope that you all will take that into consideration. Thank you all and look forward to working with you in 2022.
Thank you.
Okay. Our next speaker is P. Diane Eman. Go ahead.
Yes, correct. And good morning, Madam Chair and Commissioners. I have a question before I make any comments, and that is perhaps my comments may need to go to a general comment session. It's regarding an amendment that I see missing in the overall amendment list that is before you right now.
Similar, commissioners, to the last speaker. Ms. Amon, thank you for signing up today. I certainly am amenable to adding you to public comment if your comments are not with respect to any of the proposed amendments today, if you're okay with that. Commissioners, are you amenable to adding Ms. Amon to public comment? Okay, I see 2 hands, 3 hands, and that includes me, so it's 4. Kimberly, if you can help us in adding Ms. Eman to the second public comment, please.
Okay, she will be speaker number 10, and you'll be muted until it's your turn again.
Thank you.
Okay.
Excuse me, Madam Chair.
Yes, ma'am.
Do you also have comments on an amendment that she referenced that's missing, or is that totally public comment? I don't.
Yeah, if she provides it's missing, my presumption is that it's not pertaining to one of the code sections that are listed, and therefore will be out our realm of consideration for this package.
Right.
Yeah.
Okay.
Okay. Our next speaker is this is our final speaker for the public hearing, Greg Lowry.
Hey, good morning. This is Greg Lowry. Thank you for your time. Hey, my comment is pertaining to the amendment for 134, 230, and 231. I sent a message the other day. What I wanted to say is that the community has met with community development. We had one meeting, but we really haven't been able to review the latest version of the changes. I just feel like at this point, the existing code 134-279 has much more detail, much more specific regulations around zoning for self-storage. Deleting this one would really cause a problem. The amendments are just too vague at this point. We wanted more specifics in that. We have not had time to review that with ComDev. So my request is that we either put it on hold or deny it for now and give us some more time to work with ComDev. We did not even see the latest version of that document until a day after the Planning Commission voted to approve it. So that wasn't posted until a day after the February 1st Planning Commission meeting. So just feel like it's been rushed and we'd like more time to work on it. I'm willing to do that. I realize they don't have to take all of our comments, but at this point, the amendments just leave too many holes and remove a lot of protections that are in the existing 134-279. So that's my comment. I appreciate your time.
Thank you, Mr. Lowry.
That's all the public speakers for this public hearing, Chairwoman.
Thank you, Kimberly. Appreciate you helping us go through all of those who signed up to speak. Commissioners, this is our opportunity for us to weigh in on the code amendments as proposed. I know we did have discussion about this yesterday during our work session with respect to how we want to move forward procedurally. There was communication about us potentially holding all of the amendments before us to give us opportunity to better consider all of the feedback provided by the public and by commissioners. We had also discussed potentially adopting only those code amendments that pertain to any administrative or clerical issues that didn't have any changes or concerns that have been presented by commissioners or the public. Certainly, there are other options. We can go through each one of these one by one and consider the changes that we are aware of that were presented by Director Gwynn. And we can consider the comments that were shared today and potentially adopt these by considering changes to the amendments based on that. Those are just three options that I've seen in weighing our conversation from yesterday and listening to the presentation and the speakers today. I certainly would like to hear from each of you on what your thoughts are. I see Commissioner Burrell's hand raised, and I will share with my screen. I have you in the order of Burrell, Sheffield, Richardson, and Gamble. And Gamble, I didn't see your hand raised, but I'm going to ask for you to weigh in as well so that we can have very clear consensus from commissioners. And then I'll also share my perspective as well, if needed. So Commissioner Burrell, you can go ahead and let us know your thoughts on how you think we should proceed.
Thank you, Madam Chair. I would like to go through and the ones that have minor changes and no comments from the public in opposition or changes requested, I think we would be good to go ahead and pass those. They've been ongoing and advertised and gone through the process, legal process. And in our discussion, if there's, discussion that is opposition between us or whatever, then we can hold it or see what needs to be done at that time. But for the most part, the ones that are pretty standard and haven't had any public comments or objection, I think are ready to move forward with staff's recommendation and our discussion. Then as we go through these, there may be some that didn't have public opposition, but it may not be a consensus of the board. But if, I'm yielding to you to say how, I mean, do we call for a vote and it passes 3-2 or 4-1 or not at all, or, but I'd like to see what we can move forward without, and, you know, especially the ones that have no controversy or public comment in opposition or changes requested.
Thank you, Commissioner. Go ahead.
Hold the noise ordinance and the ones that were recommended to be held in that respect.
Okay, thank you. Before I refer to you, Commissioner Sheffield, bear with me. I'm still taking notes from what Commissioner Shaw shared. Thank you. Go ahead, Commissioner Sheffield.
Sure. Thank you, Madam Chair, and thank you all for participating in the process, and also to staff, because there is a fair amount of work that goes into preparing this to present not just to the Board of Commissioners, but also to the general public. I am of the opinion to move forward with those items that have minor or administrative changes so that we can move that forward. But I would like for us to take a deeper dive into some of the items that are of particular concern to the community as it relates to LI and HI. I think there might be some confusion still there, and we may be conflating several issues as it relates to LI and HI. But Jessica Gwynn mentioned earlier that for the Board of Commissioners to have a SLUP as it relates to LI and HI, it actually protects the public. And that's the part I need to have drilled in as we move forward in conversations with LI and HI. Regarding short-term rentals, I would definitely like to see a few more strict rules and regulations as it relates to short-term rentals. For some that may not know, I am also a real estate broker, and I have been witness to how the short-term rental market is slowly, I don't want to use the word denigrate because that's a very strong word to use, but it's turning our communities into something that they're not. It was mentioned earlier by Ray Thomas that we're turning our communities into hotel locations, and that's precisely what's happening here. So I think we need to have some stronger rules, some stronger fines and violations as it relates to short-term rentals. And I'll also share, in serving on an HOA board, on several HOA boards, that has been the consensus of the community, that they're fearful that they have strangers in their community that they may not know. There is no vetting process to determine if a person is a convicted rapist or a child molester. There's just no way. And you have parents that trust their neighbors, where the child may just simply walk to the playground or to the pool alone, but you have strangers in your community.
Excuse me, Commissioner Sheffield,
Yeah.
I'm sorry to interrupt, and I do want to hear your substantive remarks.
Okay.
Help us. I'm just trying to identify what should be our process before we do this, so that.
I'm sorry, I kind of got off on a tangent.
That's okay, and I didn't want to.
Okay, I'm sorry.
But if you can.
Okay, I guess I showed my hand with that when I got off on a little tangent. I apologize, Madam Chair. But I am of the opinion to move forward with those items where there are administrative changes, and let's hold off and have greater discussion around those items that are a greater concern to the general public.
Thank you, Commissioner. Richardson, give me one moment because I want to make sure I'm putting all of our notes side by side because I want to see where there's overlap. Okay, Commissioner Richardson?
Absolutely. And I certainly want to echo the thanks for all of the hard work that staff has done and the community has done, and all the feedback that is coming from the commissioners on these different code items. This is a pretty heavy one. I too am willing to move forward with the more administrative code amendments. With that being said, though, there is one where I have an outstanding question. Just from a clarity standpoint, I don't think that there's disagreement on the board, so I wouldn't want to be the holdout. And I don't know if I should just go ahead and ask. I'm assuming it's a yes or no on this one, but it's regarding Chapter 18 with the building regulations and the change to that Part E. I just need to know if it was mentioned that that was duplicative. And I just want to make sure that if there is a tear down or a rebuild, that Stormwater is still going to see what that new plan looks like, because there are instances where, things kind of get skirted. So Jessica, hopefully you can yay or nay me on that.
Yes, that is looked at and reviewed by Stormwater.
Thank you. Thank you. Okay. So yes, I would be perfectly fine moving forward with the more administrative items on here, and everything that was brought up as a point of concern from the community is also on my list of point of concern.
Thank you. Bear with me as I have some movement in my home. I am going to go to you now, Commissioner Gambrell.
I echo the sentiments of the board as far as going through each one of the sections of code amendments and looking at them. However, I know we had 2 speakers that we moved to public comment. However, I know there were speakers that wanted to speak at our last meeting in regards to code amendments, but were not able to because they did not meet the sign-up deadline. So we're being a little inconsistent here as far as how we allow folks to sign up. And some of those did speak today on the LIHI and then also the removal of 134-279. So as long as we can have individual discussion, and also knowing that if the public wants feedback, I think we should hold those sections and then also allow our notes to be released for public review.
Thank you, Commissioner. And if all commissioners, if you can bear with me while I capture that, and then I will refer to our notes and share whether there is consensus. Okay, thank you, commissioners. In summary, I have here for the Commissioner Burrell has desired for us to go through the code individually and for us to move forward with those that do not have opposition, comment, or questions, to hold ones where staff desire them to be held. However, for the board to consider still potentially voting on matters where there may still be some disagreement among commissioners. We can still potentially vote on those, but she's willing to see where other commissioners are. With respect to Sheffield, she has shared that she would like to hold off on approving codes except for those where they address administrative concerns. Commissioner Richardson also shared she's willing to move forward with those that require administrative changes. She also had a question that was answered by Director Gwen. Commissioner Gambrell stated she would like for us to go through them one by one and look at them and to consider the feedback provided by speakers. And she also recognized there are some inconsistency in participation for those that signed up during our last meeting that wanted to speak with respect to the code, but signed up for the wrong section. I hope that helped to capture everyone's sentiment. If it didn't, please let me know before I share my comments. I'm not seeing anyone's hand up. I would like to share that my inclination is to be generous and to not move forward with us approving the code sections in light of all the feedback we've received with persons who feel as if they had not had enough time to weigh in and hear from commissioners and to see all of the changes that have been proposed by commissioners. That was not a sentiment shared by any of you in your remarks. There is a leaning for us to move forward and go through these one by one and approving those that have administrative changes, and for us to wait on approving those that have additional questions or concerns or challenges. I am more inclined to support that, for us to walk through these or have Jessica walk through these, help us to identify which ones that are more administrative in nature without comment, question, or challenge. That would enable us the opportunity to better weigh all the feedback that each one of us has provided, to weigh the emails that have been provided by the public, similar to what Commissioner Gamble has shared, for us to share our feedback with the public so that they can also weigh that. And that way we can take all of that into consideration when that comes back before us. Again, I'm here. From what I heard, there seems to be a majority of us that are willing to support that. If I can get a show of hands of those who'd be willing for us to follow that process, will you please raise your hand? Okay, thank you. I see consensus from the full board. Jessica, if you can help us with this process, but before I do that, I do want to acknowledge Commissioner Gamble. The board did go ahead and share by consensus our willingness to move to speakers to public comment, and that may not have been the case in clarifying any confusion of the last meeting. Hopefully, with the deferring of the code changes that are not administrative, we will have opportunity to better hear from those that did not have opportunity to participate during that last meeting. And I appreciate Commissioner Gamble bringing that to our attention so that we can be mindful of that moving forward. With that, again, full disclosure, I'm trying here. This is a lot more speaking than I've been doing over the past 2 days than I've done over the past week. So, Jessica, I'm going to have you please help us in going through your presentation. And in each of the pages, you refer to different code sections. And if you can let us know, and also referring to the document where you synthesized information too. I'm just pointing out those that are more administrative without concern or question brought by the board or members of the public.
Yes, ma'am. Glad to do that. I'm going to pull the presentation up again. We'll start at the beginning so that we can walk through. The first amendments were to Chapter 6, and this was the alcohol chapter, alcoholic beverages. So the changes in Chapter 6 really were, again, to reflect state law. The exception to that, if we page through, is Chapter 6-179, and this pertains to where alcoholic beverages can be sold and the requirements for sales and amusement parks licensed under this chapter. And I shared with you all a PowerPoint presentation that Six Flags sent to me. This is something that had been discussed with the previous county management team back in, I believe, 2018 is what was indicated. So that was prior to my time and prior to the time of several of you on the board also. And at that point, the agreement was made with the county management team that Six Flags would operate in the way that's proposed in the code amendment. It was never codified in the code. So they did send us a good presentation yesterday to detail the mechanisms that they have in place to ensure that they're not over serving people, that, you know, alcoholic beverages are not leaving the park, to ensure that they're not serving to underage persons. They can't even enter something into their point of sale service without seeing an ID first and entering that date of birth into their system, as I understand it. So that's the one that's not really an administrative thing. It's really just codifying the process that's already apparently they've been doing since 2018, and we don't have any records of issues with that. So I'm glad to answer any questions on Chapter 6, and then however the board would like to proceed there.
Thank you, Jessica. Looking here, that would be Code Section 6-179 that
Yes,
you're
ma'am.
referring to.
Yes, ma'am.
Okay. I was present when Six Flags began serving alcohol on site, and know that I did have additional communication with them and staff with respect to this. So I'm inclined to at least initially defer to Commissioner Sheffield for her comments and feedback.
Thank you, Madam Chair. Thank you for following through on the policies from Six Flags, Jessica. But my follow-up with Six Flags, currently they will issue a wristband and they'll check ID. But my question is there a max number of alcoholic beverage that a park goer or patron is allowed? Or can they purchase as many as they would like as long as they have a wristband and valid ID?
I did not see in the presentation where they had a limit on the number of beverages that could be served to a single person in a day in the presentation.
Okay. Yeah, I didn't find that either, and that's why I was following up. I thought maybe you had additional information to provide.
No, ma'am.
Would we know, you mentioned that the system, once the beverages are purchased, that it's entered in the system, is the system tracking the number of beverages, alcoholic beverages that are purchased per person?
I can't speak to that. And the information I have is the PowerPoint presentation that you all sent, or that you all have also seen. That's what they shared with me.
Okay.
So it would appear from Commissioner Sheffield's questions that there still are outstanding questions with respect to this section. So I would ask for us not to move forward with this today. I did see Commissioner Burrell's hands up. I did see a nod from Commissioner Richardson as well. Commissioner Burrell, go ahead, please.
Thank you. I was just going to ask, legally, can we restrict that in our code? The number of sales to one patron, to one person. I don't know. Is that out of our?
I'm sorry, and perhaps Bill can weigh in on that. I don't know if there's some sort of state law that would require a maximum number of 2 drinks, say, for example, if the majority of the park goers are minor, or if it's at a baseball game. So I'm not sure if there's an overlap of state law here, but we can have Bill, if you're there, if you can weigh in on this for us.
Yeah, that's really covered in the state law. You're not supposed to serve anyone who's intoxicated or appears to be intoxicated. And also, the person could just buy alcoholic beverages for themselves. They can't buy it for other people. So it depends on if it's at a table, if they need to actually be, that person to be sitting at a table, or if they're walking up, they'd have to be able to purchase it for themselves. An ID would be checked for each one.
Right, and I understand that, but my concern again was the limit that a person, or the maximum number of beverages that a single person can purchase for him or herself. And you mentioned that if a person appears to be intoxicated, but people have different levels of tolerance with alcohol. So I was just wondering
That's
if
why there's not a specific limit, because they have different tolerance. I mean, I'm not aware of our code ever addressing how many drinks a particular individual can purchase.
Okay.
Again, I'm not so clear on that myself, Commissioner Sheffield. You know, again, this was done in a painstaking manner when it was initially proposed. There was a group that spoke up with great concern about alcohol being served in the park, which helped in having the presentation that was provided and the ability to ask additional clarifying questions. And so again, I would ask that we not move forward with this until we make sure all of the concerns are being addressed. I saw Commissioner Richardson's hand up. I'm sorry, I don't have you. Okay, there you are. You moved, your Hollywood square moved on my screen, but I see you now. Would you like to weigh in on this matter?
Sure. Thank you. The only thing I was just going to say is when I do agree, I'm fine with the other aspects, but where there are certain questions still outstanding, it's fine to hold it. But I will say for the Truist Park area, there is a lot of coordination amongst all of those different groups that serve alcohol to reinforce amongst each other how to meet that standard and enforce internally. So that may be something, I don't know if that's part of their presentation, but it's basically an internal check process to really make sure that everyone stays as safe as possible. So that may be something that Six Flags should also look into doing.
Thank you for sharing that suggestion. Commissioner Gamble, did you want to weigh in on this before we move forward?
The only thing I have to say is I think as a government entity, we have to be very careful about, what we start specifying on a private property owner's property. There is an assumption of risk when you go somewhere. So while I understand the concerns, but it sounds like, according to Commissioner Richardson, Truist Park has figured out a system to ensure that they stay in compliance. So I would caution us moving forward.
Thank you, Commissioner Gamble. With that, Jessica, again, why don't we go ahead and hold this so in any of the concerns or questions that were raised can be addressed with the park.
Chairwoman, this is Bill Rowling. There's a big section of Chapter 6 that there doesn't appear to be any questions. I think Commissioner Sheffield's question is just limited to 6179.
Correct.
So you go forward with the remainder portions of Chapter 6 if there aren't any questions, and then just not incorporate the change to 179.
You're a step ahead of me, Bill.
Okay, I'm sorry.
Yeah, that's okay. I got it. I appreciate that observation. And I see here that there are other sections of Chapter 6 that are listed here that Jessica, please help us as Bill shared to walk through that, as there may be opportunity again for us to approve some of these things where there are no comments, concerns, or questions that are more administrative in matter.
Yes, ma'am. Again, 6-179 is the one that was unique in that it was not an amendment that was necessitated or brought forward as a result of the change to state law. So if there are no additional questions on Chapter 6, then perhaps it's just 6-179 that you may want to hold.
Thank you. Commissioners, with what has been presented for Chapter 6, are you comfortable with us moving forward with the other sections outside of Section 179?
Yes.
I'm sorry, if you can help me in raising your hand and that way I can see. All right, so there's consensus for us to move that section forward. And just in the interest of time, why don't we go ahead and just approve that now? And so we don't have to go back to this as we're going through each chapter. So I will move that we adopt code amendments to Chapter 6, excluding Section 6-179.
Second.
Is there any further discussion or question regarding this motion? All those in favor of the motion as presented, please raise your hand. The motion passes 5-0. Thank you, commissioners. Jessica, if you can help us before we go on, Pam or anyone from our clerk's office, are you comfortable with us approving the chapters as we just did for chapter 6?
Yes, ma'am.
All right, thank you. All right, we can go ahead and go on to chapter 18.
Very good. Chapter 18 is that one section, and Commissioner Richardson asked her question. I don't know if there are any additional questions. This one is a very administrative one pertaining to tear down rebuilds of single families.
Okay. Let's give the commissioners opportunity to get to that code section, including myself.
Madam Chair.
Yes, ma'am.
Jessica, is the stormwater management, the rebuild, is that included in here?
The stormwater management already reviews these. So at this point, whenever we adopted this code initially, they weren't completing that review, but at this time they are, so it's redundant. And
Okay.
slows down the process a little bit.
Okay, I just wanted to make sure Commissioner Richardson's comments and that it was incorporated and approved. Okay, I'm good with this.
Thank you. Do any other commissioners have any comments or questions with respect to chapter 18? And with that, I move that we approve the amendments to chapter 18 as presented. Is there a second?
Unmute.
Second.
Oh, was I muted?
No.
No,
Oh,
Jessica.
okay. Okay. Okay, so we have a motion and a second. Is there any additional comments or questions? All right, all those in favor of the motion, please raise your hand. And that motion carries 5-0. Thank you, commissioners.
Okay, the next is in chapter 50. This is 50-76 pertaining to traffic studies for land disturbance permits. And again, I think that we've addressed a number of those concerns with regards to trips versus trip-ins and clarified that. Glad to answer any questions. And I know Drew is also available if there are any additional questions on this one.
Commissioner Gambrill.
Jessica, I do have a question because I know we've defined trips, but then on page 66 of the agenda book, that way everybody can follow me. It then says tier 1, but I don't see tier 1 defined anywhere. And maybe this is the wrong section to bring this up, but where is the tier 1 as far as the definition in here?
I'm going to let Drew speak to that.
Okay.
And it's referenced in, it's talked about in section 134, and that is an internal designation that we've used just to identify. It's defined kind of within that section of just that it's a traffic studies required for 750 trips or 75 vehicle. I'm sorry, you are in 134, aren't you?
Well, okay, so this is one of those that it's trips are talked about in 2 different places of our code amendment package.
Yes. Okay.
So I know we defined trips to help because it was trip ends. So we've removed the ends. So we've defined trips. And I still find it's interesting that the numbers differ from this section of the code when an LDP is required as compared to section 134 when we're talking about rezoning.
Sure. So first I'll address kind of to the question at hand in section 134, a tier 1 versus a tier 2. The tier 2 requires, if you go on down to towards the bottom of page 67, let's see, find it exactly, but it's kind of mid part of the page. So for a development expected to generate more than 3,000 vehicle trips in a single day or more than 250 in a single hour. And then we go down, it talks about the scope of the study to, at a minimum, address conditions and impacts resultant from the project within a 10-year scope. So the requirements are inclusive of that tier are within that particular paragraph. So the difference between a tier 1 and tier 2, just comparing the language of those two paragraphs, is that a tier 2 represents a much larger development. We're talking now 3,000 trips a day compared to 1,000, so three times as large. With that tier 2, it opens up not just looking at the impacts for the development in the open year of the development, but also the traffic impacts 10 years after the development opens. So growing the traffic, the background traffic, the development traffic over that 10-year period to look at those impacts. And the difference between the section here for zoning actions and for land disturbance permits is just in comparison of looking at what our code section was and then comparable counties and cities. The thresholds for a zoning being lower and more restrictive, meaning more things trigger a zoning traffic study during zoning because it's a change in land use compared to a land disturbance permit in this version because it is a by right use.
Okay, thank you.
I think that's left me with more questions. I see Commissioner Richardson's hand up. You can go ahead, Commissioner.
Have we considered in the land disturbance, since land disturbance would come after the rezoning in many cases when we're talking about these studies, have we considered just referencing that section of code instead of listing out development expected to generate more than 3,000 vehicle trips, we just say a tier 2 development as defined in section 134, 121. So that way, when we go into, because there's going to be a lot of debate on what 134, 121 comes out to be, we're not having to update both places with the numbers. The definition just exists as a part of the zoning definition itself.
So they are independent, and Jessica may need to speak to this because when we look at land disturbance permits, we're looking at those developments that are coming in by right that do not require a zoning action. When something has a zoning action, that traffic study is triggered in the zoning action, and then all of the stipulations approved with that zoning action carry through the land disturbance permit.
So I know that they're separate and they're separate processes. I just mean, can we pull out the definition so that the definition of tier 1 and tier 2 exists separately? And then we just reference them appropriately in the code so that it's just, as opposed to, because tier 2 and tier 1, that's what we're going to be debating as a board. One of the things that we'll be debating.
Well, let's see, I hear the word debate and I know we have 2 questions. I think this may be eligible for us to hold, because remember, we wanted to move forward on those things where we didn't have a lot of question and debate. And I also know that this was also referred to by one of our speakers. This would give us time to weigh each other's thoughts, to weigh what Drew is sharing, to have him weigh ours, and to also weigh the public in this. So I would ask with this robust discussion for us to not approve this particular section of Chapter 50. And then that's just keeping with the process that we said that we would have. But I know that there are other parts of Chapter 50 that are before us.
As far as not passing this, going back to what Drew is saying, while these are connected, they are separate because this is strictly for an LDP, which means it's already gone through rezoning. So as far as holding section 50, I don't know if we necessarily need to hold section 50 if this is kind of the threshold that DOT is going to use for, properties that are already zoned, we all have commercial property in our districts that essentially could go in and pull an LDP and start construction tomorrow. So to me, and Drew, correct me if I'm wrong, what this says is if they go in to pull an LDP, then this would trigger DOT to require a traffic study. Because again, some of these sites, these commercial sites that were approved, the traffic studies were done 20 years ago. Drew, am I correct in that assumption here?
You are. So currently there is no requirement for a traffic study on a development that is coming in by right for a land disturbance permit. So this language was inserted. So it's a new requirement. Again, why that higher threshold of 3,000 trips, 250 vehicle trips, just saying that if there is a large development that does not require a zoning action, that it would still trigger a traffic study.
So with that, I would be comfortable looking at supporting section 50.
Okay, 50-76, as we still have other subsections of chapter 50. Commissioner Richardson, I know you had questions. Are your questions fully answered for us to look at supporting this?
Right. I was just referencing Commissioner Gambrell's point of kind of that having inconsistent standards, even though they're two separate processes. That was my point of saying LDPs are pulled after a rezoning is done. It's time to actually do the construction. But if there is no concern about that, I just figured that could be solved by pulling the definitions out separately. But if there's no concern about the consistency, then it doesn't really pertain.
If you have a concern, there's a concern. So don't
We would just go through the process of updating both parts if there is a change in definition.
Okay. Yes, Commissioner Gamble, I see your hand back.
So we have a definition that they added for trips. And Drew, help me, it's in the section 134-206, was it?
It is, and we copied it over also if you're still in section 50-76 under N, the new language for traffic studies. So this is on page 18 of the packet or 34 of the agenda book. You'll see here it's a trip means a single one-way journey between 2 points by a specified travel mode and for a defined purpose. We had to insert it actually into that paragraph because we didn't open up the section that includes definitions for chapter 50.
So again, with the concerns that were expressed, that's covered in here. Commissioner Richardson, the concern is in section 134, where we're now talking tier 1 and 2 tiers. So I think we can take those concerns and move it to that subsection. Or address it under that section.
It's fine.
Okay.
I'm not sure if I'm communicating clearly, but that's
okay.
fine.
Well, with that, I would like to make a motion that we approve section 50-76 of the code amendment being proposed.
I will second, and I have discussion. May I go, Madam Chair?
Sorry. Yes, I'm sorry. I was muted. Yes, Commissioner Burrow, please go ahead.
Okay, we did have some, and this may be in the 134 section, not this, but since they're both related, Drew, we did have some concerns about the 30-day notice for the traffic study. So I know when we go through zoning a lot of times and a traffic study is required, sometimes we don't get it till a week before or not even a week before, and it puts staff in a bind to be able to review it in enough time. But is 30 days adequate? Is it too much? You know, maybe Amy or someone in DOT that reviews these for zoning, and of course you can speak to this, would 2 weeks be adequate? Or, I mean, what's the consensus of the board requirement for this? And keeping DOT's review and summary in mind with enough time to present for zoning.
Drew, you can respond.
Of course. So that is in section 134. You're correct. It does say 30 days. We did hear the request today for the 15 days. That would be agreeable. I think anything less than 15 days would squeeze our time of being able to provide a substantive review. The reason for the 30 days is because oftentimes the review just brings on more questions. A lot of times the review is include information about the impact to intersection X. And so while they've submitted a study, it's an incomplete study. So the 30 days allows for that back and forth. So we defer to the authority of the board. I think we could make 15 days work. It does require a complete study to be done with that. But anything less than 15 days does jeopardize our ability to provide meaningful analysis for the Planning Commission.
Okay, and one other thing to take into consideration is schools. Their vacations and stuff, because you can't do a traffic study if they're not in session. So, depending on the zoning, if it comes in the summer, that they're not going to be able to do a traffic study even in 2 weeks or 30 days. So maybe we add that to the language if the traffic study has to be done during school.
Commissioners, note that prior to this motion being shared, we stated that if there was additional questions, concerns, comments, that we would only be moving forward with those things that are purely administrative. And there are clearly a lot of questions and concerns just among the board. And I know we had some shared among the public with respect to this. I just ask for that to be considered as we have a motion on the table, that this actually is in violation of the process that we said we would have if there were additional questions, comments, and concerns about things that we thought would just be purely administrative without this amount of consideration.
Well, we did say we would discuss among the board and
yes,
consensus.
Correct, but I know I just heard you offer a potential change to the code as well. And
okay. Well, I just want to make sure the staff has enough time to review these if we reduce the time frame.
Madam Chair, may I speak to that really quickly, please?
yes, Director, and then I need to defer to Commissioner Gamble. Her hand has been up.
Yes, ma'am. And I just want to point out that the code does say that the scope of the study will be determined by the Director of Cobb County Department of Transportation and his or her designee. So I think that would give Drew and his team the leeway to specify that it needs to take place while school's in session, and some other parameters around that may ensure that they get the most accurate, best study.
Thank you, Director. Commissioner Gamble?
Okay, and Drew, correct me if I'm wrong, but I don't see a time limit specified for a traffic study to be given in 50-76. In addition, we have a change in section 134, 121, which for your reference is on page 65. For rezoning applications, we've put it instead of should to shall, which means an applicant, when they come in for rezoning, has to submit these documents. In the past, since it said should, ComDev had a problem enforcing it because our language said should. With it now being shall, if we approve it as shall, the traffic study, everything will have to be submitted in the package for when staff starts to reviewing it. So then hopefully, it'll give them time if they have questions, to give the applicant time to redo it. Because Jessica, correct me if I'm wrong, from the time someone submits an application for rezoning till the board hears it is about 90 days, correct?
Our process is currently about 60 days. It used to be 90 days, but at this point it is about 60 days. And the way the code is written, they would still have up until 30 days prior to the Planning Commission to submit their traffic study. And again, this is specific to 134 for rezonings and sloughs. So it wouldn't be expected at the time of application, but the 60-day rezoning, it's a benefit for projects that can move along a little bit more quickly, but as we've seen with the ones that have been continued and held over the years, there are some projects and some rezoning requests that do take a little bit more time, and one that warrants a traffic study may be one of those that perhaps warrants a little bit more time.
And to your first question, Commissioner, there is no timeline for Chapter 50, the traffic study requirements there, because it's not a time-intensive process. It's not required because this is a by right development, there is no zoning action. And so the department would hold off any approval on a land disturbance permit until an adequate traffic study was done. So it puts the onus back on the developer.
Thank you, Drew. And that helps with some clarification. There certainly is some similarity with this subsection and a subsection of 134. And we're doing a lot of contrast and comparison, which I don't think is unreasonable because they're so similar, but because they're similar doesn't necessarily mean they are the same. And so I appreciate the clarifying questions. There is currently a motion and a second. We are still debating on whether or not we will move forward with this code section. Again, understand I'm hearing a lot of discourse with respect to this, and that was shared by the public. So I don't know if there's any additional comments or concerns shared.
I just have a comment, Madam Chair, regarding the.
Yes, I'm sorry, Commissioner, I can't see you on my screen. Go ahead, Commissioner.
Oh, I'm sorry. I just have concern regarding the 30 days. And if we reduce that for under 30 and DOT does not have everything that they need to make, to fully review the document, my concern is what does that happen? What will happen as we move along in the zoning process? Are we going to find that we have to continue to continue cases, carry over cases? So I'd rather the developer take the necessary time that's needed and to make sure that DOT have ample time to not just review it, but to go back, get additional information, et cetera, before it's tried, it's pushed through to us and we may have to continue and continue and continue.
Thank you, Commissioner. Again, just clarifying that we will have opportunity to address that time window when we get to Chapter 134, which addresses zoning. This particular section addresses properties that have already been zoned or zoned by right. And there is not that time window in this code section. But if Director Gwen, if you can help us in making sure that we remember the points that are being made with respect to zoning when we get to Chapter 134.
Yes, ma'am.
Thank you. Okay, again, we have a motion and a second. And I'll just share the observation that I heard from the public today had to do with who shall be able to make the who shall be able to prepare the technical memorandum. And I'm not sure that's going to be made clear if this moves forward today. Again, this is being addressed in another code section where there may be opportunity to address that same point, but that is a point that I heard from one of our speakers today. Is there any additional discussion with respect to Chapter 50-76? All right, with that, we'll go ahead and call, and excuse me, if you can raise your hand if you are in support of adopting Chapter 50-76 as it has been presented. Thank you. I see a show of hands for commissioners. I'm debating my response. I know that was still an outstanding question. I will not support it just because I know we did have a question from the public that I think if we were to just hold this, we would have a better opportunity to weigh. So this motion carries 4-1 with Chairwoman Cupid in opposition. Commissioners, it is now 11:15. We have been meeting for 2 hours and 15 minutes. I'm going to go ahead and call for us to take a 10-minute break and come back at 11:25 so that anybody can do as they need to. When we come back, we will still be in Chapter 50 and we will be addressing noise. February 8th, 2022. Currently, commissioners are going through our code amendments for consideration for our 2022 update. And we left off in chapter 50. And particularly, I believe we're at the noise section, which would be, I may be wrong, there may be some, there still, I think, are additional sections of chapter 50. Jessica, correct me if I'm wrong here. I'm looking through my packet more closely.
The next section should be the noise ordinance, and I'm pulling it up right now. And that, of course, is a section that, so it's 50-256 through 50-258, and staff is asking that we withdraw this one from consideration at this time.
Okay, thank you for clarifying, Jessica. I move that we withdraw 50-256 as was presented by Director Gwen for additional staff consideration. Is there a second?
Second.
Thank you. Is there any additional discussion? All those in favor, please raise your hand. The motion passes 5-0. Thank you.
Chairwoman, there's also, you specifically referenced 256. There's also section 258 as well. There was some changes, so that would be also need to be held.
Okay, thank you. Appreciate that. So I move that we go ahead and
Madam Chair.
Chairwoman.
Jessica said sections 256 to 258.
Yes.
She included 256 through 258.
why don't we go, can our clerk provide some clarification on what you have?
I'm in here with Bill Rolling, and yes, Jessica did say that, but when you made your motion, you only indicated 50-256.
Thank you. So we'll still need another motion then to include section 258. So with that, I move that we remove consideration of chapter 50-258 for additional staff review. Is there a second? I'm sorry. I move, we have to have, I'm sorry, I need a, all right, there's a second. Is there any further discussion? Commissioner Burl, I see you, but I don't hear you.
Sorry. Rather than do them separate, why don't we just do 256 through 258?
We already
all three, 256, 257, and 258.
Thank you. And I'm looking on page 22 to 258. So we approved 256, and now 258's above or before us. Why don't we go ahead and amend the motion to include 257 and 258 since 256 was already voted on? And I'll make and I'll make that amendment in my motion. Is there a second for that?
Second.
Thank you. Is there any further discussion or clarification needed? All right.
We've already taken the vote, though, so we can't amend a motion on a vote that has already been taken.
We have not taken the vote on.
We took the vote on 50-256.
Yes, my motion, again, Commissioner Gambrill, is to cover 257 and 258. We did take a vote on 256 according to our county clerk. We did not vote on 257 and 258. The motion before us right now that is still standing and has not been voted on is for, again, 257 and 258.
There is no section 257. So with that, Bill Rawling.
Commissioner, there is section 257.
Yes, there is.
It's on page 36 of the.
Thank you. And again, I don't want to be combative, but I'm finding that tone and interaction very combative. And it's okay for us to clarify information, but I'm trying to work with you and sharing what I have before you and what has been shared by commissioners just now. And we currently still have a motion that's outstanding for sections 257 on page 236, excuse me, on page 36. And if you turn to page 38 of our packet, we have 258. That's the motion that's before us, and there is a second.
Second.
Thank you. We'll go ahead and call the question for those in support of 257 and 258. Thank you. The motion carries 5-0.
Okay, the next chapter is chapter 50. So on chapter 54, I know that there was some language that was submitted by the fire marshal's office to me, as I indicated, after the agenda was posted on Wednesday. So I'll put that out there for the board to consider. And the fire marshal's office, of course, is also available if there are questions.
Sorry, Jessica, can you restate what you just stated?
Yes, ma'am. In chapter 54, there was some additional code change language that was submitted to my office on Thursday of last week. I believe after the fire marshal's office had some conversation with Commissioner Gambrill. So that is not included in the draft that you have before you, because obviously it was after the agenda deadline, or after the agenda was published. So at this point, the fire marshal's office is online if you all would like to discuss the additional language they'd like to consider, or if you'd like to move forward with this at all.
Okay.
Yeah, I think I could summarize it really quickly. They're very minor.
Okay, and I presume that's our fire marshal. I'm hearing I don't see you before me.
Sure. Well, I'll introduce myself. Nick Daw. I'm the division chief of the fire marshal's office and county fire marshal. Like to say thank you, Chairwoman and the board, for allowing me to speak today. I'm not going to get into too much of what we've already covered in the past hearings, but there was 3 minor adjustments. In one section was regarding the pre-construction meetings. We got some feedback from constituents, the Builders of Quality Growth, and we wrote in an exception for the a waiver if the person has experience. We also addressed section 54.2. There was some clarity needed. We had a term of 1,000 being used. So we wanted to clarify that, it's 1,000 at one time is how we're going to count the crowds. And for clarity, there are things that could be related to fees. And we committed to not having any fees that don't go to the board in accordance with 54.62. And then the last detail I had was regarding some of the stuff that's coming in under the new appeals board to the Cobb County Fire Marshal's office. My recommendation was to charge $500 for that, the appeal fee. And if the appeal is approved, the applicant pays nothing and they would be refunded. And that was a suggestion, and I'm happy to take any further questions.
Thank you. These changes are not insignificant, particularly that last one, in light of the number of businesses that do come to the county with questions or concerns with respect to interaction with the fire marshal's office. I am in support of many aspects of this code, but it's just hard to process all of that right now, knowing that you just are sharing some of those changes with us today from Thursday.
So in one point, to be clear, there is no prescriptive language change. That was going to be a fee that would have to be approved by the board.
Okay.
I was just recommending that if someone does appeal and there is no fee related to it, it would be a lot of appeals. But again, like I said, that's a recommendation. There's no language regarding any of the fee in the proposed change that was written by county legal. It would be a fee, and all fees in accordance with 54.62 would need to come back outside of this process and come to the board for approval. So as currently written, there is no fees.
Yeah. I'll just share again, part of my concern I had with the appeals board had to do with notice of process and procedure for due process. And I know even in reading the code, if we were to prove it as today, it states that anything outside of the fee that you just shared would be a consideration of the appeals board and doesn't necessarily need to come back and be part of the code. And I know I still have some outstanding concerns with respect to that.
Sure. And like I said in my correspondence, I'm happy to defer to county legal.
Yeah.
There's state adopted laws. So, as written, OCGA Title 25 adopts the International Fire Code. What we referenced is the most current edition of the International Fire Code. And it doesn't exactly match the appeal process of the Cobb County Building Department.
I
So
see.
what we tried to do is, and keep in mind, this is an appeal process for the fire marshal. So a lot of this was drafted by county legal. And there are some, nuances regarding new construction and things like that. So a lot of it I wanted to defer to county legal on, but it's as prescriptive as possible. It's the least amount of change we could do to make it kind of line up and match the way the building department did it. And as currently written, there is no fees. And if there was fees to come in, you would have to vote on it at a later date.
Okay. And I presume then the code section that you read of the state, that doesn't incorporate fees into that language?
No fees.
Okay.
The fees, if any, just like the section will talk about when you put together an appeals board, if there's any compensation, that again would be a decision by the board if you wanted to compensate the people that are on the appeals board. It just gives you the ability to do it.
Okay, thank you. Commissioners, do you have any questions or comments regarding this entire code section? As being shared, a lot of this is administrative coming from our fire department. I see, yes, Commissioner Gamble, go ahead, please.
I would be comfortable putting forth this section, chapter 54, less section 54-54.2, as that is where the language was changed, just to allow people to review the proposed change, Nick, in all fairness, for public comment. But I would be comfortable putting the rest of the section of chapter 54 forward for a vote.
Thank you, Commissioner Gamble. And for our Fire Marshal, Nick, can you share, are there any other sections of Chapter 54 that have been changed prior to or following our last meeting?
Those three things, and I feel like they were just administrative. 54-54.2C, I believe, talked about the outdoor social gatherings of 1,000 persons.
Okay.
The only clerical detail was that 1,000 persons at one time. That was the intention of it.
Okay.
When you're writing these sections, sometimes you're not as focused on the details that everybody else is, but it was intended to be 1,000 persons at one time. And then, of course, any and all fees of anything related to, permitting of a special event would have to come back to the board the way it has in the past under Section 5462. But the intention of this section was to clarify that there's so many different special event permit triggers out there. The intention of it was to make it a little bit easier to understand, as you have, probate court services that apply to this. You have state laws, you have the life safety code, the International Fire Code, then you have the parade ordinance. This was intended to make things easier on everyone.
Thank you. And that's the only again, were all the three changes you were referring to in that portion of code, or were there other sections?
So to be very technical with what you're saying, there's only two changes. One was to say 1,000 persons at one time.
Mm-hmm.
With that change was accompanying that any fees would have to come back to the board. That's one change.
Okay.
The other is the feedback. I received a letter from the Builders of Quality Growth. They had some concerns about the required pre-construction meetings, and I added language prescriptively to say applicants with demonstrated experience and understanding of the fire marshal inspection process can be waived. And that was just something we never considered. Those two things are the only changes from the last meeting. And fee was really just a recommendation. But then again, even if I recommended it, I don't believe it could be approved today because it's not new language. I would just want the authority to come back at a different meeting.
Okay, thank you. Appreciate you clarifying that. So we have Commissioner Gambrell, who's supportive of us moving forward, Chapter 54, with giving the public and commissioners more time to weigh 54-54.2. And then note again, our fire marshal reference to 54-84, which was also shared during public comment by representatives that we had from the Builders Association. Commissioners, do you have any questions or comments regarding this code?
Madam Chair, I do have a question, and I don't know if Bill can answer this or if it's for Jessica, but with respect to the pre-construction meeting waiver, the reference is made that experienced applicants would not be required to would have the option to waive. And I just want to know what defines an experienced applicant? What would be the litmus test for that?
Well, the intention, if I may, the intention of the pre-construction meeting is to teach people how we do it in Cobb County. If there's complicated projects like we've all seen down near the TK Tower, or people that have very little experience, we want them to call for a pre-construction meeting. My staff in the fire marshal's office will go to the job site and explain how things need to, I guess, be called in the process. Because not all projects require contractors, there's not really a good threshold. Small business owners that just move in, you have the right to do that, but our experience has showed us that sometimes they could make mistakes. Like we said, we just wanted to denote on the approval, if the fire marshal's office feels that the person doesn't have like an understanding of our process, we want them to call us. We don't want them to call us after the construction has been done, because then we have to talk about deconstruction. And our preference would be to get in front of people as soon as possible. But obviously, the position of the Builders of Quality Growth is that they do this a lot. They have a lot of experience, and they are not the people we're trying to get to understand what Cobb County's process is. They're very knowledgeable about that process already.
Okay. Thanks, Nick.
Sure.
I'm muted. Are there any other questions or comments, Commissioner Burrow?
Yes, will you restate your motion?
I didn't restate a motion. I was just reiterating Commissioner Gambrell's desire to see us move this forward, for us to move it forward and allow the commissioners and the public more time to weigh changes to 54-54.2, as was just recently shared.
Chairwoman, this is Bill Rowland. Can I ask a question to Nick?
Sure.
Sorry.
Are you ready to, if this passes now, are you ready to move forward with this, or do you need an effective date off in the future?
I mean, I would defer to you. I mean, we would be ready to go with any of these proposals as soon as they're approved. If it's better, I guess, technical code language to add a date, we'd be happy to suggest one.
In order to give the public the right to know when they're making applications and doing things like that, an appeal board to be set up as well. So,
and one point of clarity too, there already is an appeals board process. It's in our ordinance. This is replacing it with a newer one that matches more of what the building department's doing. So our belief is, and I believe county legal's belief is, that there's a current appeals process for new construction through the state fire marshal's office. And then as we've adopted the International Fire Code, there is another redundant appeals process, but we've not had a very, I guess, it's not our own. It's kind of just copying what's in the prescriptive standards. So this is county legal's attempt to try to make it match what everybody seemed to like, which was the Cobb County Building Department's construction appeal process.
and the BOC would have to make appointments to that board, right?
Yes.
So they would need time to be able to do that as well. So
Correct.
probably like a 6-month delay in effectiveness would probably something like that would work.
That would work very well for us.
I would just encourage, if there is a motion to pass it, Chairman, I would just suggest you could do an effective date. It'd be 6 months from today.
Okay, is that your suggestion, Bill, 6 months?
Yes.
Okay. Commissioners, are you amenable to us modifying the subsection pertaining to the appeals board, which I'm turning right now? It will be 54-119, and us adding language for this code to become effective within 6 months of our passage of this code amendment?
Well, this would be all of those sections that are before you in Article 3, except for 54.2.
Okay, bear with me. I thought you were just solely referring to the appeals board. So all of Article 3, you perceive notice is needed to the public. Okay. Bill, where would this be added? Is this just general language that doesn't need to be incorporated in the code amendment? And we'll just say this code becomes effective 6 months after its adoption?
We could just say July 1st, 2022, or something like that. Effective
okay.
July 1st, 2022, in front of everything we've proposed.
Okay, and I've seen that language incorporated.
We have to incorporate it, right?
Yeah, yep. Effective. Article 3 effective July 1st, 2022.
We need 6 months to be, I want to say August 1st.
It will be August, okay. Effective August 1st, 2022. Okay, are there any other comments or questions from commissioners with respect to either that change or any other part of this article? All right, so Commissioner Gamble, would you like to make a motion that moves that forward in light of the observation you made regarding 54-54.2?
I'd like to make a motion to approve Chapter 54, less Section 54-54.2 for approval with an effective date noted in the clerk's note as 6 months.
Second.
All right, is there any additional discussion?
Yes, Madam Chair. I
Yes.
believe Commissioner quoted 54-54-1. Is that correct, Commissioner Gambrell?
No, it's 54-54.2.
Okay, I think I thought I heard 54-54. I just wanted clarification, that's all.
Correct.
Yes, it's 54-54.2. So that way the clerk has that noted as well. Thank you.
That's what's listed here in the package.
Okay.
If on page 23 of the package or on page 39 of our agenda book.
Okay, got it.
Okay, great.
I'm sorry, I was looking at the screen. It had something different. My apologies.
No problem. Commissioner Burrow?
Yes, and do you want to say 6 months or August 1st?
It was suggested by our fire marshal to put a date. And so.
Illegal.
Yeah.
I'm
Yeah.
willing to amend my motion to reflect August 1st of 2022 instead of 6 months.
Second.
Thank you. Is there any additional discussion? All right, those in favor of adopting this code amendment as presented, please raise your hand. Okay, the amendment passes 5-0.
Thank you, everybody.
Thank you and appreciate it, Nick. This will help us a long way in addressing some of the gaps we've had
Sure.
with our businesses. Okay.
The next chapter for amendment is chapter 78. And as you'll recall, we had 3 real parts of this amendment. So the first is chapter 78-1, and these of course are administrative items for the business license division. And then the second being the sections pertaining to health spas. And then finally 78-407, which is short-term rental. So based on the discussion, it seems like there was no comment or question from the public about 78-1 or the items pertaining to health spas. And then of course, section 407 was one where it seemed like there may be some discussion desired. So
I agree. Why don't we adopt these separately just so we can go ahead and quickly get through 78-1 through 78/301 or 302. Are there any questions or concerns with us moving forward, commissioners, with respect to all the subsections leading up to subsection 302? Okay, I'm seeing people shaking their heads. So why don't we go ahead? I'll move that we adopt code amendment changes to chapter 78-1 through 302 as has been presented by staff.
Second.
All right, are there any comments or questions? All those in favor, please raise your hand. All right, the motion passes 5-0, and that will take us to short-term rentals. There are a lot of questions, a lot of debate on this section. Again, in keeping with our motion, before we walk through these one by one, it would seem helpful for us to go ahead and hold consideration of this today. Is that the consensus of the board? I'm seeing one person nodding. Commissioner Burrow, please go ahead.
Thank you. As you know, we have been discussing this for a couple of years. And originally we were waiting to see what the state adopted in the legislative session, I think in 2019. Jessica, correct me if I'm wrong. And we did have different HOAs, civic associations weigh in at our public hearings on this. Most of them had concerns that still wanted, I guess, stricter code to be adopted. 2 in my district were in favor of this. So I guess we do need to do something on this because it is a problem in all the districts, and it has been for quite some time. But I want to get it right and make sure that it's something that we can enforce and that we can regulate with notification to the short-term rental owners to give them time to, produce all the necessary documents that are required and contact information. So I think it's the majority of what we heard today from the public is to hold it for further review and comments from the public. So although there are 2 in my district that are HOAs that are ready to move forward, I'm just a little hesitant because we did hear from ECCA, Mableton Improvement Coalition, that want further review. So I think I would be agreeable to holding it for further review, but I do think we need to put an ordinance in place because we've been operating for over 2 years with complaints and not being able to enforce anything. So thank you, Madam Chair.
Thank you, Commissioner Burrow. Are there any other comments or questions? I'm certainly in support of what you shared, Commissioner. This would be our second time as a board considering this and not making a decision on it. And so there certainly is a lot of interest and need that continues to go unmet without having a code in place. But I agree with you, Commissioner, and the sentiment has been shared by members of the public that there's opportunity for us to have a more clear and to also have a stronger code. So with that, I'll make a motion that we hold consideration of 78-407. Is there a second?
Second.
Is there any additional discussion? All right, all those in favor, please raise your hand. That motion passes 5-0. Thank you, Commissioners. We're on to Chapter 90.
Yes, and Chapter 90, as we indicated before, there was no change to this one, no public comment. I know some of the commissioners had thoughts on that.
Okay. Commissioners, do any of you have any thoughts or questions with respect to Chapter 90? I see Commissioner Burrow and Richardson. I'm sorry, I don't know who was first. You'll have either one of you, please feel free to go forward. I apologize.
You can go first, Commissioner Burrow.
Okay. Again, the concern here is, and it has been expressed outside, publicly, from others, of enforcement and how this will be enforced. The rangers, police, are they going to be patrolling? And then also the exception of golf courses, I'm assuming that they are exempt because you just have a group of 4 at a time going through the course. I'm guessing, unless there's tournaments or something, there could be more. But my suggestion was to maybe designate an area for smoking away from bleachers and away from ball fields where the public isn't gathered. I'm not a smoker, and I, would be fine banning this, but people do have rights that they want to smoke, and if they're outside, it's less invasive than if they were in a building, which isn't allowed anyway. But I'd like to see a designated area in the park away from the crowds or ball fields or where people gather.
Okay. Thank you, Commissioner Burrow. I saw some heads nodding. Commissioner Richardson.
Yeah, thank you. Certainly echoing those sentiments. And part of what was proposed was, could there be designated areas instead that might ease the enforcement? But I think there are 3 areas that we're trying to be tackled here. Smoking around kids. And that's kind of the concern, but coming up with language to say, you know, where people gather, well, they can gather just about anywhere on a park premise. So I understand the difficulty there. But designated areas may allow us to achieve that balance. Secondly, litter. Designated areas might allow us to achieve that as well. And then fire hazards. Designated areas might help us achieve that as well. So my recommendation echoes Commissioner Burrell's, and I think it can at least attempt to curb the 3 primary concerns.
Are there any other commissioners who would like to weigh in?
My only weigh in is, you know, again, it's the same as the 2 commissioners that spoke before me. I don't have an issue with the smoking at the golf course, but I would like to see a restriction there if there are tournaments. Obviously, there will be more people in attendance. But other than that, I'm okay with the way it's currently presented with those exceptions.
Okay. Commissioner Gambrell?
I am fine with the way this section has been presented and is in alignment with other parks contained within Cobb County within our city boundaries.
Okay. When you shared as presented by staff or in consideration of the commissioner's feedback?
As presented by staff.
Okay. So we have one that's leaning towards keeping it as it is. I'm hearing some considerations by Sheffield, Richardson, and Burrell for us to create some designated areas for our parks generally and for our golf areas when there are tournaments. I'm in support of all of those recommendations. However, I know that this is new and there are some members of the public who weighed in. Are you amenable to us holding this so we can get all of our thoughts together and also share this with the public?
Yes, ma'am. If I could, real quick.
Yes, Director.
Commissioner Burrell, if you want to go first, but I just want to give you a rundown of how we got to this part first.
Okay, let Commissioner Burrell weigh in first and then, yeah, thank you.
I was just going to say, before he chimed in, I want to hear from staff. I want to ask Michael what his.
Okay.
So I looked at a lot of the different cities, like I said, inside of Cobb. Marietta was one that actually has a golf course, and they did not restrict smoking at the golf course. So I sort of looked at that one. The other one I looked at was, I know that Atlanta has several golf courses, but Atlanta, they do not lease them out like we do. When I say lease them out, they do not have a management company. It doesn't look like that actually runs the golf courses. I could be wrong about that. But one of the things that they did was that any of the properties that they actually lease, such as Chastain, Lakewood, places like that, they also exempted it. So I was just looking at things like that is why I sort of came to that conclusion. How I came to the conclusion of just the banning of the smoking in parks. We looked at it a bunch of different ways. Yes, you can come up with designated areas. We had originally talked about the possibility of just doing it in parking lots, because that would, maybe be closer to people's car or something like that. But one of the things that we learned is when we went to all of our volunteer youth associations about 1.5 years or 2 years ago, starting to look at this. And almost every one of our volunteer youth associations, while the parks in general do not have a smoking policy, the volunteer organizations have one for any of their kids, parents, guardians, whatever, that play in their league. So they already have something policy-wise that says no smoking. So we looked at a lot of different things, and we can go any direction that the board sees fit. I think this was just one of our ways to just sort of start to get the conversation moving. So this absolutely can be looked at a little bit further down the road. Very similar to what you just did with the fire. I think the same thing would need to happen with the whatever we do here. We would need to push it out months. So we could start, engaging the public and letting them know what's going on, and then also getting our signage up, because we just don't want it to be there. From an enforcement standpoint, of course, we always look at anything with that. Unfortunately, it is what it is. The enforcement is usually by our rangers. Police do get involved, the regular police units, when they have to, but rangers are usually involved in something like this. We have asked staff not to do any type of enforcement of any code ordinances because that just usually turns into something that doesn't look good in the park. So we've looked at all of that, and yes, the enforcement's always going to be an issue, but it's an issue whether it be smoking, whether it be camping, whether it be selling commercial activities. So there's a lot of things that went into that. So that was just sort of where the staff was, and that's where we're at. But we're happy to come back with something else.
Thank you, Michael. I again value the discussion by all the commissioners. I value you letting us know how you got to this point. I think we can probably reach a good consensus in weighing the suggestions that were shared here today with this a little bit more time. So commissioners, I would ask for us to hold this again, and Michael, for you to help us in considering the comments that were shared here today.
Absolutely. I'll start looking at several variations of this with some of the comments.
Wonderful, thank you. So with that, commissioners, I move that we hold consideration of Chapter 90. Is there a second?
Second.
Is there any additional discussion? All those in favor, please raise your hand. Okay. And all those opposed, please raise your hand. Thank you. That motion carries 4-1 with Commissioner Gamble in opposition. Commissioners, I want to be mindful of time. It is now 12:06. We are in Chapter 106. The last time I tried to push something through lunch, it was during a zoning meeting. And if you can remember that day, it did not go very well, the deeper that we got into the lunch period. Also know the priority of this day is our BOC meeting, even though we have a work session that's scheduled at 1:30. In light of all of those things, I would like to hear from each of you if you want to power through the consideration for the rest of this code amendment package. You want us to just go through Chapter 106 or go to a certain time, please let us know. It's my suggestion that we do not go past 12:30 without taking a lunch break. Again, in light of what has happened in the past, that I think we're all at our best when none of us are hanging around hangry. And so again, just wanted to hear from some of you what your thoughts are with how we handle lunch. Commissioner Richardson, now you are at the top of my screen. What are your thoughts?
I'm fine with breaking for lunch.
At 12:30? Is 12:30 okay, or do you want to break now?
It is fine.
12:30 is fine. Commissioner Sheffield?
12:30 is fine.
Okay,
12:30 is fine.
Burrow? You're okay with that, Gambrel? Yes, okay, everyone's nodding. All right, so we'll go ahead and power through Chapter 106 and maybe the.
Madam Chair, may I just ask one thing? If we are in the middle of a section that we're reviewing at 12:30, can we just conclude that section before we break?
Yes, and I'm glad you said section and not chapter because we're going to spend a lot of time on 134. So yes, ma'am. All right, so we'll go ahead and power through 106.
Yes, thank you. 106, again, we didn't have, well, so 106-91, there was no real discussion or question about that, it seemed. Then 106-98 and 98.1, staff is requesting to withdraw those amendments for further consideration.
I'm sorry, Jessica, can you clarify? You're trying to pull just a portion of Chapter 106 or all of Chapter 106?
Yes, that's correct. So 106-98 and 106-98.1, that's the section that staff would request to withdraw. 91 and also 136 all seem to be pretty clear of questions. So
Okay, 91 and 96. Okay,
90,
go ahead.
yes, it's 91 and 136 are the ones that we would ask to move
136.
forward today.
You're asking to move forward. Okay, and what about, I have 106-96. It's on page 41 or 57 of 370.
I'm pulling it up, and Drew may be able to speak to that more quickly than I can pull it up.
Okay.
I'm sorry, Chairwoman, did you have a particular question about that section?
Yes, Jessica shared 4 sections, 2 of which staff is asking to withdraw, 106-98 and -98.1. She said we are ready to move forward with 91 and 136, but I'm also seeing section 106-96, which hasn't been clarified if that should continue to move forward or.
Staff is prepared for that to move forward if the board agrees.
Okay, thank you.
Chair, I think what's happening here, and Jessica, you can verify me. If you look at the revised code amendment package, it only has 106-91, 106-96. But in our original draft that we had, it had those two sections plus 106-98 and then 106-98.1. So it appears to me that staff removed those when they published the second revision.
So what I'm going to do, thank you for clarifying that, Commissioner. What I will do is ask that we move forward with Chapter 106 and not include 106-98 and 106-98.1. And I'm seeing nods from you, Drew, and from the rest of the commissioners. So, yeah. So I'll make a formal motion of that, commissioners. I move that we approve Chapter 106 and to allow staff to withdraw 106-98 and 106-98.1.
Second.
All right. Is there any further discussion? All right, we'll call, excuse me. All those in support, please raise your hand. All right, that motion passes 5-0. Thank you, commissioners.
Okay, the next chapter is Chapter 110. Again, there were no changes to 110 from public hearing number 1. And again, administrative type changes here. If there are any questions.
Commissioners, do you have any questions in Chapter 110 regarding subdivisions? All right, so I move that we approve Chapter 110 as proposed. Is there a second?
Second.
Is there any additional discussion? All right, all of those in favor, please raise your hand. The motion passes 5-0.
Okay, and Chapter 118, again, this is another one where we had no additional changes from the first public hearing.
Commissioners, do you have any comments or questions or concerns with respect to Chapter 118? All right, I move that we adopt the code amendments for Chapter 118. Is there a second?
Second.
All right, any additional discussion? All of those in favor, please raise your hand. The motion passes 5-0. Thank you. Okay, we're moving on to Chapter 134.
Yes, ma'am. The first is 134-1 definitions with the changes that have been made since the first public hearing, being the incorporation of those 4 definitions pertaining to travel mode, trip generation, and trip generation rate.
Okay, and this is where we had a lot of discussion when it came to chapter 50, I believe.
Yes, it was this section includes those definitions, and then 134-121 is the one that's specific to the traffic studies. Yes, ma'am.
Okay, so yes, this one did provide those clarifying definitions. Why don't we go ahead and just take this subsection on its own? Do any commissioners have any questions or concerns or comments with respect to 134-1? All right, see, okay, yes, Commissioner Gamble.
I do believe we had several speakers speak to this, I know the first time. And I don't recall anybody that spoke specifically to the definition. So I'm just asking my fellow board members if you remembered anybody asking about definitions. I don't remember anybody asking about the definition of the trips.
I don't recall any commissioners.
Okay.
Do you have any, do any other commissioners recall if they've received any emails or concerns with respect to this?
I have not, Madam Chair.
Okay.
Okay, I see Commissioner
Definitions.
Richardson shaking her head. Commissioner Burrow, I'm sorry, I just lost you in my screen. Did you have any feedback?
No, ma'am.
Okay, go ahead, Commissioner Gamble. Were you
Like
gonna
I
make?
said, I wasn't recalling anyone specifically at this hearing bringing up the definition of trips, but this is where I rely on the board to help double check in case I missed something. But if somebody had raised it, I was going to suggest we hold it. But since nobody raised that issue, I support go ahead and then passing this.
Okay. Again, I don't remember this being the issue as much as the other section where we started talking about the numbers of trips. So I'll make a motion that we adopt section 134-1. Is there a second?
Second.
Is there any additional discussion? All those in favor, please raise your hand. The motion passes 5-0. Thank you, commissioners.
Okay, the next is 134-7.
Okay.
Poultry.
Yes. I have heard commentary, but I don't think I've heard grave concern with respect to poultry. But Commissioner Broll, this tends to be your land of interest, so I'm going to defer to you to see if you have any comments or concerns.
Yeah, Jessica, this is just taking it out of the code because it's not required anymore.
Yes, ma'am, that's correct. It's something that we missed in the cleanup.
It's just they have to apply at community development and they're allowed, one per 5,000 square feet. I mean, they're requirements, but it doesn't go through zoning. So this is just taking it out of the zoning code, correct?
That's correct. Yes, ma'am, because 290 already addresses those now.
Right. And the 2 acres is just that's in another section, but that's just to clarify 2 acres as opposed to 80,000 square feet, because 2 acres is more than 80,000 square feet. Correct?
Yes, ma'am.
Okay. So, I'm agreeable with 134-7 being approved.
Okay, or us taking it. All right. Are there any other questions? All right, with that, I move that we adopt the amendment to section 134-7, which will be removal of the definition of poultry. Is there a second?
Second.
All right, is there any additional discussion? All those in favor, please raise your hand. Thank you, commissioners. The motion passes 5-0.
And this is the one where we had a lot of discussion, 134-121. And I wanted to address one point that the speaker made this morning and share. His questions were similar to some of the ones that you had about who determines trips and what have you. And just to clarify that the Institute of Transportation Engineers provides several formulas that are used for determining trip generation, and it's based on the type of project. So for instance, a 200,000 square foot warehouse is going to generate a different number of trips than a 200,000 square foot grocery store. So it looks at what is the use and then the size, and provides for each of those uses a calculation, a formula to estimate the average number of trips per day that can be expected. And that's what will be used to determine the number of trips, the use, the size of it, plug it into the formula, and then that'll be where the determination is made whether or not it constitutes requesting or requiring a traffic study.
Thank you, Director. Commissioners, do you have any additional comments, questions, or concerns? Again, we had a lot of discussion around this. In light of that, this section could be worth us pulling and looking at, at greater length. I know my question has been answered. I'm sorry, Commissioner Richardson. Now you move to the bottom. Yes, go ahead. I just saw your hand.
You. No, I mean, there's certainly a lot of concerns with this particular one from a public's perspective. And, maybe we have it all in here, but certainly questions around the thresholds themselves and revisiting if those thresholds are what makes sense for rezoning applications. And then I think that there is something to be said about defining, really just making sure that we're indicating the standards that we're expecting, just to ease the burden on DOT when they actually receive these traffic studies. Perhaps if there's some type of standardization, the reviews can be more efficient, but I'm leaning on staff to tell me if that even makes any sense. But also other considerations even beyond trips, such as the schools, timing and volume. I know traffic studies consider that, but making sure that that's also a part of how we read in this this requirement for applications. So what we want to prevent, or what I'm really hoping to prevent, is a developer coming in and stating or claiming a number where there isn't a PE signed off on the study, and they're using it to basically, we know we'll eventually catch it, but that's more work on us and more work on the community. So how we can set that up front to prevent that from happening downstream.
Okay. Commissioners, are you amenable to us holding this section for us to be able to get some of those concerns and issues addressed? And thank you. I'm seeing a nod from Sheffield. I'm supportive of that in light of our desire, again, to move forward things that were primarily administrative. So with that, I'll make a motion that we hold consideration of section 134-121.
Second.
All right. Is there any additional discussion? All those in favor, please raise your hand. The motion passes. The motion passes. Thank you, commissioners. With that, go ahead, Jessica.
134-127, administrative, dealing with appeal of rezoning decisions.
Okay. Were there any questions or concerns from commissioners? I don't recall seeing any with respect to this subsection. Okay, with that, I move that we adopt 134, that we adopt the amendment to section 134-127.
Second.
All right, is there any additional discussion? All those in favor, please raise your hand. All right, thank you, commissioners.
Great. right, the next is 134-162 to allow for acceptance of applications for RA6 zoning district.
All right, I move that we adopt 134-162 as presented.
Second, and then
Discussion.
Yes, is there additional discussion? Go ahead. I'm sorry I didn't ask for that initially. Thank you, Commissioner Richardson. I'm hearing you, though not seeing you.
Go ahead.
All right. So I did want to know, is it true for the RE5 and RE4 categories that has to come as request by Commissioner?
No, we do accept applications for both of those categories.
Yeah, that is what I wanted clarified as well, because at one time we could only delete 2 RA4 and RA5 and RA6, but all those have been added back in as applications now, correct?
Yes, ma'am, that's correct. And since that comment was made, I also went back and just one more time confirmed in Unicode that that is accurate, and it is, yes.
Okay. Thank you.
Thank you. I saw Commissioner Gamble's hand up. Commissioner Gamble, would
And
you like
it
to?
sounds like Jessica already did. I was going back to read the code real quick to see if it anywhere in the code that it alluded that the district commissioner had to do that, and I was not seeing it in the purpose and intent.
Okay. Very good. Are there any other comments or questions? With that, I move that we, again, I think we still have the motion. I'm sorry, we had a second. Is there any additional discussion, commissioners? All right. Those in support of the amendments, please raise your hand. All right, the motion passes 5-0.
Okay, the next one is 134-221.2, the removing the ROD from the code, and this was a commissioner-sponsored amendment.
I'm sorry, help me understand, Jessica, did we not have, and this could be the difference that Commissioner Gamble noted from what's in our published agenda book and what was published moving forward for our code section, but do we not have 134-203?
Oh, how did I miss? Oh, I'm sorry. I just skipped over it.
Okay.
I apologize for that.
Thank you. Appreciate it. All right. So can you talk us through?
I'm going to save you, Jessica. Since there was still comment made today in regards to this code section, I'd like to make a motion to pull section 134-203.2 for additional review.
Thank you, Commissioner Gamble. Is there a second? I'll second for purposes of discussion because I see Commissioner Burrell's hand raised. Go ahead, Commissioner Burrell.
Okay, actually, for a 10-acre minimum and 4 units per acre maximum, for RSL on a collector road is already code. That was done 2, maybe 3 years ago. Because I was one of the sponsors for that, or was the sponsor for that. And I think this is just putting it throughout the code to clarify that, because it wasn't in this section, but it was adopted. So to me, this is administrative. It's already code.
Thank you for clarifying that, Commissioner Burrell. I see you nodding your head, Jessica. Can you speak to that, please?
Yes, that's absolutely correct. So in 134-203.2, section or subsection 1, purpose and intent, does include in there the language that a non-supportive RSL may only be located on a collector road if the following criteria is met: a minimum of 10 acres, a maximum density of 4 units per acre. So that's in there. However, then when you scroll down further in that section, when it speaks to use limitations, item N says any RSL non-supportive residential units project must be located along arterial roadway, as defined by Cobb County Major Thoroughfare Plan, as may be amended from time to time. So what we're proposing to do here is just to also incorporate the language from the purpose of intent that says unless it's more than 10 acre or a minimum of 10 acres and maximum density of 4 units per acre, then it can be on a collector road.
Thank you for clarifying, Jessica. Commissioner Gamble, I know you have a motion that is outstanding for us to hold this, but based on this being more of a clerical cleanup, are you willing to provide a substitute motion?
Well, but going back to the rules that we set forward, we stated that if any public speakers raise questions about code sections, that we would be pulling them for further discussion and review, hence my motion.
Okay. Thank you. So her motion still stands, and I know that there have been some comments made by the public that have been clarified during this session, and we still moved forward with code. And I know I did not oppose one of them because we had a public comment made with respect to it, and we still had all the commissioners still move forward with that. So certainly you're entitled to that, but since again, we had clarification, it is still up to the commissioners how you want to proceed with this motion. But again, understand Commissioner Gamble's motion is remaining as is. We had a motion and a second. Is there any additional discussion with respect to this matter? All right, all of those in favor of the motion as presented, please raise your hand. Is there anyone in opposition to the motion as presented? Please raise your hand. The motion is denied 4-1 with Commissioner Gamble in support of that motion. Will somebody make a motion for Commissioner Burrow?
Yes, I would like to make a motion that we move forward with section 134-203.2.
Thank you. Is there a second?
I'm sorry.
I'm sorry, I didn't realize you were continuing your motion. There's a motion. Is there a second?
Second.
Is there any additional discussion? All those in favor of the motion as presented, please raise your hand. All those in opposition, please raise your hand. Thank you. The motion carries 4-1 with Commissioner Gamble in opposition. Commissioners, this brings us to 12:32, where we said at the time that we would break for lunch. We are almost through this packet, so I am hopeful that we will get through this today. I do need to know how much time you would like for lunch. I'm suggesting at least 45 minutes. If any of you would like an hour, please let me know and we can break until 1:33.
Can I suggest 30 minutes?
Okay, somebody wants to be a short timer today. All right.
I mean, we've got work session, then this will go, and we haven't gotten to our regular agenda.
You are absolutely right. And remember, we have speakers that have signed up for public comment. Just also know that we've had speakers that share that they didn't see public discourse with respect to our amendments. And we wanted to move some of these things forward so we wouldn't spend this much time plus much more time later on. So I think we just kind of got to power through this, which means that, yes, our work session will be delayed. But I do appreciate the 30-minute suggestion in light of that. Are there any other commissioners in support of us meeting for 30 minutes or breaking for 30 minutes for lunch? Can you just give me a show of hands? I see Commissioner Gamble. All right, guys. So the 30 minutes have it. We'll go ahead. We'll break. It's 12:34. I'm going to be a little bit generous. Let's come back, commissioners, at 1:10 for the latter part of our meeting.
Chairwoman Cupid, this is Dr. McMorris. How are you?
Hi, Dr. McMorris.
out of respect for those directors who are going to be presenting their budget, would it be helpful to just give them an approximate time? Because we know we have the full agenda. So would you say somewhere around 3? Or
I can't. I wish I could, but I can't. The way things are going, I did not know that we would go this long for today. And, you know, if we do that, we would have to cut, and we get to 3, we'll be cutting off the consideration of other agenda items. And again, public speakers who sign.
We're not asking to cut off the public speakers. I was just going to tell them to jump back on. They could jump back around and to kind of watch.
Jump back on at 3. Oh, I'm sorry. I thought you meant that this would end at 3. I apologize, Dr. McMorris.
We have Adolphus and the clerk of Superior Court and the water department. So, you know, we're assuming, yeah, this takes, but at least they could jump off and then just kind of check back, and we can text them along the way.
Yes, commissioners, and remember Adolphus, who waited the last time that we were going through this, and I hope that he's going to be first on our queue today, Dr. McMorris.
Yes, ma'am.
Yes, yep. I think 3 would be a fair time. And again, I apologize for not understanding what your initial request is, commissioners. I'm not trying to rush this process, but it's been made clear to us that we certainly have other business matters to address today with staff and others in the balance. All right, so we'll go ahead and we'll break until 1:10. I'll look forward to seeing you back then. Hello, everyone, and welcome back to our Board of Commissioners meeting this February 8th, 2022. We are resuming. We are resuming consideration of our code amendments, and we left off in Chapter 134. Director Gwinnett, if you can help refresh my memory and what section we are on.
Yes, let me pull it up. We are on, pull this back up. We are now on 134-221.
Thank you. That's ROD.
It should be 121, Jessica.
Sorry, 221. 134-221. We've already done 121. Correct?
Give me one moment. I am still turning pages in my packet. Yes, we did 121 already. And I believe that, 221 has to do with striking out the ROD. So whenever you're ready, Jessica, you can help us walk through it.
Okay, again, this is a commissioner-sponsored amendment to remove the ROD section from the code, and we didn't have any public comment on it today. Planning Commission recommended approval, and happy to hear what the board has to say on this one.
Okay, we can hear from those that proposed it. I sent an email to Jessica before, and really my desire would have been for all of 134 to come back when we look at all of our zoning code, as opposed to doing it in this fashion. I know there have been some interest with respect to the ROD. I have not seen any emails that have countered us striking this out, but I certainly will turn things over to the sponsor of this amendment.
Thank you, Madam Chair.
Yeah.
Just some history. This code, ROD code, was implemented or adopted back in 2006. And up until 2020, we had no applications for this. When it came before us, we just didn't want to remove it from the code because that zoning case was still pending. And now that case has been resolved and approved through the zoning process. So we're requesting again that the ROD code be removed, and it can be adjusted or brought back when we revamp the zoning ordinances in the future, if that's the will of the people and the commissioners. But I think it's just cleaner to remove it now, and it needs some work if it's going to come back. So the only thing that I guess Planning Commission recommended and that I would recommend is, and Jessica, you and I guess legal can speak to this, to clarify that the existing case that is zoned per the ROD, that it would still apply to the existing case that's on the books, that's been approved through zoning. I mean, their zoning steps and conditions, would outweigh any variances or whatever was granted, but the code would still apply to the one case that has been approved.
Yes, ma'am, that's correct.
So I would just make that note. So my motion would be to well, do you want other discussion?
No, ma'am, go ahead. I'm sorry. I didn't know you were continuing. Please go ahead.
Now, I would just make a motion that we approve the removal of section 134-221 Point two.
Second.
Thank you. Is there additional discussion? I'll share. I don't believe this would be the first time we've had parcels of land zoned to a category that was no longer existing. And we deal with this often in zoning to get it to a current or an existing zoning category. So with that, we have a motion and a second. Is there any additional discussion, or are there any additional questions from commissioners? All right, all those in favor of the motion, please raise your hand. The motion passes 5-0. Thank you, commissioners.
Thank you.
Okay, the next section is 134-230, and this one is one that we did have, a lot of public comments on. And also, this is one just, given the public comment that frankly, staff is of the position, if this doesn't move forward, that's fine. I think this is something we can certainly readdress whenever we take a deeper dive into our codes later on. So we're fine if this one doesn't move forward.
Okay. Commissioners, is there, oh yes, Commissioner Burrow, I see your hand up.
Yes, I would recommend that we hold this for further review and public input.
Okay, thank you. Is there,
second.
Thank you. Is there any additional discussion or questions? All right, all those in favor of the motion as presented, please raise your hand. Thank you. The motion passes 5-0.
And similar with 134-231.
All right, so we'll move that we hold this for additional consideration. Is there a second?
Second.
Is there any additional discussion? All those in favor, please raise your hand. Motion passes 5-0. Thank you, commissioners.
And I don't have a separate slide for 134-279, but that's the accompanying amendment that would 134-279 would have been stricken had we moved forward with the amendments to 134-230 and 134-231. So again, we're glad to hold that also.
All right. So I make a motion that we hold subsection 279. Is there a second?
I'll second that, but Jessica, it is in the code amendment package on page 81. There's a section of code in between it, but it is in the code package to be stricken.
Right. That's correct. It is in the package, and we'll correct that. We'll be sure that it comes back into the package on the final, so that it's clear that it's not being stricken.
Okay.
All right, are there any additional questions or comments? All right, all those in favor of the motion, please raise your hand. The motion passes 5-0.
134-272, I don't believe we had public comment on this one. This is parking.
Matter of fact, we need to, let's make sure. Yes, this is respect to parking. I don't know who asked that. Okay, are there questions or concerns from commissioners? Let's look at this.
I have a question.
Yes, Commissioner.
On this section, I think the 1, 2, 3, 4th bullet point, we're allowing for parking on non-hardened surface in residential districts for lots larger than 5 acres. Is that what that's saying?
Yes, ma'am.
Okay, is that permanently or for events or what?
So that would be permanently, and lots in the R districts that are larger than 5 acres, it is pretty common for people to want to have gravel driveways. We get that it comes forward pretty frequently as a variance request for the Board of Zoning Appeals, and it gets approved almost without exception. So this would allow for those large lot properties to be able to by right have an unhardened surface, so a gravel driveway, for instance, so long as there are no vehicles parked within 50 feet of the right-of-way unless they are on a treated and hardened surface, and that any new access to a public road, so if someone came in and wanted to do a gravel driveway, they would be required to have a 25-foot paved or asphalt apron at the public road prior to the start of the gravel.
Okay, thank you for clarifying that.
Are there any additional comments or questions? All right. So I can't recall that I made a motion with respect to this, or we're just discussing this. Forgive me, it's been a long day. Was there a motion? All right, I'll present this in the form of a motion that we move forward with 134-272. Is there a second?
Second.
All right, any additional discussion? All right, all those in favor, please raise your hand. Motion passes 5-0. Thank you, commissioners.
Right. 134-275.1 pertaining to the Military Airport Hazard District, and this would remove the provision for the Board of Commissioners to take into consideration existing uses and so forth, and take those on a case-by-case basis. And again, I don't believe we had any public comments on this one.
Correct. I haven't seen any public comment. I did have some questions with respect to this, particularly with respect to the PC addition for the onus to be on the applicant. Jessica?
Yes, ma'am.
So the applicant has to declare whether or not they're in an APC or APZ 1 or 2?
Yes, ma'am. That was a recommendation of one of the planning commissioners. That was not something that was recommended by the commissioner that sponsored the amendment or by staff. But the planning commission did say, currently the code says community development is to notify the applicant if they are located in APZ 1, APZ 2, or a clear zone. And the planning commissioner's thought was that really the applicant should know if they're in one of those zones. I would think that may not always be the case, and certainly community development, regardless of who the burden is on, is always going to check to ensure whether or not a property is in APZ 1, APZ 2, or the clear zone if it's something that's in that area.
Yeah, my concern is particularly for a lay applicant, you know, all the parcels within the APZs are not the same. You have some commercial properties. You have some that may be developed by a more robust or commercial developer, but you also have a lot of residents who may not be aware if they're in an APZ or APZ. I'm sorry, use my keep in an APZ that encompasses APZ 1 or APZ 2. You know, we've even heard of a case where there was a consideration of the school board that fell within those zones, and that wasn't known by someone at that level. It's very difficult for me to perceive that a resident that's coming in and let's say has an improvement to make to their property is going to know their designation. You know, with the staff in our GIS system, we're in a better position to be able to, you know, identify whether or not that parcel is in an APZ. I think it could be particularly onerous. And duly so. I think I saw a hand up. Commissioner Burrow, yes.
Yes, thank you, Madam Chair. When this came forward from the Planning Commission, I sent my recommendations for this section to community development as well. But someone coming in to apply for a rezoning is not going to know they're in an APZ zone. So the responsibility does fall on staff when they make the application to make them aware. But to take it a step further for the applicant, I had requested that in addition to staff notifying them when they apply that they are in a clear zone, APZ 1 or 2, that they also acknowledge, whether it's in writing or signed statement or an affidavit, that they acknowledge that they have been made aware and they know that they are in this zone. So I think that needs to be included to, I guess, give it more, to make them aware, because they're not going to know. And so I thought that was incorporated with the changes, but I guess it wasn't. So can we add that at this time? We haven't had any public comment, yay or nay, on the, and then also for striking the section 5, I just want to give some clarity to that. As some of you are aware, that discretionary clause was put in a couple years ago. And to remove that, anything that comes through zoning will still be the decision of the board to approve or deny. But this just makes it so that it's not an automatic given that they can be approved when they fall in these zones. And to me, it's a safety issue, potential loss of life and accident. And we have had several crashes in these areas from Dobbin. So that was my reason for bringing this forward as a sponsor, to have that one clause removed. It still gives the board, the ability to approve or deny. But I think with that clause out, it's not an automatic, and they're made aware that there are restrictions for height and other things that apply when you're residentially zoned in a APZ 1 or 2 or a clear zone path.
Okay. Thank you, Commissioner. Commissioner Richardson.
Thank you. Yeah, this is a change that I'm really looking forward to, taking out the discretionary clause. And so much appreciate that. But I was hoping that the new language was put in there, but I see that it's not in here, because I know that was a discussion about the acknowledgement of the impact if they are applying for something within that zone. And I think it accomplishes what the Planning Commission was trying to achieve on that end, because we're still going to have to double check. And certainly those were my concerns with the idea of the applicant going in and finding that it was kind of duplicative, since they probably wouldn't know where to even go to find that information. The only justification I could think of would be that, well, now they get a chance to learn about it all. But I think the language that is being referenced here about acknowledging the applicability of being in those zones is something that can be very, very, very useful in the application process for those that are applying. So I would, I'm not sure what that means for our consideration today, since that language is not reflected inside of the packet. But I do hope that that is a part of what's finally adopted as well.
Thank you, Commissioner. Are there any other comments or questions? Commissioner Sheffield?
Thank you, Madam Chair. I do support written acknowledgement from the applicant. However, it should not be the applicant's responsibility to determine if the parcel fall within those zones, and ultimately it should be our responsibility as a county. Now, regarding the language to strike through, and Bill, if you're with us still, Bill Rolling, I'll just need for him to add the legal side of this, but I don't see where removing that language still does not limit our constitutional powers as a BOC. So I'm not sure if removing this language, it may confuse the general public to think that if that language is removed, then therefore we do not have those powers. And I just don't want there to be any confusion on the end of the public as we move forward and decide on these type of cases. So Bill, if you're there and if you can just add a little, shed a little light on this from a legal standpoint.
Certainly, Commissioner. I am still here. I'm enjoying today, quite frankly. I like you guys talking about the codes and taking serious consideration of them. As Commissioner Burrell said, this does not remove your constitutional powers for the board to make an independent decision on as each of these applicants come up. And actually, what Commissioner Burrell, the language that she has suggested is we're actually going back to, I think it was prior to 2018, if I'm not mistaken, to how the code was originally written. And this language was inserted in it at that point in time. So, but yeah, you still have the constitutional powers. We can't take those away from you for local government to address zoning issues.
Right, I understand that, but my concern was also for the public in removing this with the public think that we do not have those powers, because I just want to make sure that our code is clear and concise across the board. That's all.
Okay.
Thank you for making that clear. I've had some vigorous discussion with Commissioner Burrell with respect to this, and also have researched policies that are in other communities, and many do adopt similar policies of the DOD in inserting the specified uses for the different locations around a zone, whether it be a clear zone or APZ area or other noise areas around a base. I thus do not think putting this forward is unreasonable, but I do want to share with the board is it sets a higher bar, which may be the intent of this, but it also can be a challenge, because I recall when this was put in place in 2018, we had a lay resident who wanted to make improvements to their home, and staff recommended denial of that because of what was in our code. And in reflection of that, they came back and said that we can consider the surrounding area when something moves forward under this section, and it got expanded. And if you can recall the zoning decision that took place more recently in District 2, staff provided approval for this. So really, when we have code, what it does is, our staff is going to look at the code, and they're going to look at what's being done on the ground and make their recommendation typically accordingly. So what we may be doing is just presenting a higher hurdle where staff may deny it based on what's in the code. And, for all of our experience in zoning, that staff denial or approval does have some weight. However, it is not the final disposition of a matter. It just is there to inform the board on their assessment of the code and based on the use that's being recommended. I shared this with commissioners, and I'll share it with you again, that there are substantial properties that are currently within our APZs. In consulting with our tax commissioner, we have property values that are approximately $2.2 billion within our APZ. The assessed value of those properties is $858 million of the 0.4 times the assessed taxable value. If you put this code amendment in place, which gives a higher bar based off the DOD recommendations, it does significantly limit the applicant and the board's and the county's consideration of what they can do with that property. Now, it doesn't necessarily dictate or negate their ability to have a use that is outside of what's in the DOD guidelines, but it forces them to come in through rezoning. And with the higher bar, it makes it more of a challenge for them to redevelop their property. This code change that we're making today, I know impacts a very significant business owner within our county who has provided their desire to disposition their property in a way that does not comport with the DOD guidelines. And that could have a tremendous financial impact on their business. I'm sensitive to balancing the interest of all of our parties, understanding the prioritization of our base and the economic impact that they have. But we also have other businesses that have economic impact and residents that also have been impacted. As again, I shared in 2018, a resident was precluded from improving their property because they fell within the APZ. So I just wanted to make it very clear the impact of the decision that we're making today. This board knows the history and we know our zoning power, but that doesn't necessarily mean that the next board and the next board is not going to be more apt to lean on this or on staff's recommendation based on this. And that could have significant financial impact on our property owners, again, that are in our APZs. That being said, I am in, yes, I'll leave that there since I see a couple of hands went up and before I say anything else. Commissioner Sheffield and then Commissioner Burrow.
Well,
And I'm
I
sorry,
wanted to ask
for 1 second. I see Commissioner Gamble's off my screen, so I just want to make sure she didn't have her hand up too. 1 second. Commissioner Gamble, if you can just.
I'll weigh in at the end. Thank you.
Okay, thank you.
No, just for Commissioner Burrow or for you, Madam Chair, with respect to history, was there a zoning case that passed that led to or triggered this language being added? I think Commissioner Burrow mentioned it was 2012 or 2016. What was this language amended on the heels of a zoning application that was attempted to be passed or that you guys reviewed or passed?
Well, first of all, I will let the chairwoman speak to when this was added in.
Okay.
I think it was one of her cases, but and I'll let you go and then I'll say what I wanted to say in response.
Yes, thank you, Commissioner Burrow. You know, my memory is fuzzy, and if it was 2018, District 4 did not come up to this area, but I have a great sensitivity to businesses that are on the side of the base because there was a time this was in District 4. And I do know the challenges that that community has in having age development and not having the investment that is seen in other areas of the county. And so there have been times, even prior to that rezoning, where I've made decisions on our future land use map to help encourage the redevelopment of areas there because of just the languishing character of that area. There was a zoning case that I believe did come up. It may not have been in my district again, but I was sensitive to the area where a gentleman was precluded again from improving his property because he fell within this code section. I think he was trying to build another home on it and would have had that zoning by right, but for this code section, and staff recommended denial of that. And I felt that wasn't fair, particularly if you look at what the activity is on the other side of the APZ. If you look into District 2, you see much more intense development. You see more current development. And I felt that this person was being, unfairly considered when the board recommended denial, when he wanted to add an additional home, which would have been one of the newest properties that I've seen in that area. And I advocated for this resident. I know that we did hold it. There was some additional discussion. Staff did share with me the addition of this phrase that would allow us to look at the general character of what's going on in the area, as opposed to just recommending denial outright. Even before we made this code change, after the case was held, the person came back and we ended up moving forward with supporting this individual's request. So these are the kind of decisions that become very difficult. Now, I mentioned the issue of one of our larger property owners, but this affects every property owner that doesn't have an interest in developing their property as industrial or as a park property. There's been some discussion, and I've also seen this in DOD documents, where the base in collaboration with the community may actually purchase parcels that help to ensure that their alignment with what the DOD guidelines are. And I think that's a way to meet people halfway, to recognize their property interest and to recognize they're losing out on being able to get the return for their property that they may have anticipated or expected outside of the DOD guidelines. I think that's something that, considering the weight that the base has in this county, considering their contribution that they have in this county, and the amount of impact that they have, that this is not something that we should leave off the table. This is something that I think should have some serious consideration for those property owners. And again, if we're espousing safety to be as critical as it is, you still have people living, working, in these areas. We're getting back, this is a very long drawn out answer. It's just getting back to more of the complexity of this issue of just adopting this without without keeping in language that talks about the discretion of the board. The discretion of the board will be there, but I have seen that particular zoning case become much more of a headache than it should have been for a property owner in a languishing area surrounding the space that was going to make an investment that could have potentially helped to spur other property owners in his area to make an investment or to make investments in their properties. Commissioner Burrow.
Thank you. Well, first of all, there are properties in the APZ zone that are grandfathered in, if you will, that have been there for a long time. But moving forward is the reason for safety, number one, but also for the putting Dobbins, Georgia Tech Research Institute, and Lockheed in jeopardy with Dobbins being on BRAC. And the business owners that with all due respect, Madam Chair, you keep talking about business owners developing their property. This applies to residential. It doesn't apply to commercial. So these restrictions are already in the code. And if going back to Z11, Planning Commission and staff recommended denial on that. And you know where we were with that, and
that's incorrect,
resolved in a different manner by the land exchange.
Commissioner, I'm sorry, staff did not recommend denial, and I need clarification from staff whether the military hazard district only pertains to residential properties, because that has never been made clear to me.
No, the airport hazard district does not pertain only to residential properties. In APZ 1 and APZ 2, there are different thresholds for what types of land uses would be appropriate. APZ 1 specifies only passive park use as well as industrial use for compatibility.
So residential is not, but commercial is compatible.
In APZ 1, it's industrial and passive park.
And it's not just the development of new property. Often when a property owner comes in just to improve their property, it triggers some consideration sometimes for zoning. And this is, again, becomes problematic for a large array of our property owners.
Well, again, with this language being removed, it is not an automatic. Each case, the cases can still come to us and be heard on a case-by-case basis, and they can be approved or denied by a majority of the board voting. That doesn't take away any powers or decisions by the board, but to me, if an applicant comes and they are made aware that they are in a potential hazard zone where a plane could crash and they could be killed, then to me, I would think twice about trying to put houses there or whatever they're wanting to put there. And I get where you're coming from as far as not being able to develop their property, but it's a major safety issue for them to be living in a potential crash zone or flight path. And if they're made aware when they come through zoning or apply for zoning, and they acknowledge that they know that and they still move forward, then it's a board decision to deny or approve it. I'm just trying to make them aware and to think twice about applying to build in an APZ 1 or 2.
I love the efforts for making people aware. I think that's very helpful. And I certainly going through the most recent decision, it helped to bring awareness to a lot of people. And I like the language that has them acknowledge that when they do apply. Again, I've seen it with my own 2 eyes, how onerous this has been. And if the concerns about safety are as real as they're being communicated, then I think it doesn't just apply to new residents that have, concerns for safety. It's those that are existing residents too. And perhaps there should be some real consideration for what we do with the existing residential property owners and residents that are in these areas. So I don't know if there's any additional discussion or question. I do see all the commissioners here. Yes, Commissioner Gamble.
Well, I'm not sure why a particular property is being brought up in this conversation. We are writing code that applies to all properties. To me, this code is further relaying our vision as far as how the board is going to address development in a military airport hazard zone. It has nothing to do with the single property owner, and that's not a consideration that we should be taking into effect in considering the language.
Yes, I respectfully disagree. I think when you do create law, you do look at how that impacts real people. You look at its real implications, and those cannot be denied. In fact, it allows you to craft law that carefully considers that. As I understand, it is our will to not just be able to create policy, but to create policy in light of the impact that it has on the people that serve here and the people that invest here. And I will always encourage commissioners to take into consideration the impact that any of our work has on real people. Now, I'm not saying that the public policy interest may not supersede that, but I think it allows us to, again, be able to be thoughtful in crafting policy that isn't unduly onerous to people that will be impacted by this. So with that, we have, I'm not sure if I saw a hand. Yes, Commissioner Burrow.
Yes, just for legal clarification, or Jessica, the language for the applicant acknowledging what?
Yes, ma'am. And first of all, just to clarify on that one, the reason that we didn't put it forward in this package that you have today is because since this was something that is in 134, The recommendation on this is coming from the Planning Commission, and it is put forward after a public hearing process. So out of respect to that process and to the Planning Commission, whenever we put it forward to the Board of Commissioners, we put it forward just as they've recommended. So that's why the language that you have suggested is not included currently. If that is something you'd like to change and staff is fully supportive of that, I think that, regardless, we need to be the ones checking to confirm whether or not the property is in the APZ or in the clear zone. So I would recommend that if you would like to do that we keep the language as is, and we can add on to that language that the applicant shall acknowledge the property's location in the APZ 1, APZ 2, or clear zone. And that's something we can easily incorporate into our application process.
I think if you keep the language as is, Jessica, it directly conflicts with what you're saying, and that the onus could be on the community development agency, because you're telling here that the applicant, any person ... shall notify community development, and then you're saying we'll notify them and then they'll acknowledge it.
I'm sorry, Chair. To be clear, whenever I said to keep it as it is, I mean as it is in the current code, not as proposed by the Planning Commission. So it would say the Community Development Agency shall notify any person submitting. Okay. So keep it as is, and then we can add on to them.
I received that. Thank you for clarifying that. I am in support of that.
Right. And just add that they have to acknowledge, once they're made aware, that they know they're in an APZ 1 or 2 or clear zone.
Okay, thank you. I see.
It's page 65.
Yep.
On number 5 at the top of the page.
And Madam Chair, if we can also include the type of acknowledgement. It was mentioned earlier by Commissioner Burrow that perhaps there's some type of affidavit or written acknowledgement, but if we can include the type of acknowledgement as well.
Do you have a suggestion? Or
I would say written acknowledgement. It doesn't necessarily have to be an affidavit. I'll leave that to community development to decide, but a written acknowledgement.
Right.
Okay.
Because when we get zoning analysis, the boxes are checked that they're in APZ 1 or 2, but that's staff analysis, and that doesn't come out till, a week before we hear the cases. So the applicant isn't going to know by that, but when they apply, then they will know by acknowledging it in writing that they are in APZ 1 or 2. But staff still has to make them aware, because they're not going to know.
Yeah.
So, do you want me to make a motion?
Yeah, I just want to clarify first, however, Commissioner Sheffield's point to legal. With the written acknowledgement, can attesting to that, if it's already acknowledged in the application, be sufficient for them to just sign that they saw that? Can that satisfy what it means for written acknowledgement?
Well, usually we leave this to staff to set up a policy or a procedure for them to be able to do it through the application process.
Okay.
If you want to include something that's an affidavit that they've submitted it or that it's identified, it could be a process as little as just an email that's returned saying they acknowledge it. Usually when there's at that level, granular level, we usually community development or whatever the department lead on what it is they want. But if the board wants to specifically direct what sort of acknowledgement they want to have, then we need to actually include that language in the code section.
Yes, and what I'm hearing Commissioner Sheffield say is she would like for the code to acknowledge that the acknowledgement has to be I don't know whether it's electronic, written, I don't know, but I'm just trying to make sure that whatever we put doesn't preclude, a wide variety of forms. And I think that's what Commissioner Sheffield is getting to. It doesn't necessarily need to be an affidavit, just some way of.
Right.
I think the cleanest way to do it, Madam Chair, is a suggestion. The cleanest way to do it is to have it done during the application process. If it's nothing more, it's something on the application that has a line for signature of the applicant. Because what I would like to avoid is having acknowledgement sent by email. We're trying to track down an email. I think that just, for purposes of being clean, it should just be kept with the application package, but that would be my recommendation.
Yes, Jessica?
Yes, Madam Chair. I would agree. I'd like to keep this as general as possible to say written acknowledgement, because this not only applies to zoning decisions, but it also applies to the building permit process. So if someone comes in to pull a building permit, they would also have to acknowledge that. And as you all know, right now we're in the middle of software implementation. So I think this is something that we would build into that process, and the more leeway, flexibility that we can have as possible to be sure that we have that written acknowledgement. But in terms of what form that comes in, I think helps us out a lot as we're working to streamline and improve our processes through the software implementation.
Okay, so if we move forward with this today with the motion, Jessica, what is your recommended language?
I would just add to the end of number 5, and of course leave number 5 just as it is in the current code, that the applicant shall provide written acknowledgement of the property's location in APZ1, APZ2, or the clear zone. And I think that's sufficient and gives us a little bit of flexibility to determine exactly how that written acknowledgement is delivered to us. And that would suffice for us.
Okay. And Commissioner Sheffield, are you in agreement?
Yeah, that sounds great. Thank you.
Okay, thank you. Are there any additional comments or questions with respect to this code section? Okay, Commissioner Burrow, I believe that it's ready to move forward if you would like to do so.
Thank you. Go ahead.
No, ma'am.
Oh, I thought somebody was saying something. I would like to make a motion to amend section 134-275.1 to remove the language in section 1. However, existing adjoining uses, historical uses, and height may be taken into account when making decisions on land use cases before the Board of Commissioners. This does not preclude the board from considering other factors on a case-by-case basis. And to add in section 5, that the applicant must acknowledge in writing that they're aware they're in the military hazard district. Whatever language, Jessica. Do you want to repeat your language so I get the motion correct?
I think what you said is great, that the applicant will acknowledge in writing, or shall acknowledge in writing, the location of the property within APZ1, APZ2, or the clear zone at the time of application.
Okay. That would be my motion, Madam Chair. You're on mute.
Oh, thank you. Shall acknowledge in writing. That's what I thought. Shall acknowledge in writing whether the property is in the clear zone or APZ or 1 or APZ2. All right. Okay. I see you nodding, Jessica. Commissioner Sheffield, I believe that you had additional question or comment. And Commissioner Richardson, I'm sorry, I can't see if you did or not.
I just said second.
No, Madam Chair, I did not.
Okay. Is it Commissioner Gambrell?
No, Commissioner Richardson had seconded. We hadn't had a second to the motion that was on the floor.
Okay, thank you. So we have a motion, a second, no further discussion. All of those in favor of the motion as presented, please raise your hand. Thank you. The motion passes 5-0. Okay. We are
very good. We're almost done. We're on the home stretch here with the code amendment. So 134-290, this is the backyard chickens. And again, we talked about this a little bit earlier, but this is just clarifying it's backyard chickens under 2 acres rather than under 80,000 square feet. And we had no public comments on that.
okay. So I make a motion that we approve code section 134-290.
Second.
Is there any further discussion?
Just for the record, there was a comment. Sorry.
Yes. Would you like for that comment to result? Yes. Do you have any additional discussion, or would you like for this to move forward?
I do want to move forward, but there was a comment, and that was discrimination against the rooster. So just wanted to make sure that was on the record.
Thank you.
I mean, roosters have rights, you know.
The reason
Yeah, on
why
2
roosters
acres
have,
or more, roosters are allowed.
and the reason why roosters are not allowed is because of noise, which goes back to the noise ordinance.
That was the joke yeah. So that needs to be addressed in the noise ordinance.
And you can't address it.
Actually, roosters are not allowed in less than 2 acres.
You guys don't want to be done with this code.
There you have it.
You guys just want to keep going. All right, so we have a motion and a second. I will end further discussion due to its redundancy. All those in favor, please raise your hand. All right, the motion passes 5-0. All right, Jessica, help take us home.
Yes, the last two sections are both in Article 6, the sign ordinance, 134-315, which would allow for 1 permanent sign per entrance and exit for commercially zoned property, non-residential use on residential property or apartment, and also 134-323, which would allow for some additional temporary signage on those properties. Glad to answer any questions. We didn't have any comment on either of those.
Thank you, commissioners. Do any of you have any comments or questions with respect to section 134-14 and also section 134-15? Jessica, are you also including 134-323? Or are we going to consider that separately?
I think you could consider both of them together as they're both in the sign ordinance, but it's your discretion.
Okay. Yeah, we'll go ahead and do that. And again, I'm reading off of what I have here in front of me and not necessarily your PowerPoint. I have 14 and 15, but 14 does have a small change to add consideration of 134-323.
Yes.
Yes.
So it would be 314, 315, and 323.
Okay. Commissioners, do any of you have any comments or questions with respect to the subsection of 134? With that, I move, commissioners, that we support sections 134-14 through 134-314 through 323 as has been presented.
Second.
Is there any additional discussion? All those in favor, please raise your hand. The motion passes 5-0. Commissioners, that concludes questions and discussions. We've had a lot of that for the past 4 or 5 hours, but thank you for the commissioners. Thank you to the public for all of your work in weighing these, but particularly thank you to our staff for all of your work in putting these amendments forward and in taking into consideration all of the feedback that you've received. There are a number of code sections that we have decided to hold for additional consideration. When we made those motions, we did not put a time frame on when that will come back. Bill, I would just ask that you help us determine the earliest that we can have that come back, because according to our meeting that we had yesterday, there needs to be ample time for these to be advertised.
Right, Chairwoman. I mean, each one of them may take longer than the other ones. I think Noise Ordinance has been working on it for a while. As far as the short-term rentals, different. I mean, we could work with the county manager if there's this particular point in time she wants to bring all of them back. I suggest we just bring them all back and we can work on a date that might be after the budget in the fall, or that way it gives staff the time to be able to review them and look at them and take in the public comment. Or some of them might be rolled back over to when we do them again in January. But I don't think any of them have to have a date specific they're being brought back, because right now they would just be brought back here and then during whatever the next cycle would be that the board elects to do for code amendments.
Thank you. Well, certainly, Jessica, please help keep us current. A lot of these were time sensitive. Again, I particularly think of the short-term rental code amendment and the public that has been waiting for us to consider this for about 2 years now. Yeah, I certainly don't want to be unduly onerous to your team, but I just ask that you help keep us honest with the sensitive nature for a lot of the code amendments that we did not vote on today.
Yes, ma'am.
Yeah, great. And thank you again, Jessica. We really appreciate you, and thanks for all you did in leading this for us.
Thank you all.
Thank you. Commissioners, I believe that we are now to public comment. So, Bill, if you can let us know, I believe we should probably have had 6 speakers. I don't know if we still have 6 speakers signed up for public comment.
We do still have 6 speakers, Chairwoman. Our first speaker, or do we need to go over the rules first? I'm sorry.
If you don't mind, Kimberly.
Go ahead.
I'll just remind all the speakers as the board provides the podium for public comment, it's appropriate to review the related meeting rules. Please state your name, and if you're speaking on behalf of an organization, all comments should be addressed through the chair. Public comment is not a dialogue with the board, but an opportunity for speakers to provide their comments to the board. The comments should not be impertinent, derogatory, offensive, or slanderous. Statements made during the public comments portion do not necessarily reflect the opinions of the board or the administration of Cobb County government. I'll keep track of the 5-minute timer and let you know when that time has expired.
Thank you, Bill.
Our first public speaker is Monica Delancey. Monica, go ahead.
Good afternoon, Monica Delancey, Riverside Community We Thrive and Riverside Renters Association. I just want to spend this time to remind you that February is Black History Month, and also February is National Parent Leader Month. So I just want to make sure to observe those. Last week, there was another eviction that took place in Cobb County. It took place over at Forest Glen Apartments, and I was able to assist the lady with her 3 kids. At the time, she was trying to load her items onto the U-Haul storage truck, and she had some people that was helping her. And also, I wanted to thank Felicia Stewart with Much Ministries for able to assist with a hotel for her that night. And the main concern that came about from this eviction, this was the second eviction that I've witnessed in 7 days, okay, here in Cobb County. But the main concern that came out of this conviction was the lady did state that she had applied with Star C, and she did receive Star C assistance early. That was in 2020. But when the process went to applying online, she applied online in 2021, and then there were some apartment management changes. So her application got shuffled in trying to apply online, and the new management trying to send the ledger over and not understanding that process. So basically, yes, she was evicted from her home. She did say she did go to court, and at court, that's when they gave her another scheduled date. And again, somehow she did not receive the notice via mail or attached on her door. So that's another thing. Once the Cobb County Magistrate Court reschedule hearings, is that process the same from when they first tell you? They'll tell you to come to court by, putting the notice on your door or mailing it. But when they reschedule it, it's a miscommunication on who's supposed to check back and that part. So that's something that I'm looking to help to communicate as well. But I do want to know that this mentioned that if people are being evicted, they should do a come to the shelter and they have an intake. But the hours are between 10 and 2 or 9 to 2. these people are being evicted after 2, 3, or 4 o'clock. So Musk Ministries is closed. Okay. And I'm glad that, again, Musk Ministries police was flexible enough to understand that, you know, it's getting dark outside. You know, it's hard to locate any, you know, family members to try to see if they can stay with someone. So having, you know, access to, okay, let's just cover this person for this family for one night until they're able to get to the shelter. And that's something I'm hoping to, hopefully, I know Jeff Owens said he's having a conversation with Judge Murphy about allowing that. I can't get to everyone. It's the only reason why I'm able to, you know, see some of the things taking place, because other advocates have called me and they say, Marky, can you come over? I can't get to everyone. And so when I do come, able to go over to the last 2 that took place, I'm going to send an email over to the social workers and also provide some type of filling the gap, providing dinner for the family, helping them with storage, helping them find movers and saying, okay, can y'all come help move, and we'll give you some, you know, something to help us get these things onto the U-Haul truck. And it's so hard. So it's hard to see that a lot of items are left behind, and these kids, you know, going to elementary school and middle school, they don't recover from that. They don't recover from, okay, we just got to move to another place. Once a family goes through a forced eviction, that's what it is. When your things are put outside on the side of the sidewalk, there's toys. You can tell some of the toys are still new for Christmas. Their toys, their clothes, and it's about to rain. It's going to rain on these items. They don't recover from that. So how can we send these children back to school thinking they're going to be able to learn anything? How can we send these students and these families saying, okay, we want you to be a part of these programs. We want you to be a part of this. Well, they don't know where they're going to be at 30 days, 40 to 30 months down the road. So, yes, Cobb County, it's not just a Cobb County issue, and I get this all the time, but, you know, Cobb County with the board that's in place, and we know that evictions are mostly women and women of color, we have to be the leaders saying we got to do something about this. We have to think of long-term solutions. We have to go and ask the apartment complexes to stop taking people shelters for just short amount of time and say, okay, you got to leave.
Ms.
Okay.
Clancy, sorry
Well, thank you very much for allowing me to speak. Thank you.
Our next public speaker is going to be Michael Cox. Go ahead, Michael.
Thank you, Chairwoman. My name is Michael Cox. I'm a short-term rental host in Cobb County. I wish you a speedy recovery. And this is my first time speaking to the board, and my comments are on the proposed amendment for short-term rentals in section 78-407, which has been held for further consideration. I look forward to the opportunity to provide feedback on this process starting now, if that's okay. For brevity, I will refer to short-term rentals as STRs. This code, as written, will fail to meet its stated purpose and cause harm to Cobb County residents. This proposed code will place undue cost burden on hosts, decimate the number of properties which can function as STRs, strip Cobb County residents of critical income streams during difficult economic situations, and force clients of the STR market to be subjected to the increased prices and decreased safety and security of hotels, motels, etc. A primary concern addressed by this code is the problem of party houses. I agree with the frustration expressed about this issue, as it reflects poorly on hosts like myself who offer a quiet, peaceful stay for our guests and work hard to ensure no disturbance to the surrounding neighborhoods. However, this code is basically using a sledgehammer to address an issue that should be handled more precisely. My listing specifically prohibits parties, and most STR listings also prohibit parties. This should be addressed directly without building an onerous set of regulations that destroy the aspirations of small-scale STR hosts looking for critical income during difficult economic circumstances and reducing potential for county tax revenue. Some specific requirements which will cause harm to residents include the standard conditions for A, short-term rental occupancy limited to 1 adult per 390 square feet as shown in Cobb County tax records. An explanation of the harm caused by this is that this code will place an unreasonable constraint on the properties which can host STR guests and will completely destroy the ability of many hosts to host guests at all. An exception to this residential code requirement should be considered for STRs. There are reasonable business cases where this constraint is unreasonable. The county should consider an exception for occupancy limit per square foot for each listing, as opposed to by property, or consider an exception of 1 adult per 200 square feet in STRs by property or some other more reasonable number. The maximum occupancy should also specify if this number is rounded up or rounded down. For example, a 4-bedroom, 2,000 square foot home can be comfortably furnished to accommodate 2 guests per bedroom, but will have a maximum occupancy of 5.128 adults. Per this code, a host and their partner could not even host 2 adult couples in each of the 2 other bedrooms while they remained in the home. Another example of a provision that will cause harm is standard condition 4B. Short-term rentals shall meet all applicable building regulations as required by Chapter 18. An explanation of the harm caused here. As written, it appears this code would require homeowners to upgrade their homes from compliance with the International Residential Code per Chapter 18, Article 8, 1 and 2 Family Dwelling Code, to compliance with the International Property Maintenance Code per Chapter 18, Article 6 Housing Code. This distinction needs to be clarified. Once you begin the permitting process to perform work, the code requirements can become quite complicated and frequently require an updated version of the code, or required to meet an updated version of the code. Subjecting homeowners to a different construction code to function as STRs will create excruciating construction costs, eliminating good hosts and stripping them of their access to this source of income. As written, this code will provide an unfair advantage to hotels, motels, etc., and local government should not be used as a mechanism to destroy income sources for the voting public to the advantage of corporate interest. Residential STRs provide a unique, more personal service to guests of Cobb County that hotels, etc. cannot provide. For example, during the World Series, we were able to host 2 sets of guests that would not have attended the games, were they forced to pay the minimum $400 per night charged by hotel chains that weekend. A guest that regularly books during the week is an electrician commuting from out of state to perform utility work here in Cobb County, while also coordinating a personal move. The other day, he expressed his gratitude for a safe, quiet place to stay with people he's come to know and trust. He explains that we were the most stable thing in his life over the last month, and he was extremely grateful that he didn't have to spend all those nights in a musty, depressing motel room. This type of personal experience and service is something that hotels and motels simply cannot provide. In conclusion, thank you for holding this code for further consideration. I ask the county to consider the proposed exceptions for square footage requirements, clarify the building code requirements to not place undue construction costs on hosts, and work with local STR hosts to develop reasonable measures that address the concerns of the county without crippling the residential STR market and handing corporate interest and abuse of monopoly in the industry. As a resident of this county, I specifically request that any commissioner who holds conflicting business interests with regards to the proposed code amendment abstain from voting in the matter in accordance with the County Code of Ethics. I also ask whatever venue will be available for providing more comments to this proposed amendment going forward. Thank you for your time and consideration.
Our next speaker is Hill Wright.
Hill Rooster here. Today is 5 months since many of the citizens of Cobb County woke up to find their lives had been turned upside down. Many would suffer damage for which no insurance would cover and for which many with flood insurance were not covered. People had damage to their homes. People had damage to the shared community assets running through their yards. Some didn't even know those assets were even there. There were stormwater control measures upstream that were not maintained and never inspected by the county. Today, Cobb County does not even have an accurate inventory of these control measures or even the shared community assets. The county's current plan is to ignore all of this and leave the citizens exposed and pretend this is not the county's problem to solve. This must change. Just last week, we had storms again. More damage was done. More people were pushed to the edge. I've talked to people who are waiting for help, hoping for help, people who do not have the means to fix the problem. Their only hope is that help will arrive. Some can't get the elderly out of their homes. Some are under such stress, it's even impacting their jobs. Cobb housing is at risk. I know this isn't as sexy and doesn't seem as forward-thinking as transit, but it's more important because Cobb housing and Cobb families are at risk. A basic need in Cobb is not being managed. Cobb does not have a solution for acute problems or a long-term plan, so we don't keep creating more acute problems. It's time we had both. It's time that this board finally act. I'm calling on this board to move the needle by the next board meeting. I've invited the community to watch and see if it does. I ask you that you table agenda item 39 and item 41, as I do not believe it reflects the feedback the county received during the engagement in 2019 or 2021, nor do I believe that the citizens of Cobb are aware of the details. I request this be tabled so the citizens of this county have time to review it and provide meaningful comment. Item 41 seems to be putting the cart before the horse. The citizens deserve to have a vote on House Bill 930 before Cobb submits any projects. To do so is putting the cart before the horse. It's hard to argue against cityhood when you're putting the cart before the horse so much. I appreciate and thank the board for really listening with citizens' concerns on the code amendments and not rushing ahead without considering citizens' concerns. I'm also dismayed at the conduct of the chair today. Respectfully, a commissioner should be able to raise a question if they do not agree with the clarification received, question the response, and be listened to instead of being labeled. The chair owes an apology to Commissioner Gambrell. The chair should sit in judgment on herself before it judges anyone else and engages in the very same conduct they're accusing others of.
All right, our next speaker is John McLean.
Good morning. Thank you for allowing me the opportunity to speak this morning. It is very much appreciated. I hope the chairwoman makes a swift and complete recovery. I just want to say, I'm just bewildered about needing to sign in this morning at 8:15 and having to wait till now for my 5 minutes, but it is what it is. Anyway, first let's talk about the Board of Commission meetings. How long are these meetings and public speaking opportunities going to be virtual? Has the board voted to make these events virtual? It is my impression, maybe I'm mistaken, that the chair, along with Ms. Memark, decided to mandate these virtual meetings. I don't understand why the board hasn't had a full vote. The public deserves representation from all board members. Maybe the entire board does agree that these meetings be virtual. I would hope not, but at least you'd have voted. And I don't understand the ongoing effort to restrict public speaking opportunities. I hope you all as a group take corrective action real soon. Cityhood. The City of Lost Mountain's effort is all about zoning. Every time we see a yellow rezoning sign in West Cobb, we tremble with fear and we wonder what the county and developers are up to. At the same time, this board is attempting to rewrite the entire county development code. Right in the middle of all this. It's in West Cobb, we want to keep what we think is the unique look to our community. We don't want an urban look. I think we have a great commissioner on this board. She represents us really well, but she is one of only 5 votes, and we've seen her voice shut down countless times. The organizations that support the cityhood efforts throughout the county have done their own feasibility reports. As regards the City of Lost Mountain's effort, it showed positive results. According to UGA study, the city would have a significant surplus without raising taxes on its residents. That's good stuff. But this board has known for some time now that there were several cityhood efforts underway. It's somewhere around the middle of last year, it was recommended to the chair that if the board wanted to get involved in this discussion, they should do their own feasibility study to determine how cityhood might affect the county. That study has never been done. As a result, you have no factual basis for any opinion on how cityhood might affect this county. So now you've hired highly compensated lobbyists, some of which is my hard-earned tax dollars, to lobby state legislatures in the Capitol about cityhood. I realize those lobbyists have other items of interest. I understand that. But the hot topic right now is cityhood. It is my opinion that your lobbyists cannot lobby for or against cityhood. Let me repeat that. The board has not voted one way or the other, so the lobbyist cannot lobby for or against cityhood. Without a vote or a position, how can a lobbyist represent this board? He cannot state the board's position because the board doesn't have one. All the lobbyists can do, or should do, I hope, is listen and report feedback. And according to my commissioner, there has been 0 feedback for weeks. So what's he doing? But really, you can't vote today to develop a position right now anyway, can you? because you haven't done your feasibility study that you should have done last year. You don't have any facts. If you vote now, it will be without facts. And it's only going to be about what you think it might mean for the county. So now you've hired a bunch of lobbyists to represent you, but he can't because you haven't voted. He's not offering feedback either. For me, and I bet for a bunch of other people, it's really disappointing. Thank you for your time, and I appreciate the opportunity to finally speak. I'm done.
Our next speaker is Trevino Adderley. Go ahead, sir.
Yes, good afternoon. Can you hear me?
Yes, go ahead.
My name is Trevino Adderley. I'd like to take a moment of your time to discuss some economic disparities that I've encountered as a resident of South Cobb. I'm a disabled individual and I live on Social Security disability. As some of you may be aware, low income and affordable housing has been an ongoing crisis in Metro Atlanta counties. I recall back in August of 2010, Atlanta opened its waiting list applications for Section 8. They had approximately 13,000 applications. 30,000 people showed up, making it national news and awareness of the crisis. But yet, here we are some 12 years later, and it's still an issue. One of the things I struggle with right now is that I'm on a waiting list for the Marietta Housing Authority. For the past 3 years, I applied in 2019, and when I called to check in, I said, no, you still have the waiting list between 2 to 5 years. How can that be effective housing? When people need housing, you can't wait 5 years for housing assistance. The current struggle that I face right now, the apartment that I live in, the rent was $635. When it came time to renew the rent, it went up to $1,080. I managed to argue with them and somehow they reduced it down and now it just went up about $75. Nonetheless, there is an issue of affordable housing and, as a resident of Cobb, I reach out to all of you and ask for your assistance to hold agencies that are supposed to provide assistance accountable. As I said, I'm disabled. I'm quite sure I'm not the only resident of Cobb facing this, but elderly people go through the same issues. It seems to me that the most needy are being forgotten and overlooked and suffer in disparity. In addition to economic disparities, I've also faced reasonable accommodations requests. I fought with my apartment complex for 2 years just to get a handicap parking space and a ramp, something that is supposed to be given to me by federal law. The apartment complex where I live, there's no sidewalk connecting to the main street. It's about half the distance, about 30 or 40, 50 feet, and it's covered and overgrown with shrubs, and code enforcement never comes by to enforce it. The nearest bus stop is actually sitting in a bunch of bushes. I've called Cobb County Transit about a year ago. They said that they would put a sidewalk there. It's been a year, over a year, and nothing's done. So again, I reach out to you, as these are just these are just some of the issues that I face of concern. I need help, and I'm requesting the Board of Commission for assistance.
Okay. Our next speaker, and this is the sixth and final speaker for this section, is Pamela Reardon. Go ahead.
Oh, hi. Good afternoon. I guess I moved from 8 to 6. That's good. I just wanted to talk about a few things this afternoon. I've been seeing that even the draconian lockdown states like New Jersey have just lifted the mask mandates for the children in school. And I'm wondering why we're still in virtual mode when none of the counties surrounding us in Georgia are, and why there are masked people in the buildings. I think that you've just gone through your own study with respect to this, because at the meeting 2 weeks ago, Chairwoman Cupid was masked in a room virtually by herself and then came down with COVID. I think she stated that she's been double vaxxed and boosted. So I think this virus cannot be shut down. It can't be shut down with vaccines and boosters and masks. It has to be, you do the right thing. Of course, you do the right things, but mandates don't work. And thank God I haven't had it, but I don't mask. And I think that masking actually adds germs, but that's my opinion. And it is like a bad cold because my husband had it and he didn't give it to me, thank goodness. Number two, I object to the chair giving high-paid lobbyists free rein to work against the cityhoods. And I think that it sends a bad message because cityhoods are trying to get representation closer to the people, and working against the people in this respect with their taxpayer money sends a very bad message. Number three, I object to the increasing spending we are seeing in this raising the inflation and uncertainty with the national economy, because I can see this coming watching the work sessions where every department wants more money and more staff. Number four, I object to raising the millage rate. Number five, I object to the new Comp 2040 plan inserting high density into our suburbs. Number six, I object to adding up to 2 more cents on our sales tax for transportation and 1 cent of that for going 30 years to MARTA and the Atlanta to dictate our project. I've yet to see a cost-benefit analysis to prove that this is needed. Maybe the gentleman that spoke just before me, something could be done to help him instead of spending all this money on roads and more buses that we don't need. Lastly, I want to talk about the map, the commission map. There's been a lot of misinformation about this. Commissioner Richardson, when she won her seat, she lived in the south part of that district, and within months she moved into the middle of East Cobb. So in trying to balance, and knowing that the redistricting was coming, in trying to balance these districts, east, west, north, south, and it really makes sense to me that there's a high density part going from where she was living, well, actually by the voter rolls says that she's still voter registration is still at that address. So I'm not sure what's going on with that. But I'm just trying to understand that Representative Eric Allen saying that there was communication and there was public forums. I saw that there was a public forum 2 days after the public forum. So there wasn't very good information sent out everywhere to maybe both sides of the aisle, because I hadn't seen anything. And nobody I know had any input into their districting. So I agree with the new maps that the Representative Carson has proposed down at the Capitol. So I'll be supporting that. Thank you very much for hearing.
That concludes this section of public comment, Chairwoman.
Thank you, Kimberly, and thank you for all of those who waited to speak. Hello, I believe public comment has ended. I don't know if that's someone from Cobb TV speaking. But again, I wanted to thank all of those who've been very patient to wait to speak during public comment today. This is atypical for our meetings to last this long. And I did want to provide some remarks with respect to public comment. With respect to cityhoods, please note that of the cities that are moving forward with consideration on the May referendum, that their feasibility studies were not completed until October and November of last year. In order for the county to be able to produce an impact analyses, we need to be able to understand the scope of those cities. Having those feasibility studies in hand to be able to assess the impact of the county is important. We have been talking to someone to provide an impact analyses for the county. We're just in a very difficult position to get those completed on time and collectively to know what the broad range impact will be of the county. The county is responding to inquiry of citizens who are not aware of what is going on with the cities. Just as we've been waiting for information, many of them have not had it. As stewards of all of our citizens, it is our desire to make sure that they do have information and knowing what can impact their residents here within the county. I've also had business owners reach out to me, also concerned as this also impacts their business. Even though people have reached out to us for, with concern about not having information, it has not been my position, not the chair's position, to go after cities in opposition. That has been made very clear publicly. It's been made very clear at the state, and I'll make it very clear again that the role of the county is to educate, because citizens will be financially and significantly impacted with the creation of potentially 4 cities that can result in more than half of our population living in incorporated areas. Today, only 26% of our population lives in incorporated areas. This will impact service delivery and could impact the finances not only of those living in cities, but those living surrounding those cities. So I did want to make that clear. I also want to clarify information with respect to me and having COVID, that you would have observed the presentation by Dr. Memark today, that over 70% of those hospitalized are those who are unvaccinated, and that those who have been vaccinated and those who've been boosted do have less severe impacts of COVID. That doesn't mean that they aren't impacted and that it cannot spread. It has been shared that the Omicron variant and its derivatives are highly contagious. But I do continue to be mindful of the broad impact that COVID is having on people who get impacted, that it's having on our hospital system, and encourage people to get vaccinated, and will continue to do so in consideration of the entire public, knowing that individually, yes, we may all have less of an impact based on, I can't say, but just based on our individual condition. And fortunately, there's a big unknown there. And that's why additional precautions are taken. I am fortunate that I have not been attending large events, and fortunate that we haven't had a lot of people gathered in small spaces, as I'm sure did not want to affect anyone. And knowing that we have 5 of the most significant decision makers here in Cobb that are meeting with lots of people, I think their health is also worth considering, as well as that of the public. We did vote to be able to facilitate having virtual meetings. I have asked for this to occur due to the high level of transmission. When we did vote, it didn't say that the meetings have to be virtual. It just provided opportunity for us to consider it in our code. I'm looking at the case rate, and I see that it continues to drop every week, which means that things are moving in the right direction. I do not prefer to be sitting at home here. I prefer to be out in the public, meeting with the public, hearing from you directly. And I'm looking forward to us opening up our facilities to have open meetings, but I need help of the public too, to help us in when we do have different seating arrangements in place, or we do ask for people to wear masks to help us, because we do want to open things up. And I can guarantee you, I don't know of anybody that does want things to go back to normal. There are a lot of other things that were stated today, but I do believe when it comes to assertions made around COVID and with respect to feasibility, that some information needed to be clear. And I also want to speak in defense of our Commissioner Richardson. It's unfortunate when we hear information being shared about her address. This is where someone lives. Although it's a matter of public record and she is a public servant, this is still public information. And please note, and it's been noted before, that with the new maps that have been proffered, it did not consider her old address or a new address. And that concerns all of us. When we put forward a map as a board, we stated that we desired for every commissioner to be able to stay in their district. And it's not just about them, but it's about those that elected them. With that, I'm going to end my response to public comment. I believe that those things were deserving of response before we move into the consent agenda. I believe that there has been a revision to the consent agenda, and for our county clerk, please help me in just clarifying that as I'm looking for my sheets here. I believe we had an item move from consent to the regular portion of the agenda. And bear with me, I'm trying to find that.
Yes, ma'am. Item number 7, probate court, was requested to be removed from the consent agenda to the regular agenda.
Thank you. Okay, and I believe that's the only modification that's been made to move an agenda. So I ask commissioners I will make a motion that we approve the consent agenda as it has been revised, with the exception again of item 7, which was moved to the regular agenda, and that we authorize execution of the necessary documents by the appropriate county personnel.
Second.
Thank you. Is there any additional discussion with respect to the consent agenda as revised? Are all those in favor?
No, I had my hand up.
I'm sorry, Commissioner, I didn't see you. Go ahead, Commissioner Gamble. Yes, thank you.
I am opposed to agenda item number 25.
Agenda item number 25. Thank you, Commissioner. For our county clerk, may you please note that Commissioner Gamble is in opposition to agenda item 25 on the agenda. Commissioners, is there anyone else that has a comment or question with respect to the consent agenda? All right, we have a motion and a second. No further discussion. All of those in favor of the consent agenda as revised, again, acknowledging Commissioner Gamble's opposition to agenda item number 25. Okay, I see 5 hands raised. The consent agenda passes 5-0. Thank you, commissioners. Please bear with me as I thumb through my packet here to get to our regular agenda. Our first matter up will be agenda item number 7, which is from Judge Wolk.
Good afternoon.
Good afternoon.
Take a deep breath. Thank you all so
Amen.
much.
We are here.
So am I. I appreciate you.
Amen. Thank you for your patience with us.
Absolutely. Thank you for your patience and all of the hard work. So, Madam Chair and Commissioners, this afternoon, we are asking to reclassify 2 positions in the probate court and to abandon a previous compensation policy. We are currently seeking to have we currently have 2 judges here in the probate court. Me as the elected chief judge and our appointed associate judge, Judge Riddle. We're asking to reclassify our current hearing officer to an associate judge position at 81% of the elected chief judge's salary. Then, in order to establish succession clarity as required by OCGA section 1592.1, we would ask to reclassify Judge Riddle, our existing associate judge, to a senior associate judge, so that if something were to happen to me, there is clarity on who would succeed to that position, either temporarily or permanently, if something were to happen. Just as a reminder, our court handles estates, guardianships and conservatorships, mental health matters, as well as marriage and weapons carry licenses with 2 judges. Superior Court has 11 judges with 7 senior judges assisting. State Court has 13 full-time judges. Juvenile Court has 4 full-time judges. Magistrate has 3 full-time judges and 15 part-time judges with 2 senior judges assisting. We serve the same community and the same constituents with our 2 judges and are asking for this 3rd to be authorized. You've been incredibly helpful over the past year in our efforts to be responsive to the unanticipated, unexpected increases in estates, guardianships, weapons carry licenses. We've tried to be creative in using ARPA funding, CARES funding, saved revenues, all of those ways to come up with plans to handle things to the best of our ability. Now we need this judicial position to handle these cases and to timely respond to the needs of our shared constituents. I followed the board's request to wait on personnel requests during the last budget process, but now feel that this shortfall is negatively impacting our office and the people utilizing the services of our court. I've investigated options with human resources, finance, the county manager, legal, other county and state agencies to try to find alternative funding sources for this. And at this point, I am unaware of a viable alternative. This is a request that is also part of our 23-24 budget proposal. And I know that Commissioner Burrell asked if this is something that could wait. And my response yesterday was that no, I don't think it can wait, because I wouldn't be bringing it if I thought it could wait. As the normal course of my doing, I don't try to ask for things until I think that I've gotten to the end of our rope. And so I honestly come before you, and I don't think that this is something that can or should wait until October for us to provide these constitutionally mandated services to our constituents. The reclass would adjust our new associate judge from a current salary of $71,672.64 to $138,626.64, making her still the lowest, if not the lowest paid full-time judge in the county, and adjust the senior associate from a current salary of $128,000 to $128,358 to $154,029 for a total fiscal year 22 impact of $83,497.74. And we would just request that you allow us to follow the recommendations of the HR department to abandon the existing comp policy and to allow for these reclassification salary adjustments for these 2 positions. Thank you.
Thank you, Judge Walk. I'll go ahead and make a motion that we approve her recommendation, or approve her motion. Approve her request, as presented. You could tell I'm getting there myself. Her request as presented. Is there a second?
Second for discussion.
Thank you, Commissioner. Yes, by all means, if you want to go ahead and start discussion, please feel free. No, ma'am. Okay, Commissioner Burrow.
Thank you. Judge Walk, how long have your senior judge and associate been performing their duties in this capacity?
We don't have a senior judge.
Well,
we have
2 that you're requesting to be, one to be reclassified as a senior associate. Let me rephrase my question. The existing associate judge that you're asking to be reclassified to senior associate, and the existing probate court hearing officer to be reclassified to associate probate judge, how long have they been acting in the capacity at these levels without being compensated or reclassified? How long have they been performing the duties that they're under now, that they're doing now, without the increase or the reclassification?
Well, Judge Riddle has been with my office for over 2 years now. She has 23 years of experience, most of that in probate litigation as an attorney. Kristen Poland, who is with our office, has been serving as a hearing officer for nearly 6 years. She has been qualified. You have to be a licensed attorney in the state of Georgia. You have to be a licensed attorney for 7 years. So she has been a licensed attorney as of November 21st of 2021 for 7 years when she became qualified to serve in that position. Does that answer your question?
Yes, ma'am.
Okay.
So my question is, when you came to us in 2020 and we approved some temporary positions with CARES Act funding, and then you had to come for the budget, for the 2021 budget, to make those permanent, why didn't these come to us for this current cycle, for the 22 budget? And if you can't wait till this normal cycle, we're still getting presentations. I mean, we have 3 more that we haven't even heard today, and we haven't had our retreat to review and prioritize all the requests that we're getting throughout the year for the 23 budget. So I asked you yesterday if this could go on the budget cycle for October. You did say no, it could not wait, and I understand the urgency and the need here, but I also know that there are other constitutional officers that have made requests either through their presentations for next year's budget or in the budget cycle, waiting for the budget cycle to make those requests, what we're going through now with all these presentations at our work sessions. In fact, we've added work sessions for all of our meetings so that we could encompass all the constitutional officers, the sheriff, the courts, the tax commissioner, every Superior Court clerk who we haven't even heard from till this afternoon, or maybe this evening at this point. But I'm struggling with, I know that you have a need and I want to help you, but I'm struggling with the fact that we're making everybody else do these presentations and give us our need. We haven't had a chance to even hear from everyone, and we haven't reviewed everything to prioritize because the funding is not there for all of these requests. And if we put you first in line, what does that do to everybody else? So I just want you to know what my stance is and where I am.
Thank you, Commissioner Broyle, Commissioner Richardson, and Commissioner Sheffield.
Judge Volk, I love you so much. All the work you do. But certainly when it comes to the comments that Commissioner Broyle has brought up, there's a concurrence of opinion on my part, just looking at the prioritization here. But the question, because we ask questions to see where there are opportunities, because I hope you understand we're trying to identify how to help. So the question that I have here is, are there any savings or any prevented fines that we may incur down the line by not having the capacity filled?
Absolutely.
If we were to have these two?
Yeah, I mean, if we are not timely in any number of things, we've got 3 to 5 day deadlines on emergency guardianships. We've got 7 to 12 day deadlines for mental health hearings. We've got 10-day deadlines for weapons carry licenses, all of which could feasibly result in lawsuits and judgments against the county if we are not able to timely resolve some of these tight deadlines.
Are there any, so I do understand the potential liability. Are there any fines associated with missing those SLAs?
Not that I am, I mean, no, it's a judicial act, so I'm not saying that there are not, there's nothing that I can think of at the moment.
Thank you. Thank you.
Commissioner Sheffield. I'm sorry, Commissioner Richardson, I didn't know you were continuing.
You're good. You're good. I was saying that concludes.
Okay, thank you. Commissioner Sheffield.
Yes, thank you, Madam Chair. You know, I echo and feel the same way as Commissioner Burrell, and we, even in our work session on yesterday, we're desperately trying to find a way in which this could work, even with respect to applying perhaps CARES funding. But what was determined in the work session is that what we're dealing with is not related to any type of COVID shortages. So it makes it very difficult for us to make a decision to move forward with the request, particularly since we've received requests from so many others and some that we have not even heard from at this point. But I also wanted to ask Judge Wolk, last year we passed an amendment for additional staff for you, including the weapons carry positions. Have all of those positions been filled that we granted last year?
We have made efforts to fill all of them. For example, we have part-time positions and a full-time position right now that we have been trying to list and have been unable to fill. We obviously, those positions are different than a 7-year attorney position to handle cases. But those positions, there were some efforts made to adjust some salaries because of the rapid rate of turnover. But we have made efforts to fill every available position and can't get enough applicants to even, that we haven't had qualified applicants. We offered some positions a couple weeks ago and our offers were rejected to the people who had applied. So they are not all filled, but not as we are currently working to try to fill every available position.
Okay, can you share with us, but you know what, that's okay because it doesn't have anything to do with what's before us. But just a point of clarification, earlier you mentioned that one of the judges served for 2 years and one has been an attorney for 6 years. But the question that was asked earlier is how long have those employees been in those respective roles outside of how long they've been licensed as an attorney? But for the role that they're currently serving in, how long have they been in those respective roles?
Right, that was the answer. Judge Riddle has been in her job as the associate judge for 2 years.
Right.
And Kristen Poland is not in a judicial position at this point in time. So she is the one that we're looking to reclassify as the junior associate judge. She has been in her current position with this court for almost 6 years.
Okay. All right. Thank you for the clarification. That was it, Madam Chair.
Thank you, Commissioner Sheffield. Commissioner Richardson, I see your hand up.
To Commissioner Sheffield's question about the positions approved last time that are currently unfilled, has there been a comparative look at the total summation of those roles in comparison to the uplift change that you'd need for these, and kind of a determination on where the priority would be for this upcoming year, like prior to the budget, right? Because we're all talking about the solution for the budget cycle.
Right. And to go back to Commissioner Burrell's question, because I didn't want to overstep, but the question about why things have been presented in the way that they have been presented. In the 21-22 budget presentations, we were specifically asked not to bring personnel ongoing commitments to our budget presentation at that point in time. So we did not include those budget requests at that point in time. So with the continued growth, like has been reflected in the Administrative Office of Courts study that necessitated the creation of the 11th position in the Superior Court, we have continued through this same time frame to have the increase in caseload and demand. There are obviously differences between the judicial result of the processing clerk workload. So when we have been trying to handle that increased product with the two judges. We now have a person on staff who is able to help with those things, who is qualified, and the workload is there. We are overwhelmed on the judicial side, and I don't begrudge you guys the difficulty of this decision. I'm not coming to you and saying, this is super easy, give me my money. That's not what I'm doing. I'm coming to you and saying, you all are the funding agency, and I am asking for funding so that I can appropriately fund it. That's not in any way a reflection that my ask is more important than communications or Superior Court or the tax commissioner or the clerk of Superior Court. I'm no way trying to do apples to apples or apples to oranges. I'm simply coming to you and telling you what our need is in order for us to conduct our business. And so I think that your question, Commissioner Richardson, if you can tell me again, because I got off on my own tangent.
I'm looking at total cost here. So just walk with me, because I'm going to make up numbers and I'm going to make up a scenario. We've got 3 positions that were approved that total to 100. One of them has been filled. 2 of them you're still looking to fill. We're down to 67,000. Hypothetically, could 67,000 be transferred to account for the uplift need in order to accomplish a reclassification? That's the more immediate need.
I have worked extensively with Bill Volkman and Buddy Teasar on savings options, and because fringe and all of those expenses are not rolled into savings, there is not enough from the entry-level positions to fully fund this position. And since we are looking at the totality of it, that's why we haven't been able to do it. So that when I say that we've been working with finance, that's we've tried to skin that cat a number of different ways.
I see that Bill Volkman has turned his camera on. Bill, can you help and respond to that? And Commissioner Burrell, I see your hand up again.
Sure, Chairwoman, absolutely. Judge Walk's completely right. We've looked at all of our vacancies to see if we could adjust the vacancies and use that savings to fund this request. It simply just wasn't enough money to do that. So we have looked at this probably a dozen different ways, and this was the best option that we could bring for your consideration. With that, I hope that answers your question, and I'll turn it back over to you.
Thank you, Bill. Commissioner Richardson, did you have any additional comments or questions? Okay. Commissioner Burrell?
Yes, thank you. The carry permit positions that were approved temporarily and then permanently, are you still in a backlog or having trouble with the permitting process with appointments and keeping up with that, with the unfilled positions there that were approved?
We are current with our appointments, and we are trying to be responsive to the status of the state of emergency within the county. So we went back to appointments. This past 2 weeks, we've gone off of appointments, and we do not have a backlog. Our numbers do not appear to be increasing for the first time, I want to say, in almost all of my tenure. We don't know how constitutional carry and other things may impact and what we may be having options with staffing, but right now our numbers are relatively steady. Those people are all busy. The other thing that's simultaneously happening with all of this is we're doing the unified case management system. So my supervisor and my deputy supervisor in our license division today are upstairs with my chief clerk dealing with that. They have not been in the office the majority of their time because it's taking 8 hours a day for my chief clerk since about June, minus about 4 weeks. So we're trying to, as you all are, on a much bigger scale, we're trying to address all of those demands. And that's just another piece of it. So they are all busy. They are all working on things. But we are not drowning at the 18,500 level that we were when we came for those positions. But we have been through the holiday season.
Okay.
Does that answer you?
It does, but even if if we could use those positions, the funding for those positions, it wouldn't be enough for what you're asking for, but maybe would it be enough for one position?
Well, you mean get rid of those 3 employees?
That, or was it CARES Act? Or is it fully in her budget now, correct?
Right. They were initially CARES Act.
Temporary part.
Right.
Okay.
And if we were to lose those 3 positions, then we would be in a very bad situation in terms of being able to comply with our deadlines. We couldn't do it.
Not lose them, but not hire the additional that are vacant.
Right. They're not vacant. Those positions, there's 1 vacant position in our license department right now. Everything else is staffed. In our estates division, we have some positions that we're trying to fill.
Okay. But to carry you through to October, would you be able to fund with the 2 positions in estates and the 1 in carry permitting? Would that be enough to fund one of these positions till you could get it in the full budget?
Bill tells me no, but I look to him to answer that question.
Understood. Commissioner, I'm sorry. Go ahead, Commissioner Burrow. I didn't realize you were continuing.
I was waiting for a response from Bill. But
Sorry, I was just unmuting.
Okay.
Yes, we did look at that as well, and it's just simply the grades of the positions don't work out. You're talking about a lower level graded position compared to associate judge type position, which is a much higher grade. The numbers just don't work.
Okay, but my question is, she needs 83,497.74 for the remainder of this fiscal year for those 2 positions to be reclassified and increased in pay, correct? Okay, the vacant positions that she has, can they, what do they equate to salary, total salary wise? And could they be applied to one of these positions till the end of the fiscal year, and then she can ask for everything in the 23 budget permanently?
So Commissioner, the way I understand it is that the greatest need is the lower level position to move into the associate judge, which creates an inequity with the senior judge. So if you do the one that's absolutely the most critical, it creates an inequity issue. So you by doing one, you almost have to do both. It would buy you a couple months, but because the positions they're vacant, they're only funded at 50%. So it doesn't equate to much money. And they were vacant at the beginning of the year. So you didn't have a vacancy or a position that was funded at 100% become vacant. You had an existing vacant position that was funded at 50%. So it would only get you a couple months of the year, which is why the agenda item's coming forward. I hope that answers your question.
Yes, and we're sure that ARPA money or some CARES Act money cannot be used temporarily to the end of the fiscal year.
We are, because I've having long discussions with the judge. This was not a COVID hardship, so did not feel it qualified.
Okay, thank you.
I promise I tried. I tried to get him to agree with me. I tried really hard.
Thank you for all of your questions, commissioners. Commissioner Gamble, I didn't hear from you. Did you have any questions for Judge Walker comments?
My understanding, the current conversation is contributing to it, but it's where we're going to take the funding from to fund this position. We just passed a policy that we would not use fund balance to fund one-time positions. There was an email from Bill Volkman stating that we could look at taking it from the BOC contingency, or there was one other one, Bill, I don't remember what that is. So really, I think none of us are denying that Judge Walk needs help in her courtrooms. I think none of us are denying that. The discussion should be is where are we going to pull the funding from? If we cannot pull it from fund balance, because it would be in violation of our fund balance policy, do we then direct Bill to modify the agenda item to pull it from the BOC contingency or whatever other contingency bill you had suggested?
Commissioner, yes, that you are correct. The two options were fund balance, but I did caveat that would be against the policy that you just approved. If the board wishes to fund this, I would recommend that we change the funding to BOC contingency. And we worked so long with Judge Walk on this, that was pre the approval of the fund balance policy. So we just want to make sure that that's out there for the board to consider, is if they do want to move forward, the board has adopted a $1 million BOC contingency each and every year. And this would be an eligible expense to take from that. And it would not go against the fund balance policy that we just created.
And to follow up with that question, because I know according to our county manager, she has many other departments that have these similar requests. So if we fund this with the BOC contingency, what other requests do we know of right now that is essentially going to want to come back? And would the BOC contingency be enough to cover those requests as well? I'm sorry to put you on the spot like that.
So the answer is I can't answer what other requests will come forward. The BOC contingency is a limited contingency of $1 million. So whether the board wishes to use all of that to address requests or wishes it to address other issues that come up throughout the year, that's completely up to the board and how they want to move forward. But it is a finite amount of money of $1 million.
Can we hear from the county manager of what requests she has for that $1 million contingency?
Hey, Commissioner, this is Dr. McMorris. I have several requests that I share with you guys every day, every week. I have put most, if not all of them off, unless they already had savings or it was a critically important position to fill. At which time I will either ask the director to walk the halls with you all to explain it so that you have firsthand experience of what they're asking. I asked Judge Walk to do the same thing, and I'm sure she tried to do that. But outside of policy, I don't have that authority. And so that is why we're bringing it before the board. I certainly sympathize with Judge Walk, I do. But other than capital requests, I don't recall granting any unless they were, again, with savings that were already there as a result of not being able to fill such positions. And if they didn't have enough money at that point, then it was just a small gap to fill.
Has any of that $1 million been spent?
Of the commissioners'
Other than capital?
Other than, I'm sorry, I'm misunderstanding your question.
The $1 million contingency, has any of that been spent?
No, ma'am. The only ones that have been requested, again, have been from departments that had savings already as a result of not being able to fill such positions. Bill, you can keep me honest on that. I don't recall any that have come from that expense because the majority of them have been from not being able to hire people or attrition or retirements, and they had funds already in their accounts. Bill?
That is correct. You, County Manager, you're absolutely correct. The ones that we have processed so far have been as a result of departmental savings that they could absorb within their budget. We have not used the contingency to date.
Yes, I think it becomes a question of the board of whether or not we would like to use contingency for this request. As has been shared by a lot of the commissioners, and I will also share a similar sentiment that we are supportive of the work that you do, Judge Walk, and do recognize the inequity and pay with respect to the work that your current employees are doing. And we also understand the inequity in pay with respect to pay in your courtroom versus the other courts that we have here in the county. And I appreciate the commissioner's very robust questions to try to understand your situation, to see how we can meet your need. I'm putting myself in the same position to want to meet your request. I've always wanted to support all of our staff and all of our employees in ensuring that our county is rightfully allocating resources to provide the best level of service to our constituents. And providing the best level of service and even reasonable level of service to our constituents means that we have to have a reasonable opportunity of attracting, training, retaining staff to be able to do so. And I know during this pandemic, this is becoming a greater challenge for us every day. Just within the last BOC meeting, we plussed up another department, recognizing the burden that's on them and the revolving door we've had with that agency. So this is not a new consideration. As much as I pressed yesterday about this coming to us outside of the budgetary process, because I'm always concerned about this, because it's a morale issue in your agency, and it becomes a morale issue and a retention issue across the entire agency when we make, one-off decisions like this. It's just almost like playing whack-a-mole. But, if we don't make this decision today, my concern, and this is not a fear that I think should be promulgated throughout the agency, where we think we can't retain anyone here, but a very real concern is that someone says, I will no longer continue to put up with this at this level, and they look to find something else which can be available to them with a lot less stress and a lot more pay, which is what we continue to deal with every day. And, I'd hate for us to be in that situation, considering the serious nature of the work that your office does provide and the amount of people who are depending on responsive probate services for a myriad of reasons. This is my concern, because this is very real as we continue to lose very knowledgeable and capable people across this county every day. You know, do we put this consideration at risk? A part of me has to think that when, you know, whoever's serving in the associate judge, you know, assumed that role, they knew the significance of the pay disparity. But even knowing that doesn't mean that they'll be able to put up with this for as long as we've asked them to. We are, you know, and that's, I think, where we are today. With that, you know, somebody's got to make a decision. We've got to make a decision at the board if we want to be able to find money. And from what I'm hearing, particularly based off of the previous vote that we had on fund balance, that is not necessarily the appropriate source of funding for this. However, DOC contingency may be. And so, you know, I made a motion and I would like to modify my motion, and we'll see where it stands at this point because we've had significant discussion around this. So I will modify my motion to approve the probate judge's request to reclassify 2 positions in probate court, utilizing our BOC contingency as the source of funding for those 2 reclassifications. Is there a second on that motion?
I'll second for discussion.
All right, we're back at discussion. Do I need to defer to someone else? Are you willing to discuss?
I'll jump in.
Thank you.
Bill, do we have any policies regarding BOC contingency? Because what I don't want to do is set a standard where now we basically deplete the BOC contingency because there's no real delineation for the kinds of requests that we're looking at.
So Commissioner, that is actually one of the things that we're working on as well. Our first stab was the fund balance policy. The next will be BOC contingency, but that's pretty hard to put a policy around because it's completely at the BOC's discretion. Fund balance, we ask for one-time uses because it's basically a savings account where BOC contingency is appropriated every year for $1 million. So that's kind of the distinction, but I can say this based on the 15 plus years that I've been here through BOC contingency, it's rarely spent down to 50%. So it seems like it's something that we have in case of emergencies, but in reality, an emergency is probably going to be more than $1 million. So when we look at this is just something that's kind of used sparingly, and it's been used for a variety of different things: operational expense, capital expense. I would venture to say personnel, but I can't say that definitively, but I can say it's been used for a wide variety of activities. The board would like us to consider trying to develop a policy around BOC contingency. We'd be happy to look at that, but it's going to have a lot of BOC or commissioner input in, for sure.
Appreciate that response. Because I know there have been a lot of soft policy around fund balance in prior years, especially when it came to constitutional officers. So I don't think I've come to a full decision yet in my mind, but I appreciate your answer. Thank you.
Thank you. Is there any additional discussion, Commissioner Gamble? And I'm sorry, Commissioner Sheffield, I don't have you on my page, so if you wish to speak, please just let me know. Go ahead, Commissioner Gamble.
I was leaning towards supporting this if we had moved it to a different funding source, but with comments that have now been made, I can no longer support it.
Thank you, Commissioner Gamble. Are there any additional comments or questions? Commissioner Richardson.
Just for clarity's sake, are there any comments that you can share with the board so that we can understand? Or at least I'm looking for that logic as well.
For me?
Sure, I will elaborate, Commissioner Richardson. And Judge Walk, this is in no way directed towards you, but many people saw our work session yesterday and saw the conversation that entailed. And so with the conversation that was just had, essentially, we are potentially setting ourselves up for any employee to come in and essentially demand money and a pay increase, or they're going to leave, or they're not going to get work done. That is where, when that was just inferred, I can't support this, because we can't set the county up for this, because then again, everybody's going to be wanting their pay increases. We know there's a paying class study being done. We know, the county doesn't stay with the market rate. I was willing to support this because originally it was based on the additional responsibilities that these two individuals were, coming up to. But now it's like, if anybody comes because they don't feel like they're justly being paid, the money could potentially be there. So therefore, I cannot support it now.
I don't know if it's out of line for me to say anything, but I
Commissioner, yes, I'm sorry, Judge Walk, I was going to ask for you to respond since that's what's directed.
And I don't think it was directed at me, and I don't think that but I hear you, Commissioner, but I do want to make sure and make it clear that this is a person who is serving in a unique position, but the equivalent of a staff attorney who is now qualified, and we are asking her to be a judge. It is not somebody who is threatening to leave the county for not being paid enough. And so we're trying to create a situation. There is an overwhelming demand for Judge Riddle and I to meet the day-to-day needs of each of these things. She is qualified, capable, and willing to assume this role that we could not have anticipated being at these levels. And she is now serving as equivalent of a staff attorney, and it's a completely different thing. It's not a pay me more or I'll leave. It's the opposite of that. She's an amazing soldier. So.
And thank you for sharing that. And I did not mean to misinterpret that, but yesterday during our work session, it was shared that we have someone classified at a much lower level doing the work of a judge. And at some point you get to question the reasonability of somebody performing at that capacity where they are. And if she could be a judge or, have a comparable role somewhere else, would she be compensated similarly? So it could be a matter of how we are interpreting it, but I am very concerned about having someone operating at that capacity, not being paid comparable to her peers, having a similar workload, and for us thinking that that is going to be sustainable for us until October. I mean, again, I've been on this board 8 years and have fought the good fight for us to have a process of us adequately having money in our general fund to compensate the ongoing expense of salaries. But, at the end of the day, it gets back to some of our discussion when it came to our ordinances. Our decisions are impacting real people, real work, and how they perform. And we're asking a lot for somebody to perform at a judge level at the position of which they're currently being classified. I saw another hand up, Commissioner Richardson.
And just correct me if I'm wrong, because it's my understanding she's not currently serving in that role. We are looking to move her into that role specifically to meet the demand, because she would be qualified and an asset in that role.
She is capable and sworn. And like yesterday, she was hearing cases for me so that I could participate in the work session. She is, but she's not. And I mean, there's obviously liability that comes from being a judge. There's a number of different things. If we don't have her properly classified and properly compensated, we can't conceivably, I mean, that would be like asking all of the superior and state court staff attorneys to just start hearing cases because they've been, they've been lawyers for more than 7 years. That's not a feasible, that we can't assume that y'all's assistants are going to come in and run the Board of Commissioners meetings in your place. It's not an appropriate trade out. And so I wouldn't, she is doing her best to assist us in the short term. It is not something that that I think it's an appropriate ask of the commission or of me to put her in a position of serving as a judge on a permanent basis, not just to help out with occasional vacancies when there are conflicts and things.
Judge Wolk, what is the result of that? Are these matters then getting pushed out from being heard in probate court?
Yes.
So if any of us are dealing with someone who's deceased, know that it is decisions like this that are resulting in us and citizens here having to wait to have their matters addressed in probate court.
And with all due respect, I've heard each of you make a public commitment to mental health this year. And one of the things that we're seeing is an increased number of mental health hearings, mental health agenda items. There's a push for mental health down at the Capitol. If we have two judges who are running parallel caseloads and a hearing comes in for a mental health off-site, we don't have anybody to send. So we don't have a way if we're in court. I mean, it's just, things get delayed, and it's death, guardianships, and mental health, so.
And how many judges do you have addressing probate matters for a county of 800,000 people?
2.
Okay. She's asking for one more. So we know what's before us. We know the very difficult nature of us budgeting for the county with all the budget hearings. We have a budget hearing that's being delayed right now because of what we're doing here at the BOC. And we also know what it's like to deal with those who've passed and waiting for that probate process. And we have 800,000 citizens that could experience that any day or could be in the process of that. So with that, we have a motion. There's a second for the purpose of discussion. Nonetheless, that's a second. Is there any additional discussion before I moved for a vote? Seeing no further discussion, there's a motion and a second. All those in favor of the motion, I ask that you raise your hand. I'll support it. All those in opposition of the motion, please raise your hand. The motion fails 4-1. Is there a substitute motion or another motion to be presented? All right, thank you, Judge Wolk, for your presentation today.
Thank you all. Thank you to Bill and Kimberly for all of their assistance as well.
Thank you. All right, we are moving on to our next regular matter on the agenda. That matter falls under the Sheriff's Office. It is agenda item number 27.
Good afternoon, Madam Chair, Commissioners, Dr. McMorris. This agenda item is to approve the purchase of a SWAT utility truck to replace our current SWAT utility truck. Our current truck is about 15 years old and it's at the end of its service life, and a SWAT utility truck is critical for our response to any incident because it carries all the equipment that will be needed at the incident location, and also any potential equipment that may be needed. It's also approved. It's an approved purchase under the 2016 SPLOST capital improvement. So we're asking the Board of Commissioners to approve a purchase order with Farber Specialty Vehicles for the purchase of a SWAT utility vehicle under the provisions of Omnia Partners contract number 128867 in the amount of $362,017 under the 2016 SPLOST program, Sheriff's Office Program X 1070, authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Thank you. I move that we approve the agenda item as presented. Is there a second?
Second.
Thank you. Is there any discussion regarding this agenda item? All right, those in favor, please raise your hand. The motion passes 5-0. Thank you, Commissioners. We are now moving on to the DOT regular tab.
Good afternoon, Chairwoman, Commissioners, County Manager Drew Ressler, DOT. DOT has 12 items for the board's consideration this afternoon. Our first item is to recommend the Board of Commissioners approve Amendment Number 1 to the Cobb Framework Agreement with the Cumberland Community Improvement District for Bob Callan Trunk Trail Phase 2, Segment A, Cobb County Project D11L0, formerly TR474, Cumberland CID Project Number CCID 1033, and further authorize the chairwoman to execute the necessary documents.
All right, thank you. Commissioner Richardson.
Motion to approve.
Second, is there any discussion? All those in favor, please raise your hand. The motion passes 5-0. Thank you, Chair.
Thank you. Our next three are related. First one, recommend the Board of Commissioners approve Supplemental Agreement Number 1 to the Project Framework Agreement with the Georgia Department of Transportation for Bob Callan Trunk Trail Phase 2, Segment B, Cobb County Project TR475, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents. Excuse me.
Commissioner Richardson.
Motion to approve.
Second.
Thank you. Is there any discussion? All those in, I'm sorry, Commissioner Gambrell. Thank you. I see you there now.
Thank you. Drew, I know we discussed this the other day, but can we just clarify real quickly in summary format, these next three agenda items, that these changes were not the result of the land swap that took place 2 weeks ago? Can you just clarify that, please?
That is correct. Thank you for the opportunity to clarify. This section of Bob Callan Trunk Trail Phase 2B is from Windy Hill South. It is unrelated to the area of the land transfer. That section of creek of the Bob Callan Trail is actually on the Windy Terrell Mill connector that is currently under construction. This segment is from Windy Hill South. It is also along the roadway segment, and these three items, the PFA with the Georgia Department of Transportation, the CFA with Cumberland CID, as well as the consultant services agreement, supplemental agreement, are all related to some additional design costs associated with the trail, again, south of Windy Hill, away from any of the area that was part of the land transfer.
Thank you for clarifying. Are there any additional comments or questions? We have a motion and second. For those in favor, please raise your hand. The motion passes 5-0. Thank you.
Thank you. Let me make sure the next item is okay. Number 30. Recommend the Board of Commissioners approve Amendment Number 2 to the Cobb Framework Agreement with the Cumberland CID for Bob Callan Trunk Trail Phase 2, Segment B, Cobb County Project TR475, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
Motion to approve.
Second, is there any discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve Supplemental Agreement Number 1 to the Consultant Services Agreement with Heath and Linebeck Engineers in an amount not to exceed $65,125.82 for engineering design of Bob Callan Trunk Trail Phase 2, Segment B, Cobb County Project TR475, authorize the corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Once again, Commissioner Richardson.
Motion to approve.
And I'll second. Is there any discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a consultant services agreement with Gresham Smith in an amount not to exceed $300,000 for transportation planning and engineering services for Noonday Creek Trail Extension Scoping Study, Cobb County Project X2544, authorize the corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Commissioner Burrow.
Motion to approve.
Second.
Thank you. Is there any discussion? All those in favor, please raise your hand. Thank you. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with Butch Thompson Enterprises Incorporated. The savings to the project in the amount of $17,812.50 for pedestrian improvements on Woodland Brook Drive, Paces Ferry Road, project number X2728. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
All righty, Commissioner Richardson. Commissioner Richardson.
Can you hear me? Motion to approve.
Now we can. Second. All right, is there any further discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item, a point of clarification that came from the work session yesterday. This item establishes the project budgets. Thus far, just the component level budgets have been established. This establishes the project level, so the specific bridges and intersections and sidewalk budgets being established in this item. So with that, the department recommends the Board of Commissioners approve the revised budget for the 2022 Transportation Improvements Program, funded primarily by the 2022 Special Purpose Local Option Sales Tax, and authorize the corresponding budget transactions per the 2022 SPLOST Transportation Improvements Program budget attached.
All righty, I'll make a motion that we support this agenda item as presented.
Second.
Thank you. Is there any further discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a 5-year sole source agreement for project view support with Stellar Services Incorporated, a 1-year initial term to include 4 automatic 1-year renewal options effective February 8th, 2022 through February 7th, 2027, in a 5-year total amount not to exceed $1,808,597.63 for transportation technology, project view development and support, project number B2581. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
So moved as presented.
Second.
Thank you. Is there any additional discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 to project number D2863 to the 2021 countywide unit prices contract with Grace of Great Contractors Incorporated in an amount not to exceed $14,000 for emergency repairs on Willow Ridge Drive. Approve a contract extension through March 31st, 2022. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
It is District 2 Day. Commissioner Richardson.
Motion to approve.
All right. All right. Is there any further discussion? All right. All those in favor, please raise your hand. Motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners ratify previous action by the county manager authorizing emergency drainage repairs on Bunnell Court in response to a sinkhole and voids. Approve project number D2835 to the 2021 countywide unit price contract with Advanced Sports Construction LLC in an amount not to exceed $88,274 for said repairs. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Any further discussion? All those in favor, please raise your hand. Oh, were you raising your hand to vote or did you have a matter to? Okay, all those in favor, please raise your hand. The motion passes 5-0. Thank you, commissioners. All right, we'll go to agenda item 38.
Of course. Our next item is to recommend the Board of Commissioners ratify a previous action by the county manager authorizing emergency drainage repairs on Parkwood Chase in response to a sinkhole and voids. Approve project number D2874 to the 2021 countywide unit price contract with Chatfield Contracting Incorporated in an amount not to exceed $475,417 for said repairs. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Commissioner Burrow.
Motion to approve.
Second.
Second. All right. Any further discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. And our final item this morning is related to the Cobb Forward Comprehensive Transportation Plan. This has been a three-year project to identify the population and employment growth, the resultant demands that places on the transportation system, and a plethora of transportation options to address those demands on a growing county over the 2050 planning horizon. In accordance with discussion yesterday, a revised agenda item has been provided in your packet, and that is to recommend the Board of Commissioners adopt a resolution authorizing the adoption of Cobb Forward Comprehensive Transportation Plan 2050 Recommendations Report to include supporting technical documentations, Cobb County Project Number X2519, and authorize the chairwoman to execute the necessary documents.
Thank you, Drew. And just for clarification, as a result of very robust discussion, that removes consideration of the vision statement, which we said we'd come together during our retreat to flesh out more. So this agenda item is modified to reflect, again, just the adoption of the resolution to adopt the CTP. With that, I'll make, yes, thank you. With that, I'll make a motion that we approve the agenda item as revised and presented. Is there a second?
Second.
Second.
Thank you. Is there any further discussion? All those in favor, please raise your hand. The motion passes 5-0. Thank you, Drew.
Thank you.
We are now moving on to the support services regular tab, which brings us to item 40. And we have here a new face as our interim director, Travis.
Good afternoon.
Stalcup. I hope I'm presenting your last name correctly. And Stalcup.
Stalkup. You got it close enough.
All right. Thank you, Travis. Good seeing you today.
Good seeing you. Good afternoon, Madam Chairwoman, Commissioners, and County Manager. Property Management has one item this afternoon. It's for supplemental agreement number 2 in the amount of $43,000 to John W. Spratlin and Son LLC to install a sewer lift station at the new Police Evidence Building, a 2016 SPLOST project X1042, and to also add 250 days to the contract. Property Management would request the Board of Commissioners approve supplemental agreement number 2 and authorize the corresponding transactions and further authorize the chairwoman to execute the necessary documents.
All right, Commissioner Burrow.
Motion to approve.
Thank you.
Second.
Thank you. Any further discussion? All those in favor, please raise your hand. The motion passes 5-0. Thank you, Travis.
Thank you, ma'am.
With that, we are now at the BOC Chair Regular. This agenda item, I presume, will be presented by our DOT Director. And this is with respect to the resolution pertaining to public transit projects associated with our CTP.
I'd be glad to present it. This item is relative to the ATL's regional transit plan. There are two things happening simultaneously that this item provides for. The first is the ATL has a current call for projects for the 2022 ARTP, the Atlanta Regional Transit Plan. This item authorizes and directs staff to submit the projects just approved in the CTP to the 2022 Atlanta Regional Transit Plan for their routine update. Now that update will not be done until the later part of the year. So the second piece that this item authorizes is the consideration of a transit referendum in November of this year. The state law requires that all projects put on a transit referendum, a House Bill 930 transit referendum, currently be on the ARTP, the active ARTP, that the ATL is the holder of that particular plan. So what this item does is twofold. It submits for the 22 plan, as well as submits all of the projects in the CTP to amend the existing 2020 ARTP, which then allows the board in its discretion to select projects off of that for a potential November of 2022 referendum on transit. So with that, I'm sorry.
Go ahead, I'm sorry.
This item recommends the Board of Commissioners adopt a resolution authorizing submission of proposed Cobb Link transit projects as identified in the 30-year transit plan included in the Cobb Forward Comprehensive Transportation Plan 2050 Recommendations Report to the Atlanta Region Transit Link Authority for consideration as an amendment to the existing 2020 ATL Regional Transit Plan and for inclusion in the 2022 ARTP update, and authorize the chairwoman to execute the necessary documents.
Thank you, Drew. And just for clarification from what I thought you shared is that the board is not obligated to put all of these projects on a referendum. It just gives us the ability to pull projects from this list for a referendum.
That's correct.
Okay, thank you. With that, I make a motion to approve this agenda item as presented.
Second for discussion.
Thank you, Commissioner Richardson. Would you like to lead off with discussion?
Well, I just want to make sure it's clear, especially for the public and the way that this was presented. And correct me if I'm wrong, right? But our submission to the ARTP allows us to qualify for many things, which is also inclusive of a 930 referendum, potentially if we so choose to go down that path. But it also allows us to qualify for other federal buckets of funding, considering that the ATL is a regional commission and a lot of federal funds are directed through that commission. So we are just positioning ourselves to be open to receiving funds in a multitude of ways, correct?
That is correct.
Commissioner Burrow.
Yes, part of your presentation went out. I don't know if anybody else experienced that or if it's just my computer. But, and you may have covered this, but we've had a lot of discussion and public input on the referendum for the mobility SPLOST. And time is of the essence of what we're going to do this year or in 2 years, if we're going to do anything at all. And I know that at one time there was a majority that wanted to do the 930 this year and wait on the 170. Now we're back to different opinions on doing the 170 first and the 930 later. My position is, first of all, I can't support a 2 penny regardless of where it is. I think 1 penny with a split, 75 for transit and 25 for transportation, or 50-50, whatever we think is gonna get to what we need to be. But we really don't have time to keep going back and forth, and we're never gonna, I don't think we're ever gonna get a consensus on what should go. I do know that from the survey results, the 170 was appealing for now, for this year, for November referendum. I also have heard from mayors that they support the 170, at least 5 out of the 6 that sent letters, I think, to the chairwoman, that we haven't seen all of those either. So I don't think I can support this if it moves, whatever it moves forward for this year for a referendum. I know a referendum will have to come back to us, but I can't support 2 pennies with all the other things that we're going to be, that are going to taxpayers.
Thank you, Drew. I don't know if you wanted to respond. I know you said you didn't hear all of Drew's presentation, and is not what this is, to move forward both referenda. But it was clarified, and I think Commissioner Richardson's hand is raised, that this does provide us opportunity to pull projects down from the CTP for consideration of either referendum, but it also gives us the ability to also draw down funding that comes through the ATL. Drew, can you please comment on that as well? And then I'll,
Sure.
Commissioner Richardson.
So in 2018, House Bill 930 does a number of different things. It established the ATL as well as the process for regional transit planning. Only the 930 requires that projects that are pulled off for a transit referendum be on the Atlanta Regional Transit Plan. What this item does is it submits projects to that for the ARTP to then provide the opportunity for the board to pull off projects for a transit 930 referendum at a later date.
Thank you, Drew. Commissioner Richardson?
Sure, and it's also my understanding that as a board, we would be discussing this at our retreat about what direction we want to go in. And that decision certainly has not been made yet, nor has there been a concurrence of opinions as referenced a couple of times in commentary thus far. But like I said, my concern with kind of pointing specifically to 930 in this, I just want to make sure the public is aware. This is a more fundamental submission of all of the things that have been contemplated in the CTP to a regional board. Beyond that, it allows us it does not preclude us from being able, if we do not submit, then we automatically prohibit our ability to obtain funds in a myriad of buckets. And if we're thinking about Cobb's investment and where we can pull funding from, this would be our obligation to make sure that it's the things that have been contemplated per the technical study of the CTP as it stands today are consistent with the regional commissions.
Yeah, and I don't know if we're conflating the regional commission or the ARC.
No.
But okay, the ATL.
That's the definition of a regional commission. Yeah.
Yes, ma'am. And then I'll also piggyback on that this is not the first time the county has submitted projects to the ATL for consideration of that board, which does allow our projects to potentially move forward. And that was done even prior to us moving forward a referendum. But it does make us eligible for consideration of additional sources of funding. Commissioner Burrow, yes, ma'am.
But if you look at the background on the third paragraph, second and third paragraph, it just identifies the 930, the 30-year transit plan.
Commissioner Richardson, then Sheffield.
That was why I wanted to make the point, because the background kind of skews that perspective, and I wanted to make sure the public was clear for what this process entails.
Right. And I just have a similar sentiment. And I think that, Drew, if you can just really kind of explain and maybe like a couple of bullet points and just so the public can really understand that what we're deciding right now is not the 930 versus the 170. So the conversation before us, we're not determining the 0.5 up to 1 penny, but you're just referencing in the background the nature of that bill.
That's correct. In terms of submitting for revision to the 2020 ARTP, what this item allows is for all of the projects that are on the CTP for the ATL board to consider inclusion of those projects into the ARTP. And what that does is it provides the opportunity to both submit for projects as those opportunities came available, as Commissioner Richardson referenced, while also it provides the projects that can be pulled from should the board wish to do a referendum this November. This item is unrelated to a 170 referendum.
Okay, and can you
Does that
just quickly share why 170, House Bill 170 was not referenced on this agenda item?
170 doesn't require for the projects to route through the ATL. Only the 930 does. And so it's really a separate conversation altogether.
Right. Thank you for that clarification.
Chairwoman, I believe you're muted.
Thank you, Drew. With that, we have a motion and a second. For all of those in favor of the motion, I ask that you please raise your hand. All right, and those in opposition, please raise your hand. Thank you. The motion passes with Commissioners Burrow and Gamble in opposition. All right, that takes us to the next public comment.
We have one speaker still on the line for public comment. That's Sharday Taylor.
Bless her.
Sharday, go ahead, please.
Hi, yes, I wanted to speak on the funding in regards to people that been getting evicted and things of that nature. Because we've been applying for it, and I actually wrote some of the county commissioners that's on board, and I haven't heard anything back regards to anything like the funding and things of that nature.
Ms. Taylor, public comment is an opportunity for you to speak for the duration of 5 minutes, but we can certainly have someone from our staff follow up with you, as I believe your contact information had to be left when you signed up for public comment.
Okay. So do you want me to give it to you now, or do you want me?
No, ma'am, please don't, no, please do not give us your information publicly. I believe that we have to capture that when you signed up for public comment. Kimberly, was that done when Ms. Taylor signed up?
Yes, ma'am. I have her contact information and I will distribute that
Okay.
to the right person.
Thank you, Ms. Taylor. We can have staff follow up with you.
Okay, thank you.
You're welcome.
That's all for public comment.
Thank you, Kimberly. Appreciate that. That takes us to our appointment tab. We have 2 appointments here, and both of them are just announcements. So I will announce the appointment of Terry Cease to the Cobb Workforce Development Board, which is agenda item 43. In agenda item 44, I will announce the appointment of Joe Waldrop to the Cobb Workforce Development Board. With that, commissioners, we are finally at the final portion of our meeting, which is the commissioner's public address. We will go ahead and start with our District 1 Commissioner, Commissioner Gamble.
Thank you. Are they going to be able to put the slides up? There we go. Please join us on February 17th from 6 to 8 p.m. This will be a virtual meeting to discuss with community development staff regarding the comprehensive plan. They would like you to join this meeting and then complete a survey that will analyze the needs, opportunities important to us as a community, and then put that into policy. You can help direct Cobb's vision for that. You can visit our county website to take that survey ahead of time. If not, join us on February 17th for our virtual meeting. Second, congratulations to our junior horse quiz bowl team. They placed 3rd at the state contest on Saturday, January 29th. At Rock Eagle 4-H. Congratulations. And lastly, the 1,000-minute challenge is underway. So far, we have 37 employees participating with a total of 4,035 minutes. And you can see the top 3 employees so far, and we look forward to track this in the weeks to come. Thank you for all those who are participating. That's all.
Thank you, Commissioner Gambrill. We're now at our District 2 Commissioner, Commissioner Richardson.
All right. So from the office, go to the next slide. We've got our priorities tour going on right now. So this is a chance for you to hear about all the different things, all the different agenda things that we can pursue as a district, and initiatives that we can pursue, and a chance for your HOA or your organization or business, whatever the group is, if it's at least 4 people is what I ask that you represent, to sit and just go over what it is that you would like to see. What would you like for me to focus on for the year? And of course, at the end of the month, I will be compiling all of the results from the tour and sharing that information with my wonderful colleagues on the board here, and certainly all of your other elected representatives, so that they can be aware of what has been communicated by the community. Please register. We have some new community cabinet members. We'll be bringing in a few more as well, but community engagement, Michelle Davis, Sandy Welfare for STEAM education, Eric Meyer for mobility and transportation, and Vianti Joseph for community outreach. And really looking forward to continuing on with the work that the cabinet has done so far, rolling out different community programs and just reaching a lot of different communities and getting some more public input on some of our greatest challenges. So congratulations to these new members. We also have some new office interns, and aren't they just bright and smiling and shining? And they're absolutely fantastic. Abigail Nicole Harris, she's joining on to help out with social media, photography, and videography. She's actually graduating earlier, and has decided to dedicate her time as an internship to our office while she's in kind of her off year. So really grateful for that. Shweta Krishnan is with us as well, and she's going to be handling all of the community outreach aspects and helping build our community catalog, which our previous communities intern was doing, and he's now going to be joining on as one of the youth members of our cabinet in the next month as well. But she's taking over his role, really proud. And then William Hunter, who is a legislative aide and just tracking all of the bills that are going through the state legislature and our Senate and our congressional and Senate side, just so that we can keep abreast of all the things going on and all the things that impact our neighbors. So welcome to the team, interns. Next, community updates. So Renee Jones, my Neighborhood Safety Commission appointee, worked with the office to start a reading strategies workshop at Sewell Mill Library that began last Saturday. And this workshop helps teach parents strategies to teach their children in grades 2 to 8 how to read effectively. If you're interested in joining this workshop, just reach out to the office for the link. They're doing this every other Saturday, and she's really passionate and has been she was a teacher for a very long time, and just really grateful to have that type of input in our community. Go self-starters. Next, the Cobb EMC Foundation Scholarship is now open for applications. They will be awarding 14 $5,000 scholarships to high school seniors accepted to an accredited 2-year or 4-year college or university. Friday, February 25th is the deadline. A virtual information session is scheduled for Thursday, February 10th at 5:30 p.m. Learn more about how to apply at cobbemc.com or by using the QR code. That should conclude all of my comments. Thank you.
Thank you, Commissioner Richardson. We now have Commissioner Burrow.
Thank you. Okay, now through Valentine's Day, Cobb Animal Services Big Love Adoption is back. You can take home your new best friend for $20. Any dogs over 40 pounds. So you need to visit cobbcounty.org/pets for more information and to see all the pets that are available for adoption. I would say cats too, but I hope there are not any 40-pound cats hanging around, but there might be. As Commissioner Gambrell mentioned, the special comp plan meetings are now virtual, and the one for District 3 will be February 24th from 6 to 8 p.m. I'm sorry, that's February 10th from 6 to 8 p.m. So, and then the other districts are listed here as well. So if you miss one, you can catch another. Next slide. We're up to 211 adoptions for veterans through the Cobb County Animal Shelter, partnering with Superior Plumbing. This is Mr. Holmes, who is going home with this incredible black and white cane Corso. We're grateful to Mr. Holmes for his 8 years in the U.S. Army and for supporting this program. If you're a veteran or know of a veteran that wants a dog or a cat, they're free of charge thanks to Superior Plumbing at the Cobb County Animal Shelter. On Friday, February 18th, there will be a memorial service for former Cobb Chair Mike Boyce, who passed away recently, and the service will be held at 10 a.m. at Mount Bethel United Methodist Church, 4385 Lower Roswell Road in Marietta. So we please keep Judy and his wife and the family in your prayers. And last but not least, happy Valentine's Day, Monday, the 14th.
Thank you, Commissioner Burrow. Oh, go ahead.
Thank you. That's all.
You're welcome. Thank you, Commissioner Burrow. We're on to our District 4 Commissioner, Commissioner Sheffield.
Thank you, Madam Chair. And while we're queuing up my slides, I just want to note that some might have noticed that there was not a date for the comp plan for District 4 on some of the slides, and that's because our comp plan meeting was on February 3rd. So it was not included on those slides because the meeting has already passed. But thank you so much. So District 4 news and updates. Next slide. District 4 is fortunate to have 2 tuition-free charter schools coming in the area in fall 2020. The first is Amana Academy West Atlanta is now enrolling grades K through 3 for next fall. The school will be located on the campus of Girl Scouts of Greater Atlanta's Camp Timber Ridge in Mableton and will provide students with opportunities for adventure, exploration, outdoor STEM learning. Amana's sister location is in Alpharetta, Georgia, so Mableton will be its second location. The second charter school, Miles Ahead, will be temporarily located at the campus of Relentless Church in Powder Springs off Macklin Road. The school will accept students in grades K through 8. To learn more about both schools or to enroll, please visit Amana's site at Amana, and that's AMANA academy.org. And for Miles Ahead, please visit milesaheadcharter.org. Next slide. I had the pleasure to attend the ribbon cutting and launch celebration for Strengthening Her Evolution, Inc. She, on Sunday, January 30th at the Smyrna Community Center. She Inc. was created to empower female youth to discover the aptitude of their talents, knowledge, and abilities to be productive citizens, world leaders, and professionals. To learn more about this community building organization, please visit www.she.us. Join me on February 16th from 11:30 to 1 at the Riverside Epicenter for the South Cobb Area Council Chamber meeting. I will provide updates on D4 happenings and my plans to move onward and D forward. To register for this event, please visit cobbchamber.org. Our monthly In the Zone meeting will be held a week earlier this month, and it would be held on February 16th. District 4 Planning Commissioner Michael Hughes and I will discuss February's zoning cases. Our In the Zone monthly community meetings are a great way to learn firsthand about zoning applications and potential development in your community. We have 11 cases this month, so please make sure to join in on the conversation. You can contact Deidre with deedra.watts@cobbcounty.org for the meeting link. Hope to see you there. And finally, that's it. The Haven of Help organization is hosting a Black History Month Spelling Bee contest on February 19th at 3 p.m. The contest is for children ages 12 through 15. Cash prizes and trophies will be awarded to the first, second, and third place winners. Come out and support the contestants. I will serve as one of the judges along with other community leaders. The Haven of Help is a nonprofit organization located in Austell, which aids families and individuals in 5 key areas: food, clothing, employment, transportation, and housing. Please visit the website for additional information, and it's not listed here. However, you may call or contact Ms. Swanson at 404-454-9347. Thank you very much.
Thank you, Commissioner, for your remarks. I will share in disclosure that my children are done with classes for the day and one of them is on full blast. So I can only control about this much sound coming out of the space that I'm in. If you hear someone who sounds a little animated, I apologize. They probably did not anticipate me still being in a BOC meeting. But I will wait for the slides to come up and I will quickly run through these as we still have a work session planned for today, Commissioners. All right, the first slide is respect to COVID-19. We received our update from Cobb and Douglas Public Health today. We are still actively testing residents and providing vaccinations. And I can tell you from my own experience that this is something that I wish upon no one, considering the varied response that we may have to this illness, and just encourage people to still consider getting vaccinated and boosted and to do what you can to help prevent the spread, including wearing masks. I'll go to our next slide. The county, in response to a blood shortage that's going on now, we are planning a blood drive that will occur in March, Thursday, March 10th from 9 a.m. to 2 p.m. at the Cobb County Civic Center. And this will be open to employees and members of the public. As was shared by Commissioner Burrow, there will be a memorial to remember Chairman Mike Boyce on Friday, February 18th at Mount Bethel in Marietta. And I believe that this is open to the public. As I shared during remarks earlier today, we've received a lot of comments and inquiries with respect to new cities that may move forward. We are still one Cobb County, irrespective of how these move forward, and we are a board that's serving all of our citizens. I understand we've received a lot of questions and inquiry, and we will be providing a resource center on a website here at the county, and that will be forthcoming soon. We have had some arduous discussion regarding the redistricting of lines for our Cobb County Board of Commissioners. And I put this map up here because I was trying to think of some of the changes that you're seeing. And, we have significant shifts, not necessarily on the west side of our county, but on the east side, where you see the shifting of positions of both District 2 and District 3. And I was trying to think of how District 2's realignment has changed. It's almost as it's pivoting from the bottom, like an elbow, where that arm is back, because District 2 has generally been on the northeastern border of the county, and now it's shifting towards the I-75 corridor. And that is causing potential displacement of our District 2 commissioner from that district. Again, when the board passed our map at our last meeting, it was our desire to keep all our commissioners in their respective districts. And so we're asking for support of our citizens to please weigh in on the reshaping of the character of how you're being represented through the maps that are being drawn. And you can reach out to your state delegation. Although we've been fortunate to be able to weigh in on this process with our legislative chair, we find that this process has been moving forward with others that have not been in communication with our chair, which is another issue. But each of us have representation at the state level, and I just encourage you to please reach out. As most of the shifts are taking place in District 2 and District 3, but also lines are being adjusted in the other districts as well. Next slide, thank you. We are in Black History Month, and Black History Month gives us an opportunity to recognize the work, contributions, and sacrifices of African Americans here in this country. And while we often take a retrospective look at the shaping of our history by Black Americans, we are actually shaping history today and each and every day. And so I ask for you to consider how you can be a part of Black history. Cobb Be Mine. In celebration of Valentine's Day, I would like for us to not only think about our heart for our loved ones, but our heart also for our county. And so, we have a lot that is going on in our county, but we have a lot of good going on in our county. And I share this periodically. This is what attracted all of us to be here and continues to attract many to serve here and to move here and to work here. So I ask that in this month of February, also consider not just your loved one at home, but your loved one here in the county and how we can continue to make Cobb County the best that it could be. I would like to thank our very own Raymond Goslow here with Cobb County Libraries. We actually have a contender that is representing us on Jeopardy as part of their college program. And for any of you who've ever met Raymond, you know that he is a bright and shining star among us. He is, speaking of bees, he's actually a spelling bee winner. And he also is a veteran when it comes to the Rubik's Cube and has won several cubing competitions. We know that you're going to make Cobb County shine brightly on the national stage, and we're proud of you and all that you do, and know that your team, particularly here in Cobb Libraries, is also. With that, that concludes my comments for today. Commissioners, I just want to give all of you a round of applause and our staff for all of the work that went into preparing for today and into dispositioning the various items on our agenda. We do have a work session to follow to cover continuing budget presentations. I would ask that we take a 10-minute break. Well, I'll give us 12 minutes. It is now 4:23. Ask that we come back and reconvene at 4:35 p.m. for our work session. And Dr. McMorris, are you still with us?
Yes, ma'am. So we would need to drop off this call, guys, and we will get another link that you can log into for the work session, Commissioner.
They should already have it.
Yeah, Kimberly should have already